Mhm. ಫೈಲ್ ಕಳಿಸಿದ್ದೀನಿ, ಎಷ್ಟೊತ್ತಿದ್ರೆ ನಾಳೆ ಫಿಕ್ಸ್ ಮಾಡಿ ಬರ್ಬೇಕು ನೀವು ಡೇಟ್ ಅಂತ ಹೇಳಿ.
ಇನ್ನೊಂದು ಡೇಟ್ ಇವತ್ತು ಆಗ್ಲಿಲ್ಲ.
ಹಾ, ಫೈಲ್ ಅವ್ರ ಕೈಯಾಗೆ ಕೊಟ್ಟು ಕಳಿಸಿದ್ದೀನಿ. ಅದನ್ನೇ ನಾಳೆನೇ ಹಾಕಿಸ್ಕೊಂಡ್ಬರೋದು.
ನಾಯಕ್ ಸರ್ ನಿಮ್ದು
ಆಗಿಲ್ಲ ಸರ್.
ಸಾರಿ ಸರ್.
Sir, Kotal 2 sitting at 11 o'clock, sir.
Thank you, madam. Hello? Hello? Hello?
ಸರ್ ಯಾರು ಸರ್ ಮಾತಾಡೋದು ಆನ್ಲೈನ್ ಅಲ್ಲಿ? ಸರ್ ಕೋರ್ಟಲ್ 2 ಇಂದ. ಸರ್ ಲೈವ್ ಇದೆ, ಮ್ಯೂಟ್ ಮಾಡ್ಕೊಳ್ಳಿ ಸರ್.
Just take that. One, Mr. Cole. When was it last listed?
August 2024. Notice for issuance was on 30th August.
Just get it listed after 2 weeks or so. What is convenient?
10-2. 10-2, sir.
You tell us, we'll have it. They have to just take it 1 or 2 days. No, we'll just see our convenience also.
12-2.
12th of February. Yes, Mr. Kulkarni. 2.
Service ಆಗಿಲ್ಲ.
What happened before the tribunal?
Yeah.
No, they have issued promotion orders. They have issued promotion orders. So there is no urgency in that sense. Okay. Just take it, ma'am. Just see what. Just see that. How is tomorrow? How is tomorrow? Day after. We'll have it day after, Mr. Kulkarni. Yes. Just 1 minute, Mr. Kulkarni. Objections have been cleared.
Have you cleared office objections?
Then we will say listing if no objections. Okay. Be listed. Be listed. We will only say this, Mr. Kulkarni, be listed if there are no objections. Okay. Then you remove it, then you can mention it for fresh listing. Any objections? No, the decree sheet is not there. You see, court fee, everything filed. Court fees, everything filed. Just check up, ma'am. Just give it to her. Any caveat? Any caveat filed?
No, caveat yes, sir. Caveat ಹಾಕಿದ್ದಾರೆ ಅಲ್ಲಿ.
Caveat are there. Any caveat filed?
ಇಲ್ಲಿ.
But you will inform the date also. Take an acknowledgement. No, not this thing. Please serve him. Inform him, take an acknowledgement. Okay? See, they may see, they may not see. We don't want where they will say, you please inform them, take an acknowledgement, then give it to the court officer. That would be better. Ma'am, just take it. Who is the other side? Who is the counsel?
Central government.
Who is the counsel? But we will give a date. What is the urgency? Tell us. We will hear it. What is the year of the filing? 15. 15. Just take it, man. Let's see after whatever is convenient. But you will inform the counsel, take an acknowledgement about the date having been noted. Just 1 minute.
11-2. 11-2.
Just take a date acknowledgement also. Yes. What is the urgency? So was there any interim order? Objections, any objections there? Have you said so? Just say objections complied. Complied, have you say so? Just say so, ask him to take it and say on caveat also. Yes,
If no office objections.
now it should be written, objections cleared. What is that? RFA? What is the urgency? What is when is the date of order, impugned order? Objections cleared. You say so, objections cleared. Just 1 minute. Any caveat? Just list it after 2 weeks. There is no urgency.
The appellants are filed the appeal before the period for the matter not moved to admission.
You are the appellant? No. Who is the appellant? Where is the counsel? You will call him and then mention before him. He is the appellant. You must call him. See, he should move, not you. We appreciate your difficulty. That appeal is not getting listed. Yeah, either one thing, we'll give a date, but you should inform him. Because his presence is more important. But why don't you call him also? Is he here in today? Check up. Then after lunch, you mention it. But then you will give a date, you will inform him and take an acknowledgement. Yes, sir. This is ours, man. Check up, man. This is writ appeal. This would be ours.
10th of February.
Please take the acknowledgement, then give it to us. Yes, writ appeals.
Pertaining to 3 writ appeals, KTG Ayurveda Medical College.
Which year of writ appeals?
2023.
23.
23. We need a direction to university to return the documents who have passed out students. Because the writ appeal is pending, they are not giving back the documents.
Who is the other side?
Other side university. I have served
Have you served the other side?
other side copies have
There is only
I've taken the
university,
acknowledgement.
only one respondent, there are other respondents.
4 respondents.
So you must inform everyone.
We have in
Who is the contesting respondent?
university.
University only, but you must inform the other respondents also.
I will,
We will give a date, but you must take acknowledgement for everyone.
I will,
Okay?
I will.
Just give a date.
7-2, sir. 7-2, sir. 7-2.
Well, there's a
Just give it back, man. You should take an acknowledgement.
Sir,
My lord, there's a commercial appeal arising out of a trademark violation, my lord. The matter was pending before the apex court and the matter has now been disposed, allowing my special leave petition, my lord. Subsequently, my lord, filed an application seeking for an interim injunction against the respondents, my lord. Henceforth, I'm moving this matter, my lord.
What happened before the Supreme Court?
The appeal, the SLPA was allowed, my lord.
In what manner?
My
What
lord.
was the order? Why against Supreme Court then you are coming back
My
here?
lord, my usage of trademark was accepted by the by the Supreme Court, and this is a separate suit that was with respect to the IPR matter, my lord. This is a commercial suit which was filed seeking for direction against the respondents for violation of the
One and the same.
trademark, my lord.
One and the same.
Please, my lord.
That was also infringement matter,
Please, my lord.
the earlier one.
My lord, that was with regard to recognition, my lord. This is with regard to infringement, my lord.
No, recognition between inter se between whom? Were you partners?
Both are using the same trademark of the same company, my lord. So this is between Sri Krishnaya Chetty and Sons and Sri Krishnaya Chetty and Co, my lord. Now the apex court has rightly identified that
Is it a pending matter?
this is a pending matter before this court, my lord.
So, after the Supreme Court.
No, my lord. This matter is not connected with the Supreme Court, my lord. That was with respect to the IPR matter, And this is a
This is
commercial.
a pending matter?
Here it's a pending matter, my lord.
Which year?
2023, my lord.
Just take it. What is the urgency?
My lord, now that the Supreme Court has passed the orders, my lord, we were seeking for implementation of the order through pressing on the interim application for injunction against the respondents, my lord.
Very well, we'll see it. Just take it, ma'am, after 2 weeks also.
4-2, sir.
My lords, this is with regard to reporting settlement, my lords. Both the parties are compromised.
Who is the other side? Just 1 minute, just call it. You have to inform the other side.
Yes, my lord, I've taken the memo to him.
Take.
Take
and
the
you will take an
acknowledgement.
acknowledgement about the having date and having been noted.
Please, my lord.
All the respondents,
Please, my lord.
okay?
Yes, my lord.
My lords, this matter, my lords, the caveator is there, my lord. I informed him there on 22nd, my lords, the parties are traveled from Hyderabad. So we are reporting settlement.
When do you want?
On 22nd,
22nd?
day after tomorrow.
Yes,
Since
sir.
tomorrow they will be traveling.
Take it. You inform the other side, huh?
My lord.
Is it a joint memo?
Yes, it will be compromise petition, joint memo. my lords.
The application is there.
We are kept ready, my lords. We are going to sign it. It was tomorrow.
Just one. Is it a fresh matter?
Fresh matter.
So why now a challenge? Challenge to what?
My lord, to set aside the, my lord, since they didn't go for execution, my lord, so by the time we challenged here, my lords, we were compromised outside the court, my lords, and the
They
deed.
went into execution.
No, my lord, they didn't go. By
They-
the
they
time we
wanted-
came here,
But you have an order against you.
against me,
What was the nature of dispute?
there was a commercial suit, my lords, where some pending work, my lords, they filed for damages, claim of damages,
Allowed.
allowed, my lords, and we are compromised, and DD is also ready, my lords.
But what about the objections? Court fee, everything?
My lords, only the objection would be the court fee, my lord, if that is exempted, because since it's a.
We will
comprom-
not. Let's be clear. We will not.
Since it is their compromise, my lord.
Nothing doing. We will not. We don't know. You may be right. Ultimately, even if it is compromise, you will be entitled to the court fee back.
That it is exempted, my lord. So
Right.
it is a burden to the parties, my lord. In that sense, my lords. It's really burden.
How much is the court fee?
I think, my lord, it will be around 2 point something, my lords. 27 lakhs we have settled, my lords. We are paying on one shot, my lord. So the amount.
You should have filed it and we should have returned it. You are right.
If exempted, my lords.
We don't know, but with objection on court fee,
On 22nd, both the parties, he is traveling tomorrow. The respondent is traveling tomorrow, my lords. In the
we
media,
are not concerned.
let the convenient of the parties, my lords, if this court can exempt.
So, see, we generally, you deposit it on an possibly an oral request of refund of court fee, we can do it. You are right, sort of a, this issue once in any case, you are getting it back. I think the procedure need to be taken. Think over it, okay? Come back after lunch, mention it, okay?
My lord, I am permitted to submit with regard to serial number 62, my lord.
We'll come back to that. Any other mentioning?
A commercial,
Yes,
This is RFA FR 157 of 2025. My lord, specific performance suit has been filed against my deceased husband, that is appellate. And my lord, agreement has been cancelled by virtue of a cancellation of agreement. On the same day, another agreement has been created, decree has been obtained. I have challenged that, my lord. 23rd execution petition is there.
when is that? What is the date of decree?
Decree is, my lord, in the year of 2022. My husband, who is, my lord, admitted to the hospital for severe chronic liver disease, and he was all along hospitalized. And after
We will see it, we don't know. When is the date there? See, why on the last moment everything?
that is what, my lord, they came. I'm extremely sorry, but 23rd, my lord, if the CLD.
You cannot have it so easy. Let's be very clear. Not like this.
fortunate. my lord.
No, it's all right. You see,
but
maybe
they are-
everyone has a difficulty. That little attempt must be made. 22 decree. There should be some deterrent, you know. We are sorry to say so. You're right. It requires urgent consideration. If you can work it out before the execution court, possibly you can take a date or anything, we will list it. But don't put, just take that, ma'am, and give a date, whatever is convenient.
23rd. 23rd.
23rd.
of this. Any date may be given because
That date we will give you.
We will intimate to the trial court.
That's right. Give a date, but no objections.
Yes,
Are there any objections?
no.
So we take it. You have to give it no objections.
Please.
Yes, ma'am.
The judgment is against us and it was passed in August of 2024, my lord. And we had filed the appeal on 30th of October, my lord. But the matter has never been listed before this court. my
What,
lord.
any objections?
No objections, my lord. the
Not at all.
objections- no, it has
Just
been
take
cleared,
it.
my
Then
lord.
why don't you pursue it, ma'am? You should have mentioned it earlier.
My lords, we have mentioned and moved, my lord, but it never.
Just
got
take it,
listed.
ma'am. Just take that.
My lords, and the urgency is that the corporation, the respondents are.
Is the caveat here?
My lords, the respondents are coming to the corporation and they are trying to get the recovery, my lords.
Then get it listed. You get it listed there.
My lords, it's quite urgent, my lords, a date may
Just one. We are giving day after tomorrow.
22-1, madam.
22, much of.
Lord, a commercial ejectment suit uncontested came to be rejected on the ground that the lease deed is not properly stamped, my lord. Now, the suit is dismissed, rents are stopped, and I am deprived of my rents also, please.
But, okay, just see it. Just give it next week, ma'am. That's it.
30th
Yes, ma'am.
January.
My lords, it's a suit for partition.
Hmm.
Property is being alienated by forming sites. It's a matter for admission of.
You are what? The plaintiff or the defendant?
My lords, we were the, I'm really not sure.
Was there any interim order also?
Earlier, yes,
See, what is the urgency?
my lords, because they're alienating.
What is the date of decree? Just check up, mention it after lunch, okay?
My lord, I'm for the appellant. My lord, I'm for the appellant. I'm requesting to admission on regular first appeal. We are appellants in this case, my lord. We have served the notice, but it has been not served, so we are.
Is it a fresh appeal or a
Yes, yes, my lord, fresh appeal. It's 2024 matter.
what is the urgency?
My lord, we have served the notice, but it has been not served, so seeking for the.
For a fresh notice?
Yes, my lord.
Just have it after 2 weeks or so. Just 1 minute. Yes, ma'am. Just 1 minute. Yes. Rejection of plaint. What was the issue suit about? Partition. For? Just take it. Just give it next week.
30th January.
What is the matter, ma'am? What is it a fresh appeal? Just ask him to, you have to, is there any caveat? What is the urgency? What is the date? Just take that.
10th of February, madam.
You just ask her to take the date. You take the date.
Madam, 10th of February.
Yes, ma'am. What is the suit? Any execution file? You have received notice? Just take it after 2 weeks. Just take the date. Just one.
6th of February, madam.
No urgency, ma'am. Yes. When is that coming? When is that listed? What is the date now? Then we will have it on this day. Yes. Who is the other side? You are for the appellant? No, okay. Now, what is otherwise the prayer? Partition.
I'm going to say compromised between them.
Just take it next after 2 weeks.
11 to 11 to-
MFA, what is the MFA about? No, is it in which matter? Motor vehicles or
Arbitration.
Madam,
is it just check up, ma'am?
arbitration.
Arbitration?
Arbitration. What is the mentioning, ma'am? Who is the other side? We'll give a date, you should inform him.
January. Madam.
Is it a fresh appeal? No, he's like, why do you require a direction? Is it a fresh appeal? Registry has notified the objections. You'll remove it. When is it listed? No, how is that? Who is preventing you to remove the objections? Oh, no, I don't think so. Who says so? Who they just call the officer? Have they informed you? What do they say? Just call, just ask them,
Madam,
just
give the
ask
number.
who is the officer who has said so.
Commercial appeal 24.
Check up this. Any mentioning shall run the list. Let's have the list, ma'am. These are all for adjournment. Let's start the list. Anything urgent? We'll come to that. That's all, na? Anything has some personal difficulty which need to be adjourned. He can't wait till the matter is called. We will adjourn it.
Yes, my
Serial
lord.
number 66, my lord.
Huh.
Has directed me to file an application for withdrawal of the deposit. An application has not come before the board, so I have filed the application. The amount is deposited 3 years back. Serial number 66, my lord.
Yes. No, 66 is MFA.
Yes, this was final hearing.
Yes.
Karnataka court has directed me to file an application for withdrawal of the deposit, which was deposited 3 years back. I filed an application, it has to come along with the
No, we'll hear it if we can hear it.
for the hearing.
Just wait.
It's a difficulty for the parties to withdraw the money.
We'll decide the appeal if we can. That's what we are saying. Just wait.
My lord, 62.
We'll just run through the list. Please just hold on. There would be some delay. Just hold on.
Serial number 1,
Yes.
Shri Hirematar,
And just give the files, huh? Objections to be removed. 3 weeks are granted to remove the office objections. List on.
14-3. Serial number 2, Sri Ananta Padmanabha. Serial number 2.
Yes.
You have cleared the objections. You have cleared the objections.
4 weeks are granted to remove the office objection.
14-3. Serial number 3, Sri Sanjay Krishna.
Louder.
My lord, my application for dispensation has been rejected. In fact, what has happened in the writ petition, there were about 23 petitioners who had filed together. All of them are not preferring the writ appeal. One of the petitioners who has suffered the order is preferring this writ appeal. Only in so far as his land is concerned, I have produced the translated copy, my lord, because otherwise it runs to 2 more volumes of notification and other things. Whatever is relevant for the purpose of this appellant, I have already produced.
See, not like this. You will file complete. We don't know what would be the relevancy which may be seen during the course of arguments.
My lord, I will submit the translated copies, my lord. There is some urgency because I had the benefit of interim order, stay of dispossession was there throughout the proceedings, my lord. Therefore, if this matter could be taken up, my lord, I will file the copies physically, my lord. If it is required during the course of arguments,
What are the documents which you have? What are the nature of documents?
My lord, everything pertains to notification. My lord, KIADB acquisition proceedings are challenged, my lord.
Acquisition notifications.
Acquisition notification is in respect of some 2076 acres, my lord. Out of that, 60 acres, landowners of different parts, they challenged by way of writ petition. In that, about 3 acres, 18 guntas belongs to the appellant before my lord. Only in so far as his land is concerned, I have produced all the relevant documents, my lord. I had writ petition, I had produced 60 in respect of all the 60 acres. My respectful submission it will not be, it won't be relevant for the purpose of disposal of my writ appeal. Because they are in respect of, they are all arrayed as pro forma respondents, in fact.
Who is the other side?
My lords, I am appearing for respond number 4, my lords, I am on caveat.
But what about these are all translations?
Translations, my lord, translations. In fact, my application is very clear, my lord. What is the, what I am seeking for dispensation also.
This is the only objection.
That's the only, all other objections have been complied, my lord. There is no other objection.
You have filed a dispensation, huh?
I had filed a dispensation, my lord, but by order dated 8/10/2024.
Just say
the,
that list this appeal. Who is the other side? You are appearing, ma'am?
For respond number 4, my lords, I am on caveat.
Who is the others for other respondents?
I appear for respond number 1.
My lord, insofar as the other respondents, the individuals are concerned, I'll seek for dispensation because they were the co-petitioners. I was supposed to make them as parties, pro forma parties.
You appear for 4, ma'am.
Please, my lords. KIADB.
Okay, just say re-notify. We'll just give a date. Let's see.
Please.
We'll hear you, then we will see.
Very well.
21-2.
Great. My lord, earlier date would be possible, my lord, because there is some threat of dispossession.
My lords, may I make one mention?
Yes.
My lords, the possession has been handed over to the beneficiaries and they have already constructed, my lords, on the scheduled properties, which the.
When construction has taken place.
No,
my
not
lords,
insofar as the appellant's land is concerned, my lord. Not
Possession taken.
Sorry.
It's been given.
No, this appellant.
Please, my lords, yes, sir.
No,
everyone.
my lord. I will dispute that, my lord. That is not
21st February we have given. We look into it.
earlier date, my lord.
Just give it 10th or 11th.
11-2.
Great.
Yes.
Serial number 4.
3 days time may kindly be granted. I will.
Just 1 minute, Mr. Just give us the file.
Almost ready, my lord. I will file it in the counter. I will rectify within 2 days, ma'am.
4 weeks are granted to remove office objections.
Yes.
14-3. Serial number 5.
Lordship, I'm appealing for appellant, your lordship.
Yes,
I'm seeking weeks time to complete officer objection. In this council appearing on appellant, my senior is no more.
4 weeks are granted
My
to
lord.
remove office objections.
Today, the contempt matter is listed before quarter number 1 at serial number 30. They are supposed to make, my lord, the proposal for the purpose of admission. He has already been reinstated in service, my lord. The
Look into
respondent.
it. Let him remove office objections. He has been reinstated, na?
He has been, but no salary, my lord.
That we will
They are
see.
supposed to,
You are working,
I am working, but no, sir, without salary. my lord.
that we will take care. That is not an issue. Okay? Next.
Our
26.
name may kindly be shown.
Time they are,
We are giving time, we are giving you date also. There are 7 office objections which we want him to remove.
20.
Lordship, one more submission.
Yes,
Our name may kindly be shown, my lord, in the name of, in the place of SN, but senior is no more.
mentioned, my lord, in the past title.
Yes, my senior is no more.
just say that the name of
We are Raghavendra and
of
Parikshit.
Shankar Narayan Bhatt be deleted.
No.
We are
Shankar
Raghavendra and Parikshit may kindly be added. What? ಯಾವ ಹೆಸರು?
What
We
is
are
it?
Raghavendra and SS Parikshit.
Raghavendra.
Whose name need to be shown?
Raghavendra and Parikshit.
SN bet is no more, my lord.
No, whose name need to be shown?
We are Raghavendra and SS Parikshit, my lord.
So and so name, so we will delete both the names.
Only, both name is same, my lord. Shankar Narayan Bhatt and SN, but both are same name.
Okay, the names as depicted in the list be deleted and the name of so and so.
We are
Just give-
Raghavendra and SS Parikshit.
Yes, sure, be shown in the cause list for the, as the counsel for the appellant. Next,
27-2, sir. Serial
Macho.
number 6. Serial number 6.
just give the file. Just give the file.
Serial number 6.
Just say that none for the parties. Now, the written submissions be filed 1 week before the next date of hearing.
21st April. Serial number 7.
Appearing for the
Sheena?
appellants, my lord. I seek for a 2-week accommodation. We have to take steps as against respondent number 6, my lord.
See, the gentleman has died, I suppose.
Please,
R6.
R6 has died, my lord. So I will take steps as against R6, my lord.
Notice on this, you just say that it appears that the respondent number 6 has, just say that the postal report on service to respondent number 6 states addressees deceased on the appellant furnishing the counsel for the appellant states he shall file an application bringing the LS of R6 on record. That's it. Adjourn to
28-3.
7.
Shorter date, my lord. It's kindly a shorter date, my lord, because there's apprehension of execution on their breast.
See, once we fill, then you can come back.
Please, I'm obliged.
Serial number 8. Desh Pandey.
Yes.
3 weeks, my lord, the mediation did take place. Some more negotiations are going on. We had after 3 weeks.
We have been informed that the mediation process is still in progress. Adjourn to,
Another 3 weeks, my lord.
just give it out.
26-3.
Great.
Serial number 9. The Manjunath.
Also, you appear for the appellant, my lords. My lord,
Service on respondent number 1 is not complete, ma'am.
My lords, we've taken steps, but I will take steps again, my lords. My lords, with respect to paper book, my lords, if I may submit. My lords, we've already filed all the necessary pleadings with the appeal, my lords, and also the documents run over 5,000 pages, my lords. If I may request its honorable court, my lords, to call for records and dispense filing of paper.
How will that help you? How will that help you? How will you make your submissions? If you don't file it, neither he will have it. Either you will file it, no? We will call for the record, no issue, but you must file it so that he can also have.
Please.
That's how possibly that will help your case. Just say the learner comes, fresh notice be issued to the respondent number 1, returnable on the arbitral record as directed on 22/11/24 be filed before the next date of hearing. Re-notify.
9-4.
BMR cell.
It is not. Okay, just cut this. The service on respondent number 1 is still awaited. The registry shall give its report on the next date of hearing. But then the arbitral record.
Number 10.
Notice for fifth respondent, it's sixth.
But I represent the respondent. I have moved an application seeking vacating of interim order dated 25/5.
For whom?
For respondent numbers 1 and 2, my lord.
Just show us.
Certain material facts are suppressed before the court. And suit for partition was filed, my lord. Suit came to be dismissed. There was no interim order operating before the trial court. Here an application under 39 rule 1 and 2 is filed, seeking an interim order not to alienate the property. Before trial court itself had clearly stated that item number 1 of the suit schedule property was already converted, buildings are there. In fact, apartments, they're already sold also. Now interim order is sought.
In whose name that property was?
It was standing in the name of respondent number 1.
Oh.
Joint development agreement. Respondent number 5 is
Partition suit otherwise was also dismissed.
otherwise also dismissed.
On what ground?
On the ground that there is earlier partition. This was a case where a daughter-in-law files a case for partition against the.
We will list it for hearing this. Okay.
Lord, so for us, interim order operating against the developer and me, I have also stated that.
But you have sold everything.
No, few I have kept.
Out of 40, my lord, 30 has been sold, my lord. 10 is only remaining. I am
And so
entitled
far
to
as
half
developer
his
is concerned, he has already sold. This
That's
interim.
one thing. There was no stay in the court below.
Absolutely not, my lord.
How can you now?
Not suit filed by, my lord, the daughter-in-law against the father-in-law and mother-in-law, claiming the share of husband. My lord, the court below, my lord, dismisses my suit on the ground. A widow cannot enforce a right of partition. As per Hindu Succession Act 1956, my lord, the said finding, my lord, is contrary to, my lord, section 6.
This is the ground.
My lord, this is the ground on which the stay was granted. My lord, 40 flats, my lord, was allocated to the share of first respondent. 30 they have sold.
No, not in the manner what he sought to project.
No,
it.
my lord.
There is already a partition, there is already a settlement.
My lord, what happens, my lord?
I didn't say that, my lord. What I'm trying to say is it is the self-acquired property of the first respondent. That is the contention taken.
My lord, the issue was, my lord, whether it is self-acquired or joint family property. The court finds that it is joint family property. That is an issue which is offered in my favor.
We look into it.
The only apprehension that I want to bring it.
But tell us, how would you justify this finding of the trial?
Well, that can be tried by the court. I'm not on that point. The fact that somebody.
See, we have to see prima facie case.
Certainly,
So
my lord,
the
certainly.
chances of the success, all those things need to
Lord,
be
he
seen.
shows it as agricultural land and takes injunction. That is my apprehension. That is the way I'm.
Tell us one thing.
Please.
This ground could be a ground to reject it. You may succeed on the merits. How would you answer that?
But only on the point of saying that it's an they show it as agricultural land. Where there is building, which they are aware of it. They submit that there are flats. They try to trouble those developers who have already sold the property in favor of those.
You are right. When it comes to partition by a daughter-in-law of the share of the son, to say that she will not have any right, how would you answer that?
Lord, there is one more thing there, that she is not the legally wedded wife is also the contention.
Negated.
It is also there.
Negated. Held in my favor that I am a legally wedded.
There are other
That is
wives
not
also. We
challenged.
have given property to her also.
Was this finding, was anything said by the trial court on this?
My lord, trial court agrees, my lord, that I am a legally wedded wife. The issue is held in my favor. There is no cross appeal insofar as that issue.
There is no.
No,
My lord, I've only sought with regard
We
to.
will look into it. Let service on respondent number 6 be effected. Written on the date, for the date fixed.
Well, there's one more appeal.
So I am representing respondent number 3 and 4 in this matter, my lords. We have also filed an appeal.
What is the date?
The date is fixed, my lords. So appeal number is.
What is the date, the appeal, year of appeal?
Lords 2022.
That's. before us.
332 of 2022.
Is there any date in that?
No, man,
There is
no date.
A memo.
We'll file a memo.
You are which party here?
Respondent number 3 and 4.
Both. But then file a memo.
We'll file a memo.
And
Better.
paper,
interim order. may
But
be
you,
executed.
you have to serve the respondent number 6.
My lord, await, my lord, await is the office report.
Okay. The service on respondent number 6 is still awaited. The registry to give its report on the next date of hearing.
Interim
Okay.
order granted.
Interim order, if any to continue, re-notify on. Just take the counsel. You appear for 1 and 2, na?
1 and 2.
Just give your appearance, huh? Name, 1 and 2 just, and you appear
3
for
and 4.
3 and 4. Who appears for 5?
He's the
Okay, that's the
developer.
company
So he's also represented. by
Developer.
counsel.
represented by whom?
Counsel,
Mahesh Reddy.
Mahesh Reddy is the representative.
Huh?
He is represented by.
Okay, the advocate. Next.
3rd of March. Serial number 11, Sri Prakash.
On three is concerned, Lord. I have to file my wakalat in the third respondent was.
But he has expired, that's the,
All three is expired now.
I have filed a memo.
You run a proper application to be.
no, who is
Filed.
giving instructing you?
Third respondent, Lord. Third respondent, they have given the no objection. Now I have to file the wakalat on behalf of the third respondent.
Yes, Sampath and Malika.
What is the name of third respondent?
Prabhakar.
Prabhakar, my lord, Prabhakar.
But is he alive?
No, my lord, he is right, he was right, he is right.
Now what will you do? The
No,
last thing
no,
to
I will
come-
file the wakalat, then, I mean, we are legal representative brought on record. How is
Ah.
He was right, my lord. Prabhakar.
Then
First, let the last come on.
Please, yours.
You will file or he will file?
I want to file.
File
Legal
it.
representative.
Give the details to him.
Okay, please,
What
Lord.
is the last?
I have already given in the memo.
No, no.
You have given the
I have
memo.
already given the memo, kindly see, Lord, 6/11/24.
That's right.
Brothers.
No memo was
All
given.
brothers only.
That memo.
Memo is not given, only for, through phone we are, yes, sir.
no memo is there. Along.
One more copy, madam. They are all brothers,
Right.
but they are very well aware of.
Yes, 1 minute.
In
They
some
are
other
aware.
cases, my parent for Prabhakar, my lord, he was right.
Your memo is only reporting his death.
Not also said, madam, son's details. are also
Tejas
there.
and Varun, wife Annapurna.
Yes,
Just give a copy to him.
and give.
The counsel for the appellant states that he shall file an application to bring the LS of respondent number 3 on record. Just give him.
I undertake to file for Annapurna and Varun, my lord, I am
Do
ready
you
to.
have any objection? Anyone has?
No,
One
absolutely
can-
no.
no
There's
objection,
the
he is
character.
appearing. So we'll record their statement.
Please note, I will file the wakal for this,
I-
Annapurna and Varun.
Intended memo of parties.
Yes, please note,
Okay.
please note. For
Just say
Varun
that.
and this one, madam, I undertake to file wakalat, madam. Varun and Annapurna.
What about the third one? Tejas.
Tejas also.
He is also a son.
Son, Tejas, all.
Just say that respondent number 3 has expired. Our attention has been drawn to the memo dated 6/11/2024 filed by the counsel for the respondent number 1,
Yes, ma'am.
stating that the respondent number 3 has been survived by 3 legal heirs,
Please.
namely wife Annapurna and sons Tejas and Varun.
Please.
Now, the learner counsel appearing for the appellant states that on his oral request, they be treated as, they be brought on record. The learner counsel for the respondent number 1 and 2, you appear for 2 also?
Lord, I am for one.
I am for 2.
I am for,
2 has no objection.
No objection.
If the LRs are brought on record, if that be so, the LRs as named above of respondent number 3 are brought on record, the learner counsel for the appellant shall file amended memo of parties and make necessary changes in the memo of appeal.
in the meantime, I,
The so-and-so,
T. Raja Rao.
so-and-so states henceforth he shall appear
For
for the
respondent, Please.
Will allow us to say, please. Shall file wakalat on behalf of the loss of respondent number 3. Let the same be filed within 1 week. Place the appeal on.
Admission, because preliminary decree is not on challenge, dispute is not regarding sharing. So who will have to take front portion is a question, he is only disputing.
What is the issue about?
Issue is regarding partition between the brothers. Preliminary decree, each one of them having 1/4 share is not in dispute. But in the final decree proceedings, the first respondent who has given this property agreed to divide the property even though he got it under the will from his grandmother. But he is gracious enough to allow us to all.
Make it part of hodgepodge.
Partition. But we have agreed to give a front portion. And for which he is the third respondent, one of the brothers is having some dispute. And he wanted front portion. But any one of them will have to take a portion. Not a final decree proceeding, commissioner has appointed and he has given a report. But any one of us will have to ultimately take one portion.
Now the final proceedings are still pending.
But yes.
Yes. Why don't you work it out before the final proceedings court?
But in addition to that, we have in fact, it is a Basurungudi.
No, but tell us then why this appeal, how maintainable when the share is not in
Again,
dispute?
not granting the share in the front portion is before the court.
Only that.
See, these are indivisible. How can you now? Otherwise, they will go by meets and bounds, sell it. Whoever gets what.
One more request is, property in a prime place, 45 feet, 110. We have all of us agreed to give to a developer having a maximum benefit. But he is staying over saying, no, I want divided by meets and bounds. But that is also he has held up and all the developing program, everything has been stopped from 2010 years. It is going on like this. But we could not be able to enjoy it because he is only.
My lord, the brothers are, the partition was held in the registered partition. At the time of the registered partition, my lord, they are assure me they are go through the front portions. Subsequently, the partition was affected and the FDP
Has an
proceedings.
issue on the front portion from the respondent sides?
And they are agreeing in the cross examinations.
Front portion allotted to elder brother, second respondent.
Who is the eldest? Who is the eldest of all?
First respondent, the second
respondent, elder brother, the front portion allotted to second brother, second elder brother. One more thing, my lord. Actually, property, second brother, second respondent acquired the property through a registered will executed by his grandmother. Also, thereafter, the second respondents also given portion to the all
yes,
brothers.
agreed to partition among the brothers.
Actually, there is a self-pocket property of the second respondent.
My lord, in this partition.
Is there any
date that is
chances of
affected-
settlement? Can you sit together and work it out? Is it possible?
That it has been referred to Adalat. He is still holding on that one issue. I want front portion. I am not ready to developing the property by developing, getting maximum benefit. I want to divide by meets and bounds, but I want front portion. But it is reached a dead end, but it is not possible. But from me, unless otherwise he changes his mind, not depending upon the situation. And commissioner has given a report. Everything is possible, but if he changes his mind.
What does the report say?
Report said, first they ask us to whether it is possible to develop jointly, but to get a maximum benefit. Since my friend has not agreed,
He didn't agree.
Then he has divided the property and fourth portion, last portion given to me, second portion given to another brother, third portion given to his, my friend's client. But against which now he is before the court.
Any chances?
Chances is there, my lord, can I convince my party? Can I 1 month?
You file your wakalat now.
Please, I file the wakalat.
Just have it after 4 weeks.
Intermediate.
Date may be given.
Date may be.
Date may be given.
Huh?
Date may be given.
27.
We are giving a date.
27 to.
Is there an interim order?
Interim order is there.
Interim order, if any, to continue.
27
2, sir.
27.
Serial number 12.
I get for respondent, my lord.
I appear for the appellate.
In this case, my lord, FDP 206/23 is filed. My humble request, my lord, kindly may permit me to go on with the FDP. And final decree, it cannot be executed till disposal of this subject.
Lord, I have filed.
Who appears for the respondents?
I
appear for the appellant.
For R1.
Respondent number 1, my lord, sister of the one Muni Ramana, and all our other legal heirs. Muni Ramana died. Nagaraj, one of the son, who has got it executed release deed of the property, joint family property, without my knowledge, my lord. That has been questioned in the partition. And partition set aside the sale deed, partition deed, my release deed, my lord, allotted half share of the property to me.
Do you appear for all the respondents?
One respondent, my lord, first respondent.
What about all to ourselves?
The appellant is son of
What
Muni
is
Ramana,
the date, ma'am,
second
on this?
respondent.
Lord, I appear for the appellant.
What was the date in this? But this is a CH move, huh? So we must all the councils, no? No, I know. Now tell us, what is why was the court hall moved?
My lord, I have filed an application seeking direction of this honorable court, my lord, to bifurcate my property and sell it. My lord, the facts of the case are like this.
No, is it possible to bifurcate?
Yes, my lord. Yes.
No, why,
Why
what?
My lord, why that could be bifurcated, I will demonstrate before your lordships. My lord, one Muni Venkatappa was the owner of the property, having purchased the same on 16/8/1906.
Yes.
Thereafter, my lord, that Muni Venkatappa executed a registered will on 2/4/1944. My lord, he had bequeathed, he had two sons. One is Muni Ramanna. The other is Muni Pullappa.
Yes.
My lord, your lordship will get the genealogy of the family, my lord, on page 18 of the appeal memo.
Now, what is the basis for the trial court to say half share will go to the plaintiffs?
Yes, my lord. What the trial court has done is, the property bequeathed to Muni Ramanna has also been included in the property of Muni Pullappa. And my lord passed the decree. Actually, my lord, Muni Pullappa, the Muni Venkatappa had bequeathed 21.5 feet into 8 3/4 to Muni Pullappa. Muni Pullappa's branch has become extinct. Therefore, the respondent plaintiff, my lord, being one of the class 2 heir, has filed the suit stating that she would be the class 2 heir with Muni Ramanna. She is entitled to have, she could be the class 2 heir of only of the property of Muni Pullappa. But the court has included the properties of Muni Ramanna as well as Muni Pullappa.
Have you served this copy of the application on
I
the
have
council?
served, my lord, but the mistake happened is I have not filed the memo to that effect.
You file your memo.
Yes, my lord. My lord, kindly I request your lordship to fix a date, my lord.
We'll give you date. The office objection in respect of IA 1 of 24 be cleared before the next date of hearing, and a memo in that regard be filed.
28/2.
Very well.
Seal number 13. Seal number 13, Srikanth M.
Appellant in this case, for the proposed respondent number 40, my lord. my lord, the rectification was allowed in November 2022. Subsequently, the subject matter of the property has been purchased by this proposed respondent number 40. And when we started to develop the property, my lord, we came to know there's an order of status quo by this court, but an application is filed to impede myself as a necessary party. My lord.
Who are the unserved respondents?
So respond in connected matter, Your Worship. I already taken steps on 7/11/2024, but they are not put, have not issued the registry, Your Worship. The answer response 13, 17 and 18 in connected matter 684 of 23. I already taken steps on 7/11/2024.
See, there were certain respondent 13, 17, 18 need to be served.
Yes.
That is
Moreover,
in his
I
case,
have not received the copy of the impleading application
From whom?
from the impleading applicant.
I am for the
That
proposed.
They will give you, but you have to serve these also.
Yes, yes, yes.
You appear for whom?
I am for the proposed respondent number 40, my lord, wherein the whole properties which have been purchased. Now, it's because the virtue of the interim order is coming the way for the development of the property. I put an application for impediment.
You have to serve them the copy.
I've served.
Getting the copy.
I've served.
Connected matter.
Now, have you
I have
gotten-
received, my lord. I have received. I will file my objections, my lord, because during pendency of the petition, that too after obtaining interim order, they have purchased it, my lord. Therefore, they will be having no right, my lord.
Say
I'll file
this,
objection to that
my lord,
effect.
The
By the time,
status quo,
13, 17 and
They taken steps on 7/11/2024. Instead, issue notice to the process.
13, 17 and 18 in writ appeal number 58 of
So 684. In connected matter.
58 of 2000. Thirteen, 17 and 18 are still unserved. Let fresh notice be issued for service on the said respondents returnable on. What happened to 13, 17, 18, man?
13, 17, 18.
In connected matter 684 of 23.
Where is the connected matter?
684.
684, is it 684 or 58?
684.
684.
They are served, they are not, they are respondents in 684.
684 is non-furnishing of item. Non-furnishing of acclement PF.
Is it 13.1 or 13?
My lord, in 58, it is served.
They are 13.1. So, just say respondents 13, 17 and 18 in writ appeal number.
684, sir.
Writ appeal number 4 of 2023 is still incomplete. Let fresh notice be issued for service on the said respondents returnable on.
21st April.
I will taken steps. Your Worship. I will taken steps on 7/11/24. Your Worship.
Notice has to be issued.
Notice has to issue. Register has to issue.
Notice for 8
Page number 1. Last day to 14.
Why was notice not issued on them?
No, acclement.
What happened? Service is awaited. Check up, ma'am. Just say there's service
Alright.
on, just. See, there are, the report says insufficient address and left. You have to issue, we have to serve them afresh.
Yes, Your Worship.
Just say this, ma'am, just cut that, okay?
Yes.
The service report on respondents 13, 17 and 18 in RFA number, in writ appeal number 684/2023 states, insufficient address, comma, left. The Lena Council to on furnishing the fresh address. The correct and fresh address of respondents 13, 17 and 18. Notice shall be issued returnable on.
my lord, the interim order is, I mean, against me, my lord, where I have purchased the property, it has been coming in the way of the development as an urgency, my lord. That is why the
No objection
impleading.
stated by the proposed respondents vendor, my lord, on 12/2/2024. Based on that only, the status quo was granted on 12/2/2024.
So because he lost interest
Only
after
after
selling the property, my lord,
that,
where
that too in
I have-
violation of interim order, the.
no, it
sale
is
has
not
been
in
taken
violation of the
place.
interim order. Interim order
I
only.
will put forth in the
The status quo order.
private, my lord.
Just say this, let a copy of the IA number 1 of 24 for implement
I have been served right now.
has been served on the council appearing for WF 684 of 23. To stop the councils appearing for the appellants in these appeals are at liberty to file reply to the said application within 2 weeks. Rejoinder be filed within 2 weeks thereafter. List this application for hearing on
The short date, my lord, because matters of the
interim order, if any, to continue.
14 writ petition, my lord, it was before in 22, now in 24, 25, it's almost 13 years.
Just say this, is the interim order there? Is there any interim order?
Interim order, yes, my lord. Status quo was there, my lord. Granted on 12/2/2024. It was.
12 to 2020. Interim order.
Regarding position. Regarding position.
Where is the interim order?
On 12/2/2024, second page, my lord. By interim order, parties are directed to maintain status quo regarding possession as on date, my lord. Page number 8 of order sheet.
Yeah, the interim order dated 12 to 24 shall continue till the next
Obliged.
date of hearing.
Obliged.
Can be short date, maybe that.
Next,
21/4, sir.
But the 21/4 is too long.
it's all right, please.
Because
Next.
the status quo is running against me, my lord.
Yeah, we know that. Next,
February at least, my lord, because the urgency have moved the matter.
not possible. Next,
My lord, a week's accommodation, my lord, I will comply the officer.
14.
Translation copy of to nature.
the office objection be cleared within 3 weeks, list on. You just show us the file. Next,
28/2. Serial number 15. Deepak Bhaskar.
Appearing for the respondent number 1 in this case. You are for the appellant in this matter. My lords, I'm given to understand that respondent number 2A and 2B have not yet been served. I checked with the registry. The postal shara indicates that addressee left without instructions is what has been noticed. I had filed a newspaper publication on 17th September. And this honorable court had on the previous day directed that I first attempt service again. If that doesn't work, they'll consider my application for newspaper publication.
you will serve them, make an attempt.
I've made an attempt 3 times, my lords.
What is the report?
It says addressee left without instructions. My lords, I would also like to point out that the advocate appearing for the respondent number 1 was the advocate appearing for respondent number 1, 2, and 3 in the lower court as well.
Yes. Tell us. What is the report, ma'am, on 2A23? Where is your application?
I filed my application on 11th September. I have additional copies.
Not like this. Please get it listed.
Okay, I'll do the needful, my lord. It's just that this honorable court had on the previous date mentioned that if the notice is not served again, they'll consider my application. Hence, I made that submission. This honorable court.
Just say this, 2A respondents, 2A, 2B are still unserved as per the report. The report of the postal authority reads as under, when the counsel for the appellant states he has filed an application for effecting substituted service on the said respondent. The same is not listed. What is this, man? Item delivered sender. What do you mean by sender? Okay. He states he shall get the application listed on the next date of hearing.
My lords, one submission, my lords. My lords, there is an office note saying that the second set of memo of undertaking has to be filed, but we have already filed our vakalatnama, my lords. I request this honorable court to kindly, the said objections may be overruled, my lords.
For respondent number 1.
Yes, my lords.
Now why have you filed vakalat?
I've already filed my vakalat on 19th of November, my lords.
Written with the office objection.
Written with office objections.
That you clarified.
The learned counsel for the respondent number 1 shall also clear the objection in respect of vakalat before the next date of hearing. List on
4th of March.
My lords, one submission. I'd also requested that I may be permitted to serve the counsel appearing for the respondent number 2. It's the same counsel, my lords, who has appeared for respondent number 1.
He doesn't know whereabouts. You're getting the point?
I understand.
He doesn't know whereabouts. How will we serve the party?
Last notes.
3 RB Sadashivappa.
The fresh notice we should.
appellant, my lordships.
For the first response.
5 and R6. Returnable on. The notice to respondent number 7 who has refused the same deemed to have been effected. This shows now. What does he say here? Refuse this.
That is for R7.
Just say this. Huh? This one?
That is for authorization.
Okay, refuse. Yeah. Let fresh notice be issued. Respondents 5 and 6. Returnable on.
21st April.
Obliged. A small submission to be.
Yes, ma'am.
Along with me, my lord, Advocate Muchandi, SP Muchandi is also appearing, my lord. We will file the wakalat in the same.
Yes.
Obliged.
17, government advocate. 17.
Appeal by state, my lord. Will take steps to
You have
R1.
to
my lord.
serve the respondent, ma'am.
No, my lord. Will take steps, ma'am.
Let fresh notice be issued for service on the respondent returnable on. Give it in now March, April.
23rd April. Number 18.
We have the advocate for the appellant.
Joshi.
Petitioner's appeal, my lord, challenging the dismissal of his petition, questioning the acquisition of his land under the Land Acquisition Act, only on one ground. Preliminary notification was issued. The petitioner submitted objections under section 5A. Objections have not been considered. The law on the point is that such an omission is fatal to the acquisition. In the impugned order, my lord, at page 15 it begins. The learned single judge takes note of my ground specifically on that point. At ink page 17, para 2, the last few lines. No proper inquiry under section 5A of the Act was undertaken, though it was specifically stated by the petitioners about the requirement of the said land as a means of livelihood for the family. The possession of the land continues with the petitioner. This was the ground that I urged before the learned single judge. Was filed or to be filed? To be filed. Keep it in mind.
But how would you explain the delay, Mr. Joshi?
That's true. There is some 300 days delay. Illiterate people, village people. Advocate changed hands. Well, that I asked what happened. Actually, tell me what really happened. They say the advocate before the learned single judge was different. The advocate here is different. The advocates, while changing hands, in the matter, somebody dropped the ball. It got delayed. What about this?
See, even otherwise, see, when was the preliminary?
Nothing has been happening. In fact, my lord, most interestingly, my lord may see page 80. The state itself has said, we don't need the land. At page 80.
Compensation given?
Compensation given.
That's enough.
My lord, that the position of law is that whether compensation is given or not, if my objection under section 5A is not considered, that is a fatal flaw. The reason why there was some delay also is that no activity happened on the land. I am in possession of the land.
5A would come when?
5A would come after the preliminary notification.
When, and that's what we are putting it to you.
That's right.
5A comes, there is a final notification.
That's right.
Award has come.
That's true. My lord, the preliminary notification came. Then I filed 5A application. Without considering my 5A objections, final notification came.
But will it be, we are only on the day. Is it not too late to say so?
No, my lord, it is not. Because the issuance of the final notification, ignoring my 5A objections, is fatal to the objection, to the process.
If you have come on time.
Well, makes no difference. Once the process failed, the process failed. The reason why I then did not come on time, petition was filed in time. My appeal is delayed. My petition was filed in time.
No.
And the reason why the petition was also filed appropriately was no activity on the ground happened. Nobody took possession from me.
When was the preliminary notification issued?
2004.
When was the final notification issued? 2005.
That's right.
Was the writ petition filed?
No, the writ petition was filed subsequently for this reason that my possession remained undisturbed. Nobody came to me. So we are villagers, my lord. How are we to know what actually turns around in law? Nobody came to my land. The state itself at page 80 has said so in its resolution. We are not interested in this piece of land. My lord, just for a moment indulge me. Take a look at page 80, my lord. These are the proceedings of the municipal authority for whose benefit.
Now what is the position on that?
Now recently they have started some activity in the land, and that is why the agitation, my lord. Now they've started, I've just got some photographs today. They've started clearing up the land now. There is apparently some change of mind on their side.
Just see, what is that? You have
Photographs for the municipality.
Huh?
For the municipality.
Lord, I'm told that my compensation, I made a submission, was received. Compensation has not been received. It's been deposited in the court. It's
Deposited in the court.
deposited.
You will now work it out. Show us. What is the name, why it was acquired?
My lord, for a sewerage treatment plant.
And then
Which
Has it been
initially,
put?
my lord, one part of it has been put up. Early, it was stalled because we didn't get permission from the Pollution Control Board. But now under the Swachh Bharat scheme, there's a whole new technology being used, which has been approved. Therefore, tenders have been floated. This construction, which was going on at that time, is
Are they in possession now?
Yes, sir.
we are in possession, my lord. This is what page 11, my lord, ink page 11.
So this is going in a very large scale,
No,
Mr.
this has started only recently, large scale or otherwise. This has started only a few months ago. Roster bench earlier, my lord, we tried to move, we could not do it. Some difficulties, logistics wise.
See the nature of construction and the level of the construction also.
My lord, the state would still have to get over what they have submitted at page 80. A decision that they took 2004, the land acquisition. 2023, they changed their mind after having conceded that they don't need this land. If at all that had to happen, then they may as well re-notify this land and then we could consider. But my objections have not been considered. Lord, may I just point out the law and leave it at that? I'll just point out. Memos.
So you're right, Mr. Joshi, this can be an issue. Poor illiterate people, they don't know. As long as they have the possession, they are happy. This is agricultural land or a barren land. There is nothing.
Agricultural land. I was tilling. And I was tilling until recently. This activity started over the last year or so. And that is why since then we have been trying to get the matter listed. It could not be done. Previous delay, my lord, I was not concerned at all because in spite of the acquisition of 2004, until 2023, admittedly, as pointed out by my learned friend also, no activity happened in the land. I am in possession and I'm enjoying my land.
No, he is saying because there was a pollution control board.
Because or otherwise we are illiterate people. The fact of the matter is that nobody came near my land. What the point of law is, if I have submitted objections and you went ahead and issued final notification, what is the legal effect or standing of such a final notification?
You are actually right. But the fact remains you have given objection. The plea of illiterate would not be viable.
No, my objections also are something
Objections
is right.
filed.
The village headman comes and says, you submit this. I submit this. Somebody else writes it for me. I submit. Those are the realities of village life, my lord.
These
Just
are the
because the
hard
villager.
realities we know, hard realities. But in law, how would you sustain?
Well, that is a point. The position of law is this, that once I have submitted my objections, ignoring those objections, the state could not have proceeded.
When did you submit your objections?
The date is available. 10th May 2005, prior to the final notification.
Then what happened? Final notification came?
Final notification came.
No action.
No action by them.
No action by you.
Because there was no action by them.
Very well.
I am a villager. I am seeing my land. I am tilling my land. I have access to my land. Some paperwork happened, I would not know.
Mr. Joshi, 2006 is a final notification. They are required to consider 5A for the purpose of final notification.
That's right.
Final notification has come. There is an action on their part. But you don't take it action. 2010 award, 2013 is the petition.
But only when I come to know that some further activity is going on in respect of the acquisition proceedings.
We can't take that.
My lord, we'll just consider what is he standing. My lord is going by the fact that 2006 the final notification came. What is the significance of that in law? If it is non-est, it makes no difference.
We are with you on that.
But my lord, my petition not to have been allowed.
1 minute, Mr. We are with you on that. But would you sit over the matter?
For this reason, and again, for this reason only, that my land was not disturbed. My possession is not disturbed.
Would that be a relevant consideration?
Lord, for a villager, for an illiterate villager, what else ought to be, my lord? He would not be aware of what transpires in the bureaucracy or in the court. Some deposit has happened, some award notice has been issued. illiterate fellows, what would they know?
The objections, Mr. Joshi.
Objection, like I said, my lord, objections are because somebody else comes
No,
and
we will
tells me
not
this
take it.
is
No,
what
no.
has to be done.
No. Two different parallelly
That does not give
opposite
me,
direct submissions being made. We will not take that.
the filing of the objections, I'll put it this way, does not portray me to be a literate, diligent person. But he comes and tells me, Aisa, why you file it? So I put some signature and say file.
Why did you go to the person who has filed it?
These are all,
He had not come to
these
you.
are-
You
these
must
are all-
have gone there.
these are all conjectures, my lord. We don't know what transpired then.
You are right.
Acquisition notices come, meetings take place in the village. In the assembly hall, somebody would come and say, you sign this and it will be submitted and don't worry, your land will remain safe. I do that. And nobody touches my land. I remain safe in my land. Therefore, no action on my part. And more so, my lord, when I am assured by the municipal authorities there, at page 80, my lord, but the state would still have to say, what, this is not the ground on which they delayed, that PCB approval was not available. At page 80, they say the land around my area has completely been developed. Therefore, the placement of an STP in that area is not feasible. At page 80.
I don't think, Mr. Joshi.
Well, just one more thing pointed out. At page 138, it is not a question of delay in approval. The project itself was set aside. At page 138, there is no budget, there is no fund. Therefore, there is currently no opportunity to construct such a project.
What is the date of this?
No, this also, sometime in 2012-13, my lord.
That's right.
All this, the state does not explain. The state merely says very blandly, PCB approval, 20 years, my lord. I ask myself this. My lord will just consider the position of law in ignoring my section 5. Yeah. What objections, what happens? Because the state, having notified my land, does nothing until 2023. Then, my lord, a little bit of delay on my part. Yeah, we are villagers, my lord. What do? We are villagers.
No, we know. What is really is the objections having been filed.
My lord, that does not grant me either a halo on my head or some enlightened soul. I still
Why
remain
not?
illiterate.
Why not? What is the effect in law? Tell us that.
Well, that is the point. But having filed my section 5 objections, and if the final notification is issued ignoring my objections, what is the effect in law?
Very well, then you should have come at that time.
Well, nothing happened on the ground.
Very
At
well.
the cost of reputation, nothing happened on the ground.
No, Mr. Joshi, we will not take it. And more so, see, the whole project is started for a larger interest of the public. We can't set it to naught.
That also the Supreme Court says. Merely because you say there is public interest involved, ignoring 5 objections is fatal.
Oh.
In so many words.
Sure.
Well, just 2 citations, my lord. The first one, my lord, is of 2012 to SCC 25, Kamal Trading.
Which page is that?
My lord, at page 6, para 15.
Let's see the facts, Mr. Joshi.
My lord, at page 4, para 2 onwards. The appellant, which is a private limited company, was entrusted by 17 joint owners of the premises known as Industry House at number so and so to look after day-to-day management and maintenance of the premises, as also to initiate proceedings for and on their behalf. 17 joint owners include respond number 6, 7, and 8 herein, and 1 so and so. They are seized and possessed of certain floors of the said premises. State of West Bengal requisitioned the said floors under the provisions of the West Bengal Premises Requisition and Control Act 1947. Under the 1947 Act, the maximum period of requisition was fixed at 25 years from the date of initial order of requisition, and the state government was obliged to release the property under requisition after expiry.
No, come to paragraph 4 and 5.
But
5 and 6.
The second land acquisition collector issued another notice dated 26/9/97, fixing the date of hearing of the objections on 30/9/97. By a letter dated so and so, the appellant again requested for adjournment till after October 97 on the ground that its constituted attorney was unable to attend and the advocate was out of station. According to the appellant, while they were waiting for further communication about the date of hearing, the state government issued a declaration dated so and so under section 6 of the Alia Act. So effectively no hearing was conducted. Lord, the position of law is discussed.
Paragraph 6.
The appellants along with the owner companies filed a writ petition number so and so of
Now just pause
97.
for a moment. Everything happened in 97, even the filing of writ petition was 97.
That's
And
right.
the ground was taken, it was not considered for the purpose of final notification.
No, but if, my lord, the learned single judge were to reject my petition on the ground that I have approached the writ court after several years of delay, I would then have urged this ground before the honorable single judge also the reasons for my delay. But the fact that I approached the honorable writ court after several years is not even a ground for rejection.
No, let's see this. We'll show you.
My lord, let me just finish this on the position of law.
Okay.
Para 15, my lord, message. My lord, the learned single judge merely says compensation has been deposited and therefore it is too late in the day. Para 15, my lord, in this decision, hearing contemplated under section 5A2 is necessary to enable the collector to deal effectively with the objections raised against the proposed acquisition and make a report. The report of the collector referred to in this provision is not an empty formality because it is required to be placed before the appropriate government together with the collector's recommendations and the record of the case. It is only upon receipt of the said report that the government can take a final decision on the objections. It is pertinent to note that declaration under section 6 has to be made only after the appropriate government is satisfied on the consideration of the report, if any, made by the collector under section 5A2. As said by this court in Hindustan Petroleum Corporation, the appropriate government, while issuing declaration under section 6 of the Alia Act, is required to apply its mind not only to the objections filed by the owner of the land in question, but also to the report which is submitted by the collector upon making such further inquiry thereon as he thinks necessary, and also the recommendations made by him in that behalf. Subsection 3 of section 6 of the LA Act makes a declaration under section 6 conclusive evidence that the land is needed for a public purpose. Formation of opinion by the appropriate government as regards the public purpose must be preceded by application of mind as regards consideration of relevant factors and rejection of irrelevant ones. It is therefore that the hearing contemplated under section 5A and the report made by the land acquisition officer and his recommendations assume importance. It is implicit in this provision that before making declaration under section 6 of the LA Act, the state government must have the benefit of a report containing recommendations of the collector submitted under section 5A2 of the LA Act. The recommendations must indicate objective application of mind. We may make references to a certain decisions, my lord, they do that. And then, my lord, at para 23 plus item G, the property of a citizen cannot be acquired by the state without complying with the mandate of sections 4, 5A, and 6 of the LA Act.
Say 23, no?
Or 23 plus item G.
Radhesham.
Radesh.
Yes.
But then at page 11, my lord, another decision. 2017-11 SCC 601. Lord, here the question that fell squarely for consideration was this. That, my lord, we'll see at page 61. Page 61. Questions were framed at page in para 66, 66.3. Whether the inquiry as contemplated under 5A2 of the LA Act has been duly conducted by the land acquisition collector. Now, this was dealt with by the Honorable Supreme Court at page 65, para 78.
65. Yeah.
Page 65, para 78.
You said 65 at 70?
Page 65, para 78.
78.
The question was framed at page 61, the way in which it is dealt with, para 78. Thus, there seems to be no application of mind either at the stage of issuance of the notification under section 4 of the LA Act, or the report of the collector under section 5A2 of the LA Act, or the issuance of the final notification under section 6 of the LA Act. Such an acquisition, if allowed to sustain, would lead to the attempt to justify any and every acquisition of land of the most vulnerable sections of the society in the name of public purpose to promote socio-economic development. At page 69, para 88, it is also a well-settled principle of law that if the manner of doing a particular act is prescribed under any statute, the act must be done in that manner or not at all. And then so on, so on. So this rule has since been approved by this court, so on. So Lord, page.
When was section 6 notification issued?
Lord, section 6 notification was issued. I'll give my date. 28/10/2005.
No, what was section 4 notification? What is the date?
Section 4 notification was issued, my lord, on. I will give it. 24/1/2005. Section 4 notification 24/1/2005. My objections were filed on 10/5/2005. And final notification came to be issued on 28/10/2005. Which document is this?
See, that's the only factors or dates which would be relevant.
That's right.
See, we are comparing the dates between these which have been relied upon and the one which we are concerned in this appeal.
That's right.
Is the difference between the final notification and the filing of the writ petition, Mr. Joshi.
Look,
that becomes relevant.
I would not urge this point so much. I would not labor on this point so much as much. If, my lord, my writ petition were to be rejected on this ground, if my writ petition were to be rejected on this ground that I have come too late to the Honorable Court, I would have then had an opportunity to demonstrate before the single judge, learned single judge. In fact, my lord, if my lord even now is inclined, may remand this matter back to the learned single judge. I will urge this point before the learned single judge, justifying the reasons for coming to the late at a belated stage, to the court at a belated stage. For this reason, the state itself said they don't need my land. The state itself did not do anything near my land. I had no reason or occasion to approach this Honorable Court questioning these things because in any event I had submitted my objections and I heard nothing from the state. Therefore, I had no occasion to come before this Honorable Court, before the learned single judge. It only several years later, when some activity was threatened, that I came before the learned single judge. There I urged this ground, correctly so, that Section 5A objections were not considered and that is fatal to the acquisition proceedings. Learned single judge takes note of that, but says, no, compensation has already been deposited, now it is too late in the day. And my learned friend said that PCB approval has not been received, but I have also filed an application under 41 Rule 27 to produce an additional document. This was apprehended and therefore anticipated, and therefore, my lord, there is one more proceeding of 11th July 2014, where they themselves take into consideration the factum of delay of the PCB approval and say that we are not proceeding with the project.
No, but that has been dealt with by the learned single judge. Insofar as delay is concerned, come to page 19, paragraph B. That answers the delay. He refers to the judgment of the Supreme Court.
That's right, my lord.
And
that is true. Those are decisions referred to by the learned single judge suo motu. It was not a ground raised against me. I was not confronted with the question that please explain the delay why you have approached this court after so many years. The delays, the reasons for the delay are very apparent from the record itself. Nothing was done on the ground. They themselves have taken decisions that this project is not necessary. We are not going ahead with the project. If at all the approvals have to come, as and when they come, we will consider at that point of time. Can the state, my lord, notify a land for a public purpose in 2004, 2005? Do nothing about it, right?
Mr. Joshi, now possibly you are right if they had not done anything even as of today.
True.
Getting? But it's a fact that which you also concede, he also has.
The photographs, those are on the ground. What is happening is on the ground.
So if that be so, surely we can't overlook this aspect.
Lord, then, my lord has been very patient. My lord has been indulgent towards.
No,
Give me one more opportunity on this ground, that where the state has notified, because there is case law, I don't have it in my hands right now, on this proposition only, and I will not urge any other proposition thereafter. On the ground that where the state has notified a land in a particular year, does nothing about it for more than a decade or two, and then ventures to say that I had notified your land then, now I'm coming up with a public purpose. Would then the courts allow such an acquisition to proceed further? Or would the state be asked, what did you do for 20 years? And now if you decide to use the land, you please re-notify. Only then you will be allowed to use the land. On that proposition, my lord, I will find decisions supporting. 20 years later, my lord, they wake up and say that now I want to do something about it. When the record goes against them,
Now they are showing it.
The record goes against them. They have given up the land. They have given up the acquisition.
That has been dealt with by the learner single judge. We don't know.
Not
There
in
is
so many
some,
words.
there is an, yes.
Not in so many words, my lord. Those are just references to say the learned single
Page
judge was
2122, paragraph D. It's ununderstandable as to how the town municipal council could pass a resolution of the count, recommend that the subject land is not suitable for the purpose which has been notified for it. It's a matter of technical expertise, therefore the credence cannot be given to the version of this. But in any case, it's a fact insofar as these documents are concerned, the photographs are concerned. And it's ultimately for an STP plan. Now, see the larger.
this one indulgence on whether the state can be permitted to do this. My lord is impressed with also the fact that now activity has started. What would be the legal significance of
We are
such an
with
act
you.
on the part of the state?
We would be with you. We should have been with you, provided if they had not done even laid a brick on that from 2004 till 2024, after 20 years of elapsed, possibly what you are arguing, we could have put it to them and answered them to explain.
In
But
fact,
that's not the position now we have gone much about. When you were arguing before the learner single judge, possibly you had that ground.
correct, my lord.
Maybe because no work had started.
True.
And you had relied upon the town planning department resolution.
And a few other resolutions by them also saying that we are not going ahead with the project.
But that's in any case, factually, that may not be able to be sustained today in view of this work is being done.
Well, on this one single limited aspect, let me just come back for.
No, but tell us what would be
the proposition is this.
No, you have to show us, tell us what would be the follow-up. Let's assume for a moment we agree with you. What would be the consequence?
This activity will have to stop.
And what?
Merely because, my lord, it is a public purpose. The state cannot be allowed to get away with anything and everything. It still has to follow the law.
That's where the delay latches comes. That's where the delay latches comes.
Except for the delay in filing the present appeal, approaching the learned single judge, there was no delay. There was no reason for me to delay. There was no occasion for me to act diligently or come at an earlier point in time. List of dates and events and on this proposition. I know, my lord.
We would be with you if you have 2005, 2004 notification, you give objections under 5A, right? 2005 itself or 2006, the final notification comes. That's the triggering point.
True.
For you to challenge it, look here, I have given my objections. This is the law by the Supreme Court. And mind it, all these petitions are those petitions where the gentleman has gone immediately thereafter, unlike the case here.
Thereafter, he is guided by legal counsel. Therefore, he acts more diligently. Earlier, not so. Earlier, on the ground, this is the issue. Well, on this proposition indulgence, a few days later, I just
to take it further, Mr.
Because 20 years later, if they are coming forward, can such an activity be permitted?
No, the work is going on. So, what is the stage? This is the latest stage.
No, my lord, that is 1 year back.
1 year back.
Well, this also started only after the writ appeal was filed.
All right, we don't know what is the position. Maybe the whole plant is working also.
Part of it is working, my lord.
My
We're
lord,
separating the segregation of.
Can somebody be sent there to examine the proposition? Nothing has started working there.
No proposition in these facts, Mr. Joshi. No propositions in these facts.
Only on this proposition.
Case, you're right.
Only on this proposition, my lord. 2 decades later, an old acquisition, can that be revived by the state at this point in time and say, 2 decades ago, I had done it. I did not do anything about it now. Today, I'm doing something and nobody can question me.
Not in these facts. Thank you.
Very good.
We'll pass orders. We will just dismiss this appeal. Just give
Obliged.
us also, ma'am, judgment secretary. We'll dismiss the appeal. Next.
Obliged, my lord. Patient.
Thank you, Mr. Joshi.
Serial number 19.
Just show me that.
Tejas.
file.
Appear for the
Just show me.
appellant.
Yes, Mr. Raghavan.
My lord, the first submission I would make for your lordship's my lord is with respect to the order and repeal dated 6th of March 2024. The order, my lord, is against.
Yes,
I'm sorry. I'm very sorry.
Your lordship, kindly, my lord.
Wait.
Yes.
Your lordship, kindly, sorry. Lord, in this matter, we have engaged the service of Advocate General. Some inconvenience today is in Delhi. So any other date, my lord?
We'll have it some other day, Mr. Raghavan. Him come.
Very well.
Just say that request for adjournment is made on behalf of the respondent on the ground that learned Advocate General is out of station. Adjourn to interim order if any to continue till the next date of hearing.
I am the subsequent allottee. The allotment made in favor of Mr. Raghavan's client was thereafter made to me after it. My
Are you a
request for an
party?
earlier date, my lords.
Are you a party?
I filed an impleading application. My request for, there's an interim order.
What do you say, Mr. Raghavan?
I am objecting to that, my lord. It was all done during the pendency of the proceeding. It can't be done alone. It was done during the pendency of the proceedings before this court.
When were you allotted?
Lords, I was allotted after the writ petition was dismissed.
After the writ petition was
Dismissed.
After the writ appeal was filed, I believe.
No,
The writ appeal
the-
was filed, right? When was the allotment?
What does the interim order say? Does it say status quo?
Status quo.
Very well, whatever is status quo, we will interpret.
That's all. I have objection to the impleading, but they can't now. It is purely a matter between me and the KADB. And according to me, my lord, the entire cancellation is illegal because it is not in accordance with the law laid down by this honorable court in an earlier division bench judgment.
Which is your application? What is your application number?
My lord, the application is, my lord,
3 of the 4.
Give me the dates. When were they allotted? When was it? My lord, writ appeal in this case was filed on 22/3/2024. Allotment was made on 18/4/2024. That cannot be done. And of course, my lord, the interim order is, my lord, on 23/4/2024. My lord,
Before allotment.
No,
no, my lord. No. The interim order is 23/4/2024. The allotment was made on 18/4/2024, but it was during the pendency of the writ appeal. Therefore, my lord, they can't be implemented.
We say nothing on that.
Yes, great.
We'll just adjourn it. We will see whatever is.
Very well, whatever.
He requesting for a short ticket.
We'll give you a date. What is, just give a date, ma'am.
21st February,
Next 21st February, Mr.
serial number 20, Shri Sanjay
Right.
Krishna.
Yes.
20.
My lords, I appear for R4, my lord, on caveat, my lords. So similar matter to serial number 3, my lord. Serial number 3, my lords, in today's list. A similar matter,
This is?
a similar matter to serial number 3, my lords, and of today's list, my lords. The beneficiary has already taken possession and they have
Does
already
it
transferred.
arises from the same order?
Yes, my
Same,
lords.
same order.
Same order, my
Same
lord.
order, but insofar as my learned friend's submission that beneficiary has taken over possession is concerned, I strongly oppose that, my lord. In fact, I have obtained information under RTI as on 8/1/2025, they have given the list of.
What is the date there?
11-2, my lords.
We'll have it on 11/2.
Both the
Yeah,
matters can be
11-2.
taken up together, my lord.
List on 11/2. When we have been informed and a connected writ petition writ appeal being 584.
Yes.
2024 is listed. I just say item number 3 in today's list.
Please.
Is listed 11/2.
Yes.
21. Vinayak Rao.
But is the section 9 petition before the trial court, interim order was refused by the court, and against that I have filed the appeal before this honorable court. On 10/12, my lord, this honorable court granted an order of status quo. Therefore, the refusal to grant interim relief, my lord, that is subject matter of this appeal. Under section 37, my lord, refusal
What
to
is the
grant-
ground for challenge?
Refusal to grant interim order is also an appealable order under.
Why there is a maintainability issue?
The railways have terminated my contract. It was entered in 2019 for 8 months. And it was for construction of toilets in 17 locations, my lord. They did not give me the locations, only 7 locations, 8 locations they have granted.
The issue on maintainability.
Please, my lord.
What is the issue on maintainability under 13(1)(a)?
My lord, the office says appeal under refusal to grant interim order is not appealable is the.
Now, how would be maintainable? Tell us.
Section 37 of.
No, 30?
37 of arbitration.
Was it under section 9?
No, petition under section 9.
The petition was under file under section 9.
Please, ma'am.
Now, let's see, how do you 37(1)(b). Okay, now what happened? The arbitrator in place?
Well, not yet, my lord. I have.
You invoke?
I have not yet invoked, my lord. I will have to.
Invoke, no?
I will invoke, my lord. I will invoke shortly, my lord. I will have to. This interim order was granted on 10/12, my lord. I will invoke shortly, my lord.
This is not the way. You should have invoked it.
My lord, yes, my lord.
No, you will not.
But that is.
So when did you file section 9?
But section 9 was filed before the court on 24/11
of
2024. On 4/12, my lord, the court has.
What is the process of appointment of arbitrator? They appoint the arbitrator.
My lord, yes, my
The
lord.
panel.
GCC, my lord, they will appoint that, but that is now gone, my lord, because of.
No, they may have recasted the panel also now.
After.
Have they?
That information that I don't know. Well, because of 2024.
Now, what is the interim order you sought?
Not to invoke the bank guarantee which was given.
Have they invoked the bank guarantee?
Not yet, my lord. It is in after because of interim order granted by this honorable court.
Oh, this court has granted the interim order.
Please, my lord, 10/12.
Very well. We'll ask them, is anyone appearing?
They have served, my lord.
Have they been served, ma'am?
Please, ma'am.
Central government.
She has appeared on the first date of hearing.
Just call the council. Pass over.
Sumati. 22. Serial number 22.
My lord, appearing for the appellants in the matter, my lord. The matter pertains to affiliation.
May I make one submission, my lord? This appeal has become infructuous in view of the fact that the order which was impugned has been complained by CBSE, which is the appellant herein, and an endorsement has again issued rejecting my application for seeking affiliation. That was challenged in another writ petition. The other writ petition also came to be disposed of, my lord, with a direction to, I am just
My lord,
passing on
this
this,
is
my
not a
lord.
question of law, my lord. The fact that they have not got BBMP approval, my lord, they are seeking affiliation by the CBSE board, my lord. 27 students are going to suffer on this account. And they,
So who is the appellant today here?
CBSE, my lord.
No, you appear for CBSE?
Yes, my lord.
Now, what did the learner single judge hold?
The learned single judge
Remanded the matter for fresh consideration of the application filed by the respondent.
My lord, this is.
Fresh
the
consideration
second
for what?
petition, my lord.
For affiliation, my lord, seeking affiliation for CBSE course.
Now, what happened? Have they passed any order?
Yes, my lord. They have again rejected. I am just passing on.
Then, ma'am, what remains?
My lord, the fact that they have not built the boundaries of the school and they haven't complied
Right.
with the.
But you have again
bylaws.
rejected it?
Yes, my lord.
That's all. They will challenge that order.
That also has been challenged.
That has been challenged.
And that writ petition also came to be disposed of, again remanding the matter.
Again
Second time. That
So
copy
this
also I
will-
have produced.
So now what remains in this appeal? Now there is a further appeal.
Yes,
That is a further remand.
Yes.
That you must look into it.
My lord, but the fact, it's a question of law, my lord. It's
What is the question of law? Whether the wall is relevant to be there or not for the purpose of recognition or affiliation.
Yes, my lord.
That's all.
Yes,
You will
my-
look into in the second appeal, not in this appeal.
My lord, there's no challenge on the second appeal, my lord.
No. I produced a copy also. Told you.
Just give it to her.
That also came to be disposed of.
My lord, this is the second writ petition, my lord. It's not an appeal.
Right. What he's saying is, after this order, there was a fresh order passed by CBSE. Which order has been challenged, that writ petition again dismissed or again remanded back.
Yes.
Now it's pending with them.
My lord.
They have passed a final further consideration.
That I am not aware, my lord. That is remanded again, my lord.
So, but what he says is against this order appeal has become influence.
Yes.
We will note his submission.
My lord.
An order copy I have produced along with the memo. Yes, I'm sorry.
We'll note his, just take down.
Yes.
The challenge in this appeal is to an order passed by the learned single judge in writ petition dated 24 January 2024 in writ petition number 25599 of 2023. Whereby the learned single judge has disposed of the writ petition by stating in paragraph 10 as under the learned counsel appearing for the respondent would state that pursuant to the order of the learned single judge, the CBSE has rejected, has passed an order dated 4/53/2024, rejecting the application for affiliation of the respondent. He states that even the said order was challenged by the respondent in writ petition number 8992 of 2024, which came to be disposed of on 12th August 2024 by the learned single judge by stating as under paragraph 11. He states he is not aware of the any further any order passed by the appellants herein pursuant to the directions of the learned single judge. In any case, it is his submission that insofar as the present appeal is concerned, which arises from the order dated
24/120.
Order dated 24 January 2024 in writ petition 25599 of 2023 would not survive for consideration. Full stop. Yes, ma'am.
My lord, may I take you through the bylaws, my lord, if,
Ma'am, you have to take it bylaws.
yes, my lord.
If you have filed any order, challenge the appeal in this order, in pursuant to this order.
My lord, we haven't challenged the writ
Full stop.
petition.
You just say that you are aware that what happened on this order?
My lord, we aren't aware of writ petition
They are represented by the
8992.
council. They are represented by the council, ma'am.
My lord, different counsel, my lord.
Just check up, we'll pass over.
Yes, my lord.
Just ask take instructions after 12th August 24 order was passed, what action they have taken.
Yes, my lord.
Okay, pass over. We'll call up after lunch. Just get your instructions.
23 office objections complied by.
What is the issue?
To serve copies on the Union of India, second respondent.
What is the issue?
Issue is transferring the respondent from Bangalore to Mukteshwar, Uttarakhand.
Oh, Mukteshwar is a beautiful place.
But these people are refusing to go there.
Who?
The scientists.
Acha, you are from ICAR.
Yes, my lords.
So what is the difficulty they are facing?
They're facing is continuously 10 years he was there. Thereafter he has transferred to Bangalore. Now 5 years are over here as on today. As on the date of refusal, his daughter was studying in second PUC. That was to eradicate PPR virus from India. His service is more essential. He's the best scientist. There are 2 scientists in Bangalore. Their service is more important to the ICAR. Therefore, they transferred them, not intentionally or in any other manner.
Just say that issue notice.
They filed KV.
How much service he is left with, we want to know.
1 minute, my lord. He's now 49 years, my lord.
Oh, he's 49. You still have service. No, he's a scientist, no?
He's scientist.
It would
He's
be
the best
65.
scientist.
This must be, I think you are following the UGC
Yes, my lord.
issue notice, returnable on. Next.
5th of March. 24.
A short date may be given, my lords.
All right, sir. Then easy working, na?
Yes, and their service are much essential, my lords. It's a serious diseases for the animals, cows, that
Today-
comes to the mouth.
That tell us one thing, when you transferred him back, you must have posted someone there.
So, other scientists are there, my lords, but they are not capable like these scientists, my lord. These were the best scientists,
What is his designation? Principal scientist?
principal scientists, my lords.
Who appears for the respondent?
No, it's not it. This is, office objection has come, my lord. I complied on the 18th.
Okay, just we'll give it in first week of March.
Kindly have it in the month of February, my lords.
First week of March.
5-3.
5-3. Next.
4. 24.
My lord, kindly give me 2 weeks time to remove the office objection.
What is the office objection, Mr. Gupta?
2 frames.
Say two different orders.
Yes, my lord.
At the request, office objection be cleared within 2 weeks, list on.
21st February. Serial number 25, Sudhakar Pai.
I beg to appeal for the appellant, my lord. There is a little discrepancy, my lord, as to the date of institution of the suit. In fact, my lord, suit is instituted on 18/1/2016. Your lordship may kindly turn to ink page 33, my lord, in the decree. Suit present ink page 33, my lord. Decree. 12/1/2016, 18/1/2016. Registered on. Even your lordship may kindly turn to, my lord, ink page 14, my lord, in the judgment column, internal page 4. It is 18/1/2016. But by inadvertence, my lord, the register of the trial court in ink page 11 has stated that it is 13/1/2023. It is by mistake, my lord. For acceptance of that, my lord, the register has posted this before your lordship. In fact, I am having the certified copy of the plaint. It is presented on 18/1/2016 in OS number 16 of 2016, which was renumbered as OS 30 of 2023 in the year 2023.
The decree sheet rightly shows 18/1/2016.
Yes, my lord.
So where is the discrepancy? Where is the error?
Error in ink page 11, one place. In 2 other places, it is correctly stated. That is error committed while giving the certified copy of the judgment, my lord. Only in judgment, ink page 11, first page of the cause title, my lord. It is stated on the top. That is 13/1/2023. It is a mistake.
Who will correct it? The district court concerned must correct it. We will not correct it here.
Yes, but the date of judgment is 25 October 2024.
We are with you on that.
Yes.
But this presented, registered on, need to be corrected here. Possibly you may have to file an application there.
Yes.
So there, that correction is undertaken in this order passed by the trial court.
No, but in the very same judgment, it is stated, my lord, ink page 14. 14 may kindly be perused, my lord.
You're right. We have seen that, but you will say this to the court concerned. You're right.
Yes.
See, otherwise, unless this order is corrected, for all future purposes, this order would stay like this.
But the problem is, in fact, there is no problem because OS number 30 of 2023 is a renumber and date of decree, everything is, my lord, in October 2024. Everything is in order, my lord.
Will it not be appropriate you get it corrected?
But the problem is, my lord, I will assure your lordship, my lord, to do it. But the problem is, my lord, now the final decree proceedings is initiated and this appeal is filed on 6th of reopening, the 6th of January. So your lordship may accept it, my lord, that it is a mistake of the registry of the trial court. And this appeal may be posted for admission any day this week.
Not even the registry, it's something when the order was being dictated or signed, that was not seen by the trial court judge.
Yes. So, my lord, even my lord, at the time of filing, my lord, I have seen.
What is the challenge to the first appeal, in the first appeal?
In the suit for partition, my lord, the parties are governed by Roman Catholics. My lord, the property was of the father. My My lord, mother, my lord, under section 33 of the Indian Succession Act gets 1/3. My lord, they have set up a will of the mother. That will is accepted, my lord. It is totally concocted and evidence led in by the attesting witnesses of PW and 2 and 3 are totally contradictory, my lord, to their own stand. That I will point out, my lord. And
The date in the final proceedings,
30th or 31st of this month, my lord.
any commissioner appointed?
My lord, on 4th it was there, my lord, 4th of January, because I have filed the appeal in time. But before I filed the appeal, my lord, they have filed the final decree proceedings. And on 4th, my lord, it's finally posted to 30th or 31st, my lord. I am not sure.
For what purpose?
For making, my lord, for effecting the division, my lord.
No,
For
but
appointing a commissioner to appoint.
to appoint a commissioner.
Yes. So I have stated so in the affidavit also, my lord, that the FDP number also I have stated, my lord, the 15 of 2024, my lord, FDP 15 of 2024, my lord, they have filed 1/5. In page 48 in the
Just
affidavit.
say issue notice. You serve the other side,
Yes.
returnable on, give it first or second week of February.
12th of February.
The learner counsel for the appellant states that an error has crept in the impugned order of the trial court in as much as the page 11 of the paper book depicts the filing of the suit as 31/1/2023.
13/1.
13/1/23, whereas the decree
14.
sheet at page,
No, even in 4, my lord, page 4, the judgment itself.
whereas at page 14, the date of institution of the paper book, the date of institution is depicted at 18/1/2016.
Yes.
In fact, this date of 18/1/2016 is also reflected in the decree sheet. He states that he intends to move the trial court for the correction of the date of filing in the judgment oblique the decree sheet. You know, at page 11 of the
Yes.
paper book. First, noting
Correction
the
is
said
required only
submission-
here.
Noting the said submission, issue notice, re-notify for the date fixed.
May I seek
Just
one,
give the,
may I seek your lordship's one indulgence, my lord. So far as respondents 3 to 10, my lord, I am seeking dispensation, my lord. I am not seeking any relief as against them, my lord.
just say this, notice. Then
So
a counsel
only
for
1
the-
and 2, my lord.
Then a counsel for the
Yes.
appellant states that the notice to respondents
3 to 10,
3 to 10 be dispensed with as no
relief is sought
no
against.
relief is being sought against the said respondent. If that be so, in this regard, he has filed what is this?
Memo seeking dispensation, my lord.
He has filed a memo seeking dispensation of notice to the said respondents. The same is taken on record. He should file the
Yes.
same through e-filing also
Yes,
within 2 days from today.
yes,
Okay.
yes.
Then issue notice to respondent number 1 and 2, returnable on.
12/2.
Next,
In the meanwhile, my lord,
12/2, you make a request. You are before this court. Okay.
no, in the meanwhile, my lord, drawing a final decree may be stayed, my lord. Let the proceedings may go on.
No, will tell us one thing. Commissioner need to be appointed. He will give his report. He will go inspect everything. There's a lot of work to be done.
Well,
Like-
generally, my lord, this is a first appeal, my lord, requires to be. So let the proceedings may go on, my lord. Only drawing a final decree, your lordship may say, my lord.
Very good. We have been informed that the date of hearing in the final proceedings is
30th of
30th of January 2025. If that be so, no final order shall be passed in the final decree proceedings till the next date of hearing, list on 12/2.
12/2, my lord. Great.
Serial number 26. Recontra.
Lord, appearing for the Appellant, Lord, I seek leave to convert this MFA into a commercial appeal. It's passed by the commercial court. Inadvertently, it has been filed as a MFA. I kindly seek liberty to convert the petition, my lord.
The learned counsel for the appellant states that inadvertently the appeal has been filed as an MFA. He has also, we also note that even the registry has raised an objection on the maintainability of the appeal against an order passed by the Commercial Court, Bengaluru. He states that the permission be granted to convert the MFA as a commercial appeal. Just noting the said submission, comma, the what is the separate classification which has been done?
That is commercial appeal.
Commercial appeal.
Commercial appeal.
If that be so, comma, the appellant counsel for the appellant is permitted to convert the MFA as a commercial appeal. Necessary correction, necessary, what will you do? You will file a fresh or you will make correction here only?
I'll make correction, my lord.
Will not create confusion.
I'll carry out the correction. He has to file another commercial appeal.
First, I'm noting, he has to file a fresh appeal. Everything, the permission is granted, comma necessary corrections being made in the appeal memo for the purpose of statistics. This MFA 251 of 2025 shall be considered as disposed of. Okay?
Much obliged.
Thank you.
27. Shobhit Shetty, 27.
Appearing for appellant, my lord. The appeal is maintainable, my lord. There is no commercial dispute between the parties.
Commercial dispute.
You are filing it under 37,
Yes, my lord.
not under 13(1)(a).
No, my lord.
Why?
There is no commercial dispute, my lord.
This is land acquisition.
Yes, my lord.
Okay. The submission on the objection of the appeal, the registry on the maintainability of the appeal against order dated 8/11/2024, Learner Council states, as the dispute in question is not a commercial dispute, hence the MFA is maintainable. The registry shall give its report on the next date of hearing on this submission made by the Learner Council for the appellant. Re-notify on, just give it in February.
Please.
Next.
20th February. Serial number 28, Shri Jaikar Shetty. 28.
My lords, I appear for the respondent. My senior Naresh Thakur is appearing online, my lords.
My lords, with your lordship's permission, may I appear in this matter for the respondents, my lords. Your lordship will recall, my lord, this is that matter of Google where, my lord, a FEMA matter of Google where the tribunal, in the tribunal, my lords, the matter was listed on the 13th. However, my lords, they have once again sought time on the same ground. And the matter has now been posted in the tribunal on the 20th.
Yes, Mr. Shetty.
This is against the interim order, my lord, without ordering
You say
for,
security.
please, my lord, pre-deposit or subject to certain security, my lord. What the second proviso of section 19 of the act, very clear, my lord. it can be dispensed with, but subject to. That word is used, my lord. But here, my lord, the
What is the apprehension?
apprehension, my lord, the amount involved, my lord, the outstanding was 363 crores and penalty imposed, my lord, almost 6 crores, 5 crores to the main company and 20.
And what does the tribunal say?
Prima facie case made out. So prima facie case made out, my lord, that is not the ground, my lord, that is Manatosh Sahas case, my lord. On the point, my lord, it has been discussed. In fact, my lord, the realization of the penalties also, that is undue hardship as well and may be considered, but safeguarding the realization of penalty is also a twin points to be considered. That is the dictum of the Honorable Supreme Court, my lord, your lordship very well aware. But when Act says, my lord, the, whether tribunal is right in discarding that particular provision, maybe pre-deposit, my lord, to some extent, whatever may be the discretionary, but condition subject to certain condition, that is the word used, my lord. Even it, that prima facie case will not come in the way. That is on merits, my lord, it has to be decided. Maybe for interim order, my lord, that word may be used. But ultimately, my lord, the tribunal is seized of the matter so far as merit is.
No, see, he is trying to justify it. Please. Permission granted by the RBI.
No, that is the only point, my lord, whether it is a permission, whether it is condone the delay. Because here the delay is, my lord, 6 months is the maximum, my lord, under section 5(3) regulation. So here 3 to 7 years, my lord, they have kept the outstanding amount 363 crores, that is 79 lakh. With them, they may say, we have no benefit. That itself is a benefit, my lord. They should have sent it back to the foreign country. Because there is a clear violation, my lord. That is not disputed also. So far as delay is concerned. The only question is, my lord,
So you say penalty is justified?
Penalty is justified, but the only thing is, my matter is seized up by the tribunal. The only question is to safeguard the realization of penalty. That is the word used, my lord. Even I will just produce the one judgment, my lord, which is on the point. That is page 1, my lord. Manatosh Sahas versus Special Director Enforcement. The almost similar situation, my lord, here. Facts. Para 2, my lord, that is a penalty of 25 lakhs have been imposed.
Which one you are reading, Mr. Shetty?
First judgment, my lord.
Yeah.
Page 1 starts.
How much, what is the total now penalty?
Penalty 5
is 6 crores.
Nearly, my lord. 5 crores to the company, main company. 20 lakhs to each of the foreign directors and 5 lakh each to the Indian directors.
So that comes to 6 crores odd.
Almost, I will not have
Now,
not
which
calculated.
paragraph you are saying?
But in the order itself, it is there, my lord, page last 90.
How much is the percentage allowed for deposit?
Fragment, there is no fixed percentage. It is left to the tribunal, my lord, considering the hardship, if they make out normally 50 or whatever, my lord, normally 100% will not be because there is no, but the lordship kindly see proviso 2 of 90, that is very clear.
Sure that FEMA.
FEMA. The tribunal can't substitute that, my lord. That provision, my lord, when there is, that's expressly provided. Discretion, okay. All right, my lord. Considering,
Tell us one thing.
please.
There is a concept of undue hardship also.
That is why, my lord, pre-deposit may be, my lord, it varies to the percentage wise, but the condition that security, my lord, subject to certain security. That is,
Let's see that.
that is bothering factor, my lord. Because the amount is, because they have violated for more than 7 years, my lord. That is not in dispute. Only question is whether RBI has condoned the delay or they have given permission to the bank.
Which provision you are reading?
That is proviso
17,
19, my lord.
19. Appellate to
Appeal to appellate tribunal. That is provided first proviso, my lord, second proviso. Provided further that where in any particular case, the appellate tribunal is of opinion that the deposit of such penalty would cause the undue hardship to such person, the appellate tribunal may dispense with such deposit subject to, that is very important, such conditions as it may deem fit to impose.
So it may not be the complete penalty. Something lesser than that also in the discretion of the tribunal can be
My lord, we,
directed to be deposited.
please.
Okay.
Then even in Manato's case, my lord, they have deposited it, but still, my lord, the Honorable Supreme Court imposed a condition of that is.
No, where does the Supreme Court say?
Madam.
Para 8, my lord.
Hmm.
In fact, they have extracted in the order itself, my lord, 19. It is true, para 8, my lord, page 2.
Hmm.
It is true that on merely establishing a prima facie case, interim order of protection should not be passed. But if on a cursory glance, it appears that the demand raised has no legs to stand, it would be undesirable to require the assessees to pay full or substantive part of the demand. Petition for stay should not be disposed of in a routine matter, unmindful of the consequences flowing from the order requiring the assessee to deposit full or part of the demand. There can be no rule of universal application in such matters, and the order has to be passed keeping in view of the factual scenario involved. Merely because this court has indicated that the principle that does not give a license to the forum or authority to pass an order which cannot be sustained on the touchstone of fairness, legality, and public interest, where a denial of interim order may lead to a public mischief, grave irreparable private injury, or shake citizens' faith in the impartiality of the public administration, interim relief can be given. It has become an unfortunate trend to casually dispose of the stay application by referring to decision in Siliguri municipality and Dunlop cases, Supra, without analyzing the factual scenario involved in particular case. That is para 10, my lord, section 19. So proviso 2 is also too significant, that is para 11, my lord. Expression used in provisions are undue hardship to such person and safeguard the realization of penalty. Therefore, while dealing with the application, twin requirement considerations, that is consideration of undue hardship aspect and the imposition of condition to safeguard the realization of penalty had to be kept in view. As noted above, there are two important expressions in section 19(1). One is undue hardship. This is a matter within the special knowledge of the applicant for waiver and has to be established by him. A mere assertion about undue hardship would not be sufficient. It is noted by this court in yes, Vasudev and state of so and so that under Indian condition expression, undue hardship is normally related to economic hardship. Undue, which means something which is not merited by the conduct of the claimant or is very much disproportionate to it. Undue hardship is caused when the hardship is not warranted by circumstances. For hardship to be undue, it must be shown that the particular burden to have to observe or perform the requirement is out of proportion to the nature of the requirement itself and the benefit which the applicant would derive from compliance with it. the word undue adds something more than just hardship. It means an excessive hardship or hardship greater than the circumstances warrant. This is important. The other aspect relates to the imposition of condition to safeguard the realization of penalty. This is an aspect which the tribunal has to bring into focus. It is for the tribunal to impose such conditions as are deemed proper to safeguard the realization of the penalty. Therefore, the tribunal, while dealing with the application, has to consider material to be placed by the assessee relating to the undue hardship, and also to stipulate condition as required to safeguard the realization of the penalty. The above position was highlighted in.
But how would you answer
Please, ma'am.
the other aspect, paragraph 15, relates to imposition of condition to safeguard the realization of penalty?
That is what, my lord,
No. Submission, the ground is that if you succeed, you will be not in a position to realize the penalty. You're getting the point?
Please, ma'am.
One is undue hardship on the part of the appellant. See, I don't have money or for certain reasons. This penalty is highly improbable or it's very high. It will create undue hardship, not only
Maybe, my lord.
hardship, undue hardship.
They satisfy the tribunal matter.
Now, both need to be satisfied or one is sufficient.
But even if it is satisfied undue hardship, but tribunal has got the responsibility of safeguarding the realization of penalty. That is what the pin
Right.
condition.
Now,
Please,
suppose what is being argued is,
please.
look here, where can be an apprehension that if it doesn't, the respondent doesn't succeed, you will not be able to recover the
Please,
penalty.
ma'am, for that at least, ma'am.
What is the basis for you to say so? You're getting the point. He will run away. He's night by, once he gets a judgment, he may do it. He will not be able to recover the penalty. Hence, under such scenario, the penalty coupled with not a case of undue hardship and the fact that he will run away, because of which the penalty need to be asked to be deposited, whatever is in the discretion of the tribunal concerned. So these twin tests need to be, satisfied, or one test would be sufficient. It is not a case of an undue hardship. There are sufficient means for them to deposit.
But right or wrong, my lord, they suffered in a penalty order, my lord.
They are, right? You're right.
Please, my lord, that's why, my lord, order is against him, but he has to
show the
amount has been, the order has been challenged, my lord, that is a subject matter before the tribunal. But order is there, staring at him. But for that, my lord, at least deposit, it is left to the tribunal, my lord, considering the undue hardship. Whatever he makes out a case, my lord. So far as, that is why I'm word used, my lord, the para 15, my lord.
Oh, now see, very interesting, this provision only refers to undue hardship. Provided further.
Provided further is.
In a particular case, the appellate tribunal is of the opinion that deposit of such penalty would cause undue hardship to such person. The appellate tribunal may dispense with such deposit subject to such.
Subject to that is the word, man. Because he can't avoid that condition, the security.
No.
But deposit of the amount may be dispensed with.
But we want to know, how does the Supreme Court, in paragraph 15 of this judgment, refers to this? The other aspect relates to imposition of condition to safeguard the realization of penalty.
That is other aspect is, my lord, they have mentioned what is other. So safeguard the realization. That is a twin condition. One condition is undue hardship. Or Supreme Court discussed. Then other aspect is realization, safeguarding realized.
Achha,
because two twin condition.
Now come to 19 first proviso.
Please. Provided that any person appealing against the order of the adjudicating authority or the special director levying any penalty shall, while filing an appeal, deposit the amount of such penalty with such authority as may be notified by the central
Now,
government.
what has been notified by the central government? Any authority notified? Where will they deposit? See, deposit has to be made where?
That I will have to ascertain on that.
Before which authority? Will they be with the
Tribunal
appellant
only, my lord.
or the tribunal?
Because appeal with the deposit, my lord.
You're right.
But second provision, my lord, it has been, discretion power has been given, but subject to condition.
Only in the case of undue hardship.
Undue hardship, they will have to make out a case, but deposit may be dispensed with. But condition, my lord, subject to condition. There also word used, my lord, in the provision itself. That's why, my lord, Honorable Supreme Court says, the other aspect of that's safeguarding the realization, because the tribunal can't
Okay, which are the other judgments?
forget
you are-
the, please, my lord.
Which are the other judgments?
Other judgment, next, my lord, page 5. There is a under central excise, my lord, here also, my lord, pre-deposit for hearing an appeal. Here also, my lord, the consideration of to be balanced by a court, undue hardship to SSC and safeguarding the interest of revenue.
See, tell us one thing.
Please.
They may not have undue hardship. It cannot be their case. Let's assume, subject to hypothetically, we are thinking. They may not say undue hardship, but they say what is the apprehension on the part of the appellant that if you succeed, they will run away or they will not be able to deposit or they will not deposit the penalty. What is the basis for you to say? You're getting the point?
Normally, my lord.
Let's assume you succeed in the appeal.
But in any of the cases, my lord, that point has not been come, because we will also, he has to prove, my lord, undue hardship. But realize, safeguarding the realization of the penalty, my lord, they have not
But this
discussed about
this proviso, even the Supreme.
because penalty is there. Order is against him.
Right.
That itself is a.
What is the basis for you to say, if you succeed before the tribunal, who succeed before the tribunal? You succeed, they are in the appeal before the tribunal
But
against the penalty.
Amount will be
But
reimbursement.
what we are putting it to you
Please.
is, if you succeed before the tribunal, you will unable to ensure the penalty is paid. What is the basis for you to say so? You're getting the point?
Please, madam.
That they will run away.
But none of the case, my lord, that point has not come.
Obviously, see,
Because
these
since he
provisions.
suffered an order of penalty, so to safeguard that, my lord, that is the point, my lord, even in the.
Safeguard for what purpose? The purpose is only this.
But
If you-
Honorable Supreme Court doesn't say, my lord, I will have to prove that if we succeed, there will be a problem for.
Obviously, you
recovery.
have to show.
But that is not the
Why not?
intention of the provision, my lord.
You read
Please.
this proviso, this paragraph 15 of the Supreme Court. Page 3. The other aspect relates to imposition of condition to safeguard the realization of penalty. Who would ensure the realization? You would ensure. This is an aspect which the tribunal has to bring into focus. It is for the tribunal to impose such conditions as are deemed proper to safeguard the realization of the penalty. When will the tribunal look into the fact that the realization may be difficult? You would only urge, look here, ABC are the reasons. Even if they don't succeed, even if you succeed, the realization for ABC reason would be difficult. He will abscond. He will not pay the penalty, or we filter away the money. He will send the money to other jurisdictions. You know, all those things. No doubt, insofar as the undue hardship is concerned, they have to plead. Very well.
They will have to prove, my lord. But so far as realization, my lord, there is no.
Which are the other
There is no
judgments?
responsibility of the department to disprove or prove of this running away or whatever, my lord.
Tell us.
Because your lordship very well aware in all this recovery suit and all, once a award or a decree is passed, there, my lord, normally the court will put a condition.
That's right. That's in a money decree. But
So,
here
Here also, my lord, penalties.
but there are conditions which have been laid down. That under what circumstances you would direct pre-deposit.
In this Manatosha Sahag's case also, my lord,
Very well.
so far as realization of penalty is concerned,
We'll come back
the
after lunch. We'll
Honorable
continue.
Court has not asked us, my lord.
Hmm?
Honorable Court has not asked the department to prove the
Yes, Mr.
Morning, my colleague have moved a memo that with one commercial appeal without court fees, my lord, we have compromised the matter. I have filed the appeal before this honorable court. In the meantime, parties have entered into compromise and my client is ready with the DD. Now, my lord, it is not, before it is, morning they have compromised, morning I have also filed. So now they are ready
We
with
were
the
only just thinking, Mr. Srinivas, whether you should file it, then seek the refund or.
Well, the reason is it is 100% refund. 4 lakhs I have to pay, my lord. I have to go pay and get it refunded. It's again a process. Instead of that, my lord, section 69 provides that even before hearing, first hearing also, if the parties compromise, 100% refund is provided. So therefore, I am seeking without insisting for 100% refund is provided under the.
Right, we are conscious of that. That's the reason we are saying. But that presupposes if deposit first, then return.
It's
We are getting into
undue process, my lord. It's a process, sir.
Right? It's all technicalities, but we are only in a situation where court fee must come, then you seek your refund. That's what we wanted to convey. Getting the point?
Yes, my lord, I got it.
Must come. See, ultimately it will come back to you.
My lord,
See, we don't want they should have any future consequence. People will seek exemption from filing court fee. Exemptions granted, no difficulty. We say 2 weeks, 3 weeks, 4 weeks. By the time they settle, knowing well that the settlement talks are going on. See, we don't want to put a procedure which would. That's what we are on. You're getting the point?
yes, my lord. If it's posted along with the office objection, we'll file the compromise petition also.
But still be the position same. The court fee has not come. That's the reason. File it. Now there is a Supreme Court judgment we have given. Supreme Court is also clear. Even out of court settlement between private, court fee can be refundable. Look into it. That's the reason we don't want to put a procedure which will have some future precedential value. That's the reason. Okay.
With my lord,
serial number 63, my lord. My lord, serial number 63. The senior,
Yes.
senior is out of station, my lord.
Who is the other side?
Other side,
You must inform the other side.
I will inform the other side.
No, you call them.
My lord, serial number
Call them.
61. Serial number 1, my lord, 61. A week's time may be granted. We have given the.
61.
Yeah.
Who is the other side?
Other side.
My lord,
65. my lord.
serial number 48, my lords. My learned friend is present.
Wherever both the parties are there.
Both
then
parties are present, my lord.
Who is the other side?
My learned friend,
40?
48, my lords.
Yes, what do you want?
My lords, a week's accommodation, my lords. Senior is undergoing some medical tests today. Therefore, my lords. Yes, my
That
lords.
we will decide. Okay? What is the order challenged?
My lords, 37 application I filed, my lords, where my 34 application is dismissed on the ground that it is not maintainable, my lords.
No, we want to know, what are the proceedings still going on?
33, my lords.
The application I filed after the issuance of the final law. My lord, I made a claim under 33 subclause 4 stating that some additional claims are required to be adjudicated. The arbitral tribunal makes a preliminary finding saying that there is some merit in the application but requires further information from parties. That is the order. That order was challenged by my learned friend before the commercial court. The commercial court comes to the conclusion that that is not an award or an interim award and therefore dismisses the 34 application.
What happened to 33?
One of the 30 is pending.
Still pending?
Yes, my lord.
For how long it's been pending?
My lords, stay, my lords. It's
Now tell us one thing. Let's
24.
put it this way. Now, suppose a final order is passed in 33, you'll get the jurisdiction to file 34? Yes or no?
Yes, but my lords may kindly permit me to make this submission, my lord. The learned arbitrator, my lords, in 33, what the order passed is, my lords, file fresh claim statements, file replies to the fresh
You're
claim
not
statement.
understanding. You're right.
I'm entitled to,
The 33 scope is very limited.
correct, my lords. I am entitled to it, my lords, but my sum and substance, my lords, in any which case, my lords, the learned trial court, my lords, dismisses my application under 34. My lords, on the ground that it is not an arbitral award. But my lords, the predecessor.
That he can't say so. 34 would still
yeah,
be.
Yes, my lords. That is and
No, you're right. Let's see, let's balance the.
I still
Just
have.
1 minute,
remedy.
please. 1 minute.
Yes, ma'am.
34, that's an award.
Yes,
He has sought the correction or he has filed an application under 33 under that.
yes.
That's an award. Now we are contemplating another situation. Let's assume his 33 is allowed. Where will you be placed with regard to your 34?
I'm allowed to file.
Then you have to challenge this?
Yes.
That's what we are saying.
Yes.
Think over it.
That's why, my lords. But in this case, my lords, all assume I'm in acceptance, my lords. But in this case, the predecessor entitled, my lords, in the trial court comes to a conclusion that it is maintainable. An application under 34 is maintainable and grants me an interim order. After that, my lords, when we are arguing on merits, it is urged for the second time.
It's an interim order, only a prima facie.
Yes, my lord.
Final view. Very well. Just say that.
65,
Request of
my lord,
counsel
serial
for
number
the-
65. Serial number 45.
1 minute.
My lord, 65.
At the request of counsel for the appellant, re-notify.
Serial number 45, my lord.
Just 1 minute, please. Let us give a date.
21 to
Next.
Serial
Yes.
number 45.
46 year. Other, it is not served to the other side.
40,
46 year. 2 weeks may be granted.
you said 46.
Yes.
What do you want?
2 weeks time may be granted.
Just show us, man, that.
Commercial.
What has to be done in this?
No, it has,
Huh?
it is as, already the notice has been issued, Your Honor.
Huh?
Still is
Who
pending for
represents the
state.
respondent?
No, it is not served yet.
Not served. Has it been served?
served, sir.
Served.
Served.
Not contesting.
46.
Cost title is not be shown.
Hmm?
Consider, sir.
46 is served. Just say at the request of counsel for the appellant, re-notify.
My lord, serial number 45, my lord.
In March.
45. 2 weeks time may be granted.
Who is the other side?
Other side is not contesting, my lord.
Uh-huh.
Other side not appeared.
Other side not appearing?
Yeah, yeah.
At the request of counsel for the appellant, re-notify.
My lord, 65. 65, my lord.
Hmm. Yes.
Seeking for 2 weeks time.
Hmm?
2 weeks.
Who is the other side?
We have informed the other side, madam.
Jay Kumar.
At the request of counsel for the appellant,
Appellants.
re-notify. Yes.
21 4.
21st February. If I could just request for any date in the first February.
It's not possible. Make anyway, we'll take it up on that.
My lord, serial number.
Possibly you must look into it, everything.
Yes, my lord.
33, see, the only thing appropriate would be to let 33 order be passed. Suppose if it is dismissed, your right to 34 gets revived. That would be the time when you will go. Suppose 33 is allowed, you have to challenge that.
That aspect, yes, my lord. But the procedure again, my lord.
My lord, 62, my lord. Sorry, my lord. I may permitted to submit.
Yes.
My lord, 62, your lordship may kindly permit me submit that. My lord, the first matter is filed by me. It is of the 2019, my lord. My lord, I should not be mistaken. The roster is different, my lord, and 21 is the subsequent appeal. And my lord, I inquired, my lord, because my lord, 19 is my first appeal, my lord. 21 is clubbed with this. I have requested Mr. Sunil also. My lord, the roster bench.
What is the submission?
My lord, submission is that my lord, 19th roster, it will not come to this honorable.
As per General Order 23/10/19, senior DB having.
Please, that was passed earlier, my lord. Subsequently, it was listed.
We don't know, ma'am, just
Please,
check up
please.
this.
Please, I will clarify.
My lord, serial number 56, my lords.
Madam. Madam.
Live ಇದೆ, live.
Hello, court officer. Hello. Hello. Court officer. Madam court officer. Hello. Hello. Court officer.
Madam, ಹೇಳಿ madam.
Madam, 2:30 Passover matters will be taken up first or from
Continue,
it
madam.
this
Continue,
will
continue. Continue.
Okay, madam. Thank you so much.
One small submission in respect of serial number C3, my lord. And for the appellant, in that serial number 63, there are no respondent, my lord. In respect of R2, they are already been dispensed with. R1, earlier counsel, the filed the wakalat, he was representing the appellant in the district and district courts, hence his name was removed, my lord. So there is nobody to inform regarding the adjournment, my lord, in respect of serial number 63. 63, my lord.
Where is that, ma'am? It shows the file. No? Who appears for the respondent to?
Respondent to is the sole arbitrator, my lord. So the notice has
Respondent number 1.
Respondent number 1, earlier the wakalat has been filed by the on PT Hebbar, my lord. The PT Hebbar, he was representing the appellant in the district court, so hence his name was been removed. And after that, nobody has filed the wakalat for the respondent number 1. So senior is out of station, so kindly have it on after.
Request of counsel for the appellant re-notify on.
After 15th, February 15th.
21st April.
Yes, Mr. Shetty, come.
So far as burden is concerned, my lord, undue hardship, my lord, he has to establish. So far as reverse burden is not there for the department to show. In case they fail, then what would be the consequences? Because there is a penalty, my lord, just like award or a decree. So this is a precondition to file a appeal. So there, my lord, the tribunal is required to follow certain procedure that is provided in the very act itself. Proviso 2 to section 19.
Is there any judgment which you have now relying upon?
Please, my lord. There also, my lord, page 4, my lord, 19, para 19 makes. There 25 lakh is the penalty. So he has deposited, still, my lord, Supreme Court ordered for security.
More
security, because there is no, I will just read, my lord. Undisputedly, appellant had deposited the amount which was directed to be deposited. However, for the balance amount, demand would be due to the safeguard the realization of the penalty. Appellant shall furnish such security as may be stipulated by the tribunal. So here, my lord, let the tribunal decide, my lord, how much security, at least, because pre-deposit, my lord, now there is a discretionary order that has been exercised.
Yes, yes. What is the counsel? Just take.
Yes, now it is in argument stage, my lord, there.
Yes, Mr. Thakkar.
Yes, my lords. My lords, in the first instance, let me just state what is the law on stay applications. And this is a law which, my lords, is followed in all jurisdictions which are revenue jurisdictions, namely, my lords, Central Excise Act, Customs Act, Income Tax Act, and my lords, erstwhile FERA, now FEMA. The, my lords, issue on stay, and there are 3 elements which actually need to be, my lords, satisfied. One is prima facie case, second is undue hardship, and the third would be, my lords, balance of convenience. These are 3 that need to be demonstrated. Prima facie case, my lords, obviously is that when on the face of it, if the appellate authority comes to a conclusion, on the face of it, as my lords also what the Supreme Court says, that there is actually a case made out, then, my lords, the tribunal concerned will take that into consideration and decide the matter accordingly. Undue hardship, my lords, is not just financial hardship, which is what the Supreme Court actually, my lords, says. undue hardship will be something more than financial hardship, and therefore, my lords, as what fell from your lordships as well, I will need to demonstrate that there is indeed undue hardship. Balance of convenience, my lords, actually would follow the first two elements. If there is prima facie case, if there is undue hardship, then, my lords, balance of convenience is certainly in my favor. And therefore, my lords, it would be my respectful submission that the tribunal had correctly decided, and therefore your lordships ought not to, my lords, interfere with this order. Now, my lords, before I go into the law, because, my lords, as what has been shown to your lordships is the decision in Manotosh Saha. Manotosh Saha, my lords, if your lordships are to see paragraph 16, the Honorable Supreme Court, my lords, relies upon the decision in case of Benara Valves versus Commissioner of Central Excise and another, which is 2006 decision, 13 SCC 347. That is, my lords, to be found at paragraph 16 of the decision that has been handed over by my learned friend. This decision, my lords, has been a subject matter of interpretation by various courts, including your lordship's court. And I will therefore, my lords, demonstrate how Manotosh Saha, which relies upon Benara Valves, and thereafter, my lords, all the decisions of various courts, how they have interpreted the term undue
Three more
hardship.
decisions are there. I will finish it and I think.
Let him complete it.
Please.
Now, my lords, before I do that, before I go to the law, allow me, my lords, very quickly to demonstrate that I had a prima facie case, because, my lords, my learned friend has not addressed that issue at all. And the tribunal, my lords, goes into the question of whether I had a prima facie case or not, and thereafter considers the question of undue hardship. Tribunal has considered both. Very quickly, my lords, what was the dispute? I, my lords, had established myself in 2005. I had, my lords, at that relevant point in time, entered into a contract with one of my subsidiaries, which was basically a distribution agreement. That distribution agreement, my lords, required me to sell what is understood as an AdWord program. For the purposes of distribution of that AdWord program, I was required to make certain payments to my subsidiary in Ireland. The second transaction was a transaction where I had imported certain goods for which also, my lords, payments were to be made. All of this happened between the period 2006 to 2009. Therefore, the period involved was 2006 to 2009. The amount that my learned friend is talking about, my lords, which is 363 crores, which was actually supposed to be repatriated by my client, was supposed to be repatriated between these three periods, 2006 to 2009. During those periods, my lords, there was investigation which was commenced by the Income Tax Department and investigation commenced by the Service Tax Department. The Service Tax Department, my lords, obviously said that what I'm providing is a service, despite the fact that I pleaded that it is actually a case of service relating to export and therefore non-taxable. They did not agree. They asked me to deposit monies. Therefore, my lords, under both investigations, namely in income tax as well as service tax, my lords, I was required to deposit huge amount of money, which I actually deposited with them. So I was left with no money to repatriate to my subsidiary outside the country with who I had the distributors agreement. I, my lords, on my own, when the income tax, my lords, lifted that sanction and the service tax also lifted the sanction and the monies came back to me in 2011 on my own, not at anyone's behest, not under any investigation by the ED, but on my own, I go to what is understood under FEMA as my authorized bank to request them to allow me to repatriate the sum. Your lordships also make a note that for all these years, the amounts were lying in my current account, meaning thereby, my lords, your lordships are aware, if the amount is lying in my current account as a business, I am not allowed to earn any interest by the bank. So I'm not earning any interest. There is no benefit that accrues to me. The money lies in the bank and I have not utilized the money. It was there in the bank for all these years. Therefore, my lords, when I went to my AD bank, I said, look, I have done nothing with the money. I could not utilize them. I could not do anything with the money, could not repatriate for the following three reasons. One was income tax, second was service tax, and the third was that after everything happened, I needed to reconcile. All of that is now done. So please allow me to repatriate. In my respectful submission, my lord, they should have allowed me to repatriate because there is a master circular, and I will shortly show that to your lordships. Under the master circular, which has been issued under section 5 of FEMA, which is provision which deals with current account transactions. And just to tell your lordships, there is under section 5 a current account transaction, and under section 6 a capital account transaction. Current account transactions are transactions where I import certain services or goods for which I have to make the payment. Those would be categorized as current account transactions. Capital account transactions, on the other hand, would be anything. Assume for a moment that an investment is to be made into India, into a telecom sector. Then that how the investment has to come, that will come under the directions of the Reserve Bank of India, and for that a separate circular is issued. So those are categorized as capital account transactions. My transaction is a transaction of current account. Under current account transaction section 5, RBI has issued a circular. Under that circular, and since I am on that circular, may I request your lordships to kindly have a look at the circular. It is to be found in a convenience compilation which I have filed with your lordships court at page number 48. Your lordships have that, notes? Page number 48. Page number 48. Now, your lordships will kindly see, this is a circular of July 1, 2014. And your lordships will take it from me, unless my learned friend can show it otherwise. This circular also applies for the period 2006-2009, because identically, these circulars have continued. They have not changed over a period of time vis-a-vis the issue which is at hand. Now, kindly see, under this circular, it begins by saying import of goods and services into India is being allowed in terms of section 5 of the Foreign Exchange Management Act 1999, read with notification dated 3rd May 2000, Foreign Exchange Management Current Account Rules 2000 as amended from time to time. And this master circular, paragraph 2 says, consolidates the existing instruction on the subject of import of goods and services at one place. Now, kindly see, page number 51. Serial number B5. Time limit for settlement of import payments. Time limit for normal imports. Roman 1. In terms of the extant regulations, remittances against imports should be completed not later than 6 months from the date of shipment, except in cases where the amounts are withheld towards guarantee of performance, etc. Roman 2. AD category 1 bank may permit settlement of import dues delayed due to disputes, financial difficulties, etc. Interest in respect of delayed payments, nuisance bills or overdue interest for a period less than 3 years from the date of shipment may be permitted in terms of directions in para C.2 of section 3 below. Section 3 below that your lordships will kindly see. And I need not trouble your lordships with it. I only need to tell your lordships that the requirement under section 3 is that they need to verify the genuineness of the reasons that I have given. That is what they need to do. Now, under the FEMA Act, please see section 10. Section 10 under FEMA Act. Section 10 is establishment of what is understood an authorized person. Who is an authorized person? And I would request your lordships then to see section 11. But I may quickly read only the opening part of section 10. The Reserve Bank may, on an application made to it in this behalf, authorize any person to be known as authorized person to deal in foreign exchange or in foreign securities as an authorized dealer, money changer, or offshore banking unit, or in any other manner as it deems fit. So therefore, there are, and your lordships are
probably aware, my lord, there are many money changes in the market. They are also to be authorized under Section 10. Similarly, a bank to become an authorized dealer also needs to be authorized under Section 10 by RBI. Now, my lord, Section 11. Reserve Bank's powers to issue directions to authorized person. The Reserve Bank may, for the purpose of securing compliance with the provisions of this Act and any rules, regulations, notifications, or directions made thereunder, give to the authorized person any direction in regard to making payment or doing or desist from doing any act relating to foreign exchange or foreign security. The Reserve Bank may, for the purposes of ensuring the compliance with the provisions of this Act, or any rule, regulation, notification, direction, or order made thereunder, direct any authorized person to furnish such instruction in such manner as it deems fit. Where any authorized person contravenes, because I am not concerned with that, because that is a contravention by the authorized dealer himself. What we are concerned with is 11.1 and 11.2, whereby Reserve Bank can direct the authorized person to produce any records which are relevant for the purpose or its purposes under any investigation by it. Now, kindly see, in this connection, when I made this request to the authorized dealer, I will show just one such request that I have made. Your lordships will kindly see page number 130, Exhibit O of the of a compilation of documents, a separate compilation of documents, because my learned friend has not given any documents. I am producing a compilation of documents which was available with the appellate court.
Which
kindly
page?
see that. Page 130, Exhibit O.
Is it part page?
130, 130.
No, is it part of this convenience file?
No, there's a separate compilation of documents. There were two compilations.
Yes.
No, I would request your lordships also to keep this compilation, because the decisions are there, that I will show to your lordships. But before that, if I can just show this. Now, page 130, if your lordships have that,
Just show us that. Just 1 minute, Mr. Tucker.
Yes,
Compilation of documents.
Oh, we got this. Now they have filed. You are filing it.
Oh,
Manoj, I'm sorry, we filed it, Manoj. I'm not sure if it's not there in the file. These are office copies, Manoj. Extra copies and office copies of it.
You should. When did you file it? You should follow it up. It's there on record or not? Not like this, you know. It should be part of the record. We don't want something which is not part of the record. You will file it during the course of the day, e-filing today.
Yes, sir. Yes.
My apologies, Manoj.
Is it there? Oh, then we are, sir, our mistake. Our mistake. Just give it to back. Is it only one file or the other? Yes, yes, Mr. Tucker.
Yes, Manoj. Because this is a letter which, upon my request, the AD Bank, this is my letter to the AD Bank, I'm sorry, at page 130, which is 1st March 2011. I write to the manager Citibank, which is the AD Bank in this case. Subject your lordships will see is intercompany payments. And there, my lords, your lordships will see, I've said that we have received material from our parent group companies from time to time to run our operation in India. We have to pay these amounts against those purchases, namely to Google Link to settle our intercompany balance. Please find the list below for the payment to be made to Google Link against the material we have received from them. These payments are outstanding for more than 3 years. We could not settle this balance earlier than this, as we had some reconciliations to be completed, and also we were waiting for some clarification from these entities. We have completed the said reconciliation and are ready to make these payments. And your lordships will see the last sentence there. We hereby confirm that we are paying only the principal amount and not paying any interest on the same. Over the page, at page 131.
This you are saying that you have a prima facie case.
Yes, yes. Please.
That's the endeavor.
Yes, the endeavor to demonstrate that I have a prima facie case.
Yes.
And before I show the next page, your lordships will also kindly see page number 29 of this compilation. which is a letter dated 25th March 2012.
Hmm.
Says Exhibit D.
Exhibit D. This letter, your lordships will see, is towards, the very first line makes it clear, this was towards distribution fee. So as I told your lordships, there was distribution fee and then there were imports for which payments were to be made. The first letter was vis-a-vis the import payments. This letter is vis-a-vis the distribution payments. And your lordship
So
will
this is regarding that, you know, you had that advert program.
Yes, my lords. Advert program and the distribution of that advert program, I was required to pay distribution fee to my counterpart. And this is payment towards the distributorship fee.
What do you mean by distribution fee?
Because what happens is that advert program, my lords, is a program basis which, my lords, certain, so those businesses which are interested in.
We know that advert program, that search word.
Yes, my lords, your lordships are right. Search word. So therefore, my lords, towards that, because I'm an Indian entity, I'm only licensed by them, my lords, for the purposes of for sales.
Okay.
Towards that, my lords, I have to make payment to them because, my lords, they have given me this benefit. So whatever revenues are earned, part of it, my lords, as distribution fee needs to be paid to them, to Google Ireland.
No, but the advert program is basically run by the Ireland.
Yes, my lords.
From Ireland.
Actually run by Google Inc. US, which has in turn, my lords, its subsidiary in Ireland. It has, my lords, given it to a subsidiary in Ireland. Subsidiary in Ireland.
From subsidiary, you got it.
Yes.
Now you are operating that advert program in India.
Yes, my lords.
So
Yes.
whatever revenues you generate through advert, you are sending it back to Ireland.
A part of it as distributor fee is sent to them.
Okay.
Under the program, under the distribution agreement. That agreement also, my lords, I have annexed in this, in case if your lordships want to see it. It is there in the compilation.
Yes.
So, my lords, this letter, your lordships will see is towards the distribution fee. Here again, your lordships will see the three reasons that I have given for not having made the payment. One was intercompany reconciliation, which is serial number 1. 2, my lords, were tax assessments. And 3 was, my lords, eligibility of service tax, eligibility of service tax exemption, actually. Then your lordships will see the last sentence there again. We hereby confirm that we are only paying the principal amount and not paying any interest on the same. Further, this amount was not utilized by us for any other purpose and was part of our bank balance. Now, my lords,
Mr. Tucker,
yes,
just only sorry to interrupt you.
Yes, my lords.
Now, what is the basis for them to impose penalty?
No basis whatsoever. I have explained.
No, is it their case, according to you, that the interest component has been retained, not paid, because of which the penalty would endure?
Lords, in fact, all the more reason no, because if there is no interest payment that I have made, and that is the case that they want to run against me. The case is, by keeping the money in India for 3 years and more, I have actually, my lords, converted what was otherwise import payment into what is understood as ECB, external commercial borrowing. If it was, and this is my case, if it was external commercial borrowing, I would have paid interest, but I have not paid interest. And that is exactly what I told my AD bank. That is exactly what the AD bank communicated to Reserve Bank when Reserve Bank asked this question. And under section 10, Reserve Bank, and which is what I wanted to show to your lordships, why I'm saying, lords, the tribunal comes to a conclusion that I have a prima facie case. Kindly see the next letter, my lords. I only need to show 3 more letters, my lords, not more.
Yes.
Please see, AD bank writes to...
Which page? Which page?
I'm sorry. Page number 30, Exhibit F.
Yes.
This is a letter, my lords, which is written on 5th of February 2013 to the Reserve Bank of India by Citibank.
Hmm.
And my lords, they refer to my letter, they refer to their Reserve Bank's letter, reference so-and-so, email dated 11th October 2012 for the caption subject. In this regard, kindly find below the submission responses as provided by to us by Google Private Limited. 1, reason for delay in payment of distribution fee. Whatever reasons I communicated to the AD bank, they communicated further to Reserve Bank of India. Then serial number 2, reconciliation, and serial number 3, specific undertaking from the company that the tax assessment was to be completed. And then the last sentence there, we hope the above addresses your queries. We shall be glad to provide any further information required by your good self. Request you to kindly consider the application and accord your approval. And your lordships would recall that under section 10, all such things which are required to be done for the purposes of compliance of the act and the rules and the regulation, Reserve Bank will give those compliances and regulations. It will enforce it under section 10. Now kindly see a letter at Exhibit G written by Reserve Bank on 10th of April 2013, which is at page number 31. They say, paragraph 2, in this connection, and this letter is for distribution fee. In this connection, you are advised to submit the following clarification to examine your request further. Whether the AD bank is satisfied by verification of documents if necessary about the genuineness of the reasons adduced for the delay in making the remittance. Whether the income tax and service tax departments have given their clearance from the tax dues angle. Whether there was any pecuniary gain by the company due to interest rate fluctuation on account of the delay in making the remittance. So 3 things that they wanted. This, I have provided CS certificates to them. They have looked at my documents and I don't need to trouble your lordships with that. But straight away, if your lordships will kindly now see page number 126, Exhibit K. This is a letter by the Reserve Bank of India. And please see what it says. The Deputy General Manager, Reserve Bank of India. Approval for remittance of distribution fee for invoice more than 3 years. Please refer to your letter number so-and-so dated so-and-so on the caption subject. In this connection, you may grant permission from FEMA angle, and I would request your lordships to kindly make a note of it. Because what is the FEMA angle? Is it converted into ECB, or am I yet within the law seeking now the repatriation, and should the repatriation happen without any problem? They say in this connection, you may grant permission from FEMA angle to Google Online India Private Limited to remit 363 crores to Google Ireland in respect of distribution fee payable and reimbursement of expenses as per Google Advert Program Distribution Agreement dated December 12, 2006. This was written by the manager, Reserve Bank of India. Over the page, at page 127, page 127, Reserve Bank of India, the manager, then writes to the AD bank and says, in this connection, we advise that you may permit the remittance of 363 crores on behalf of Google India Private Limited to Google Ireland in respect of distribution fee payable and reimbursement of expenses as per Google Advert Program dated 12th December 2005. Para 2, or rather 3. This communication is issued from foreign exchange angle under the provisions of FEMA and should not be construed to convey the approval by any other statutory authority or government under any other law / regulation. If further approval or permission is required from the other regulatory authority or government under relevant laws and regulation, the applicant should take whatever necessary action that he is required to take. So therefore, from FEMA angle, there is no issue, because Reserve Bank of India, which is the authority under section 10, says that I grant you permission from FEMA angle. Therefore, there is no issue. The tribunal, now please come to the decision of the tribunal. In the first instance, I must also tell your lordships, they thereafter issue a show cause notice. I replied to the show cause notice, and in this connection appear before the special director who is supposed to within the act pass an adjudication order. Your lordships will kindly make a note of it.
But tell us, Mr. Thakkar.
Yes, my lords.
This letter at 127 is only to remit the amount, no?
But my lords, from FEMA angle. Therefore, my lords,
you're
yes.
right.
Yes.
This communication is issued from the foreign exchange single. See, why is
Yes.
the permission of Reserve Bank of India is required for remittance?
Because it is not required otherwise. But, my lords,
But why did they actually permit you when it is not required?
because, my lord, they wanted to understand if my reasons were genuine. Your lordships would recall, my lords, if your lordships were to go back to the circular, master circular, they are supposed to verify the genuineness of my difficulty and my request. If they are, my lords, if they are okay with the genuineness, if they are convinced about the genuineness, thereafter they will grant their permission. That is the reason, my lord, they grant that permission under section
No,
10.
tell us, suppose on your own you want to remit the amount, you could have done it without the approval of RBI.
Within 6 months, my lords. Within 6
Within
months,
6
I have
months,
done
you
it.
could have done it. Very
Yes,
well.
yes,
Now, very well. No, 6 months have gone.
yes,
Now you have completed 3 years, the money has not gone back.
yes, my lords.
Okay. Now the issue would come whether this now you can be permitted to send it back.
Yes, my lords.
Dehors the effect of not remitting it within 6 months, but beyond 6 months, even till 3 years, has not been dealt with in this letter.
Because it has been, because I'll tell your lordships how. Reserve Bank of India will not grant me any permission. So what Reserve Bank of India would have done, if it would have found that my request was not genuine, it would immediately, my lords, refer my matter to Enforcement Directorate. Because then, my lords, what it becomes is, it becomes what is understood as an enforcement case.
Okay.
But because Reserve Bank of India wanted to understand two things, my lords, your lordships, you go back to that letter of Reserve Bank of India, where they ask my AD bank to confirm two things. One, whether my request is genuine, and two, if I have made any pecuniary gain, and which is the key. Because if the money remains with me over here, am I converting it into what is understood as ECB? In short, my lords, ECB has it becomes a capital account transaction. It no more remains a current account transaction. If I was to borrow money from outside India, which is nothing but ECB, what I am required to do is that I would require permission from RBI.
That's right.
I have not sought any permission.
You
I
did
have
not have.
in the guise. So assume for a moment, my lords, that there were no genuine reasons with me. And
Yeah.
I was to retain this money in India, use it at my, my lords, will and fancy, and then, my lords, make money out of this. And then one fine day go back to RBI and say, allow me to repatriate. They would say, I'm
Yes.
sorry, I will not. Because you have made money, you have converted into what was a current account transaction into a capital account transaction.
That's right.
But that is not the situation. And that is the reason they ask for two things: genuineness, and second, my lords, whether I have made any money out of it. On both, my AD bank tells them that it has not happened, and that is the only reason they give permission.
Tell us one thing.
Yes, my lords.
If the money has not gone within 6 months, but
Yes,
went much after that, like in this case, maybe with the permission of RBI, possibly you would argue, you would say that there were no preconditions or any conditions attached to it by the RBI.
Absolutely, my lords. In fact,
but would that mean that suppose in a given case, if it was not done in 6 months, anything beyond 6 months would entail a penalty automatically?
it would not, my lords. It would not entail a penalty, because even then, Reserve Bank of India, my lords, I would either the AD bank can do it. Your lordships saw the circular that under B5, as I showed to your lordships as I read out, the AD bank itself can grant me the permission. And if it goes beyond 3 years, then AD bank will go back to RBI. What would AD bank, my lords, at that point in time see? If your lordships were to go back to the master circular, AD bank is also required to see whether my request for repatriation beyond 6 months is genuine or not. If it is genuine, it does not even need to go to, my lords, Reserve Bank of India. It will on its own grant me permission and I will repatriate. There is no enforcement case made out. However, if it finds even within, my lords, 3 years and the jurisdiction that the AD bank has, which is 6 months to 3 years, if it was to find that my reasons were not genuine, it will have to report to RBI, and RBI will in turn report it to Enforcement Directorate for the purposes of an enforcement case.
Okay.
Which is the reason I'm saying, which is the reason, my lords, I'm reiterating this, that if it was an enforcement case, RBI would have referred it to ED, but RBI does not do it. RBI, in fact, grants permission under FEMA angle. That is the point. That when they say so, that I am only granting permission under FEMA angle because FEMA is my prerogative. any other law, if the applicant has to fulfill, that the applicant will go and seek those permissions. But in short, my lords, I was not required to seek any further permission. I was not required to do anything beyond this. And this was the only thing that I was required to do. Now, my lords,
Let us see under which provision they are within their rights to impose penalty.
yes. Yes, my lords. Under FEMA, section 13. And in fact, my lords, I'm obliged to know that your lordships asked this question. Section 13, because it should make things clear now.
This is the charging provision.
Yes, my lords. Penalty, this is the charging provision.
Yes.
If any person contravenes any provisions of this act or contravenes any rule, regulation, notification, direction, or order issued in exercise of the powers
You said
under
which section, Mr. Tucker?
I'm sorry, my lords, section 13. 13.
Yes, yes, yes.
Yes. If any person contravenes any provisions of this act or contravenes any rule, regulation, notification, direction, or order issued in exercise of the powers under this act, or contravenes any conditions subject to which an authorization is issued by Reserve Bank, he shall upon adjudication be liable to a penalty up to thrice the sum involved in such contravention, which where such amount is quantifiable, or up to 2 lakh rupees where the amount is not quantifiable, and where such contravention is a continuing one, further penalty which may extend to 5,000 rupees for every day after the first day during which the contravention continues. This is what would be relevant, my lords, for the purposes of what your lordships are asking me. Therefore, my lords, if I have contravened any of the provisions of the act or rule, regulation, notification, direction, or order issued in exercise of the powers under this act, or contravene any condition subject to which an authorization is issued by Reserve Bank of India, then, my lords, I am liable for penalty. Now, my lords, kindly see who is the nodal agency for the purposes of making any decision under this act. It is the Reserve Bank of India, because Reserve Bank of India decides whether a amount is a current account amount which would be a current account transaction or a capital account transaction. Whether, my lords, the money which is kept in India, does it become an ECB, which is external commercial borrowing, or remains an import payment which was supposed to be repatriated? Therefore, my lord, that decision has to be made by Reserve Bank of India in exercise of its powers under section 10. Now, if Reserve Bank of India within its powers believes that I have not contravened anything, it can grant me a permission, because that prerogative is the prerogative of Reserve Bank of India and Reserve Bank of India alone. However, if Reserve Bank of India believes,
where is that circular which says within 6 months you have to repatriate?
Yes, your lordships will kindly go back to the
Regulation
convenient
53.
compilation which I was showing to your lordships.
Which page, Mr. Tucker?
Yes, Manoj. Page number 48 of the convenience compilation. Earlier
Yes, yes.
Page number 40. This is the master circular. And now, Manoj, kindly see page number 51. Sorry, 51. B5, paragraph B5.
Yeah.
Roman 1.
Regulation emittance against import should be completed not less than 7 from the date of shipment, except means for withheld towards guarantee of performance, etc.
In fact, my lords, we have moved ahead from foreign exchange regulation to foreign exchange management. Lords, your lordships, lords are aware that foreign exchange regulation had stringent conditions. To that, we are now in foreign exchange management, where the AD Bank, otherwise, my lords, under Foreign Exchange Regulation Act, the AD Bank did not have the power to even that condone 6 months to 3 years. I had to go to Reserve Bank.
Just read this B 5.2.
Yes, my lords. Deferred payment arrangements, including suppliers and buyers credit. My lords, it does not apply, because this is suppliers or buyers credit. This has nothing to do with our case at all. The case
buyer is the buyer who is placed outside.
No, my lords. Buyer is the buyer who's placed here. supplier is so Manoj, this is a case
Okay.
of this would become a case of bias credit if at all. But this is not a case of bias credit.
Regulation 5(3), my lord, of the act. It is on the point.
Yes. Then 3 years are treated as trade credits for which the procedural guidelines laid down in Master Circular for external commercial borrowing and trade credits may be followed.
Yes, yes. So the question is this trade credit at all or not? That, Milods, B 5.1, as I showed to your lordships, Roman 1 and Roman 2, allows one, the AD bank within 6 or rather between 6 months to 3 years for repatriation, which means, Milods, mine is not the first case where, Milod, there is a delay in payment, in repatriation of payment. Repatriation of payment is a common thing. And therefore, there has to be some mechanism by which, Milods, the AD bank in itself could have allowed the repatriation of payment. And that is the reason Master Circular has been brought in to ease the trade's difficulty in repatriation of payment. So therefore, under B 5.1 Roman 2, any amount that is to be repatriated, albeit it is delayed, that delayed repatriation, if it is between 6 months to 3 years, can be allowed by AD bank itself. And in this case, my payment of 2009 could have been allowed by AD bank. Because 2011, when I went to them, I was within the 3-year period. They could have done it. However, because the period was ranging from 2006 to 2009, they actually went back to Reserve Bank of India because a large part of my payment was beyond 3 years. So therefore, if it is beyond 3 years, the permission to grant such a repatriation would lie only with Reserve Bank of India. Had Reserve Bank of India not granted me this permission, it would have converted into what is understood as ECB. But that the Reserve Bank has not allowed. Today, Manoj, and that was my submission before the tribunal, that the ED has jumped the gun because RBI has not come to them to say that look here, while I grant them permission, but this is nothing but ECB. No, RBI in fact goes to AD bank to ask if I have got any benefit out of it. Have I earned any interest out of it? Have I earned out of interest fluctuation? If the answer to all of that is no, then this is not ECB. That is the reason they grant me permission from FEMA angle. There was no other reason for them to do that and not go to ED. They would have immediately stopped and they would have asked ED to step in. They did none of that. In fact, Manoj, the ED writes to the AD bank and ED asks this question of them. The adjudicating authority, Manoj, records this fact that the ED had gone to the AD bank to ask if RBI had granted them permission, and AD bank confirmed to them that permission was granted. Despite all of that, they, Manoj, jumped the gun and they, Manoj, issue the show cause notice. Now, Manoj, two submissions. One is that when they issue the show cause notice and I make my submission before them, they take 2 years to pass an order. In between that time, between the time that I appear before them and an order is passed, plus 2 years is passed, and the submissions that I've made are completely diluted. They don't go into it. In fact, that I will show to your lordship's decision of the Honorable Supreme Court under Excise and Customs and numerous such orders. I will show only 2 of them. Numerous such orders where the Supreme Court says that if an adjudicating authority or an appellate authority is to pass an order, it should do so within a reasonable time. And that reasonable time, even 9-month period, I will show to your lordship. Kindly see a decision.
But Mr. Thakkar,
yes,
what is permissible under the provisions of this master circular is something which can take place between 6 months, above 6 months and 3 years, less than 3 years.
It can take place even beyond 3 years, but that beyond 3 years can only be with permission of RBI.
How do we get that?
Because the master circular limits it to 6 months to 3 years.
That's right. That's right.
It does not. Otherwise, what would have happened is.
Otherwise, so you can say, since this is a master circular issued by the Reserve Bank of India, they have limited it from 6 months to 3 years.
Absolutely.
Anything beyond 3 years, RBI.
Absolutely. Absolutely. That is the reason AD Bank goes to RBI. Otherwise, there was no reason for them to have gone to RBI.
Now, where is the penalty clause?
Section
Penalty
13.
clause is none. No precondition attached by the RBI.
No precondition attachments. No precondition attached. Nothing. In fact, Milods, if they grant me permission from FEMA angle, what would it mean, Milods? I ask myself this question. From FEMA angle, as your lordship saw, section 10 read with section 13. Section 10, if your lordships were to go back to section 10 for a moment, or sorry, 11. 11. Section 11 says, Reserve Bank may, for the purpose of securing compliance with the provisions of this Act and of any rules, regulation, notification, or directions made thereunder, give to the authorized person any direction in regard to making of payment or doing or desist from doing any act relating to foreign exchange or foreign security. That is the direction that RBI can give to the authorized bank. In this case, authorized bank is given direction by RBI, but those directions that are given provided AD bank is able to give reasons, and those reasons are genuine and verifiable reasons, and whether any interest I have earned any money, anything untoward out of the 363 crore which I was to repatriate outside the country. Now please see penalty clause under section 13. Section 13 says, if any person contravenes any provision of this act or contravenes any rules, regulation, notification, direction, or order issued in exercise of the powers under this act, or contravenes any conditions subject to which an authorization is issued by Reserve Bank of India, he shall be liable to a penalty. In my case, when Reserve Bank of India issues an authorization, it does not require payment of any penalty at all.
But tell us one thing. What is otherwise the stand of RBI on this?
Routinely, payments are allowed to be made delayed. And like I said, trade payments can be delayed for genuine reason.
Oh.
The question is my reason genuine or not? That is what needs to be seen. And
but this is otherwise, Mr. Thakkar, this is otherwise on a merit of the penalty itself.
I am only trying to demonstrate that the tribunal, when it considers, question is that does it find a prima facie case or not? It has found a prima facie case. All I'm trying to demonstrate before your lordships is that it is not as if that I'm trying to run away from the merits of the matter. In fact, I am crying hoarse. I am telling them, please come. The tribunal wants to hear us finally dispose of the appeal. They don't want to do it. They continue to take adjournment there. For the last 1 year, they've been seeking adjournment before the tribunal on the premise that the matter is pending before your lordships on a stay order. And the tribunal comes to a conclusion on a prima facie case, and the tribunal has considered these aspects. Your lordships will kindly see the impugned order for a moment. For a moment, your lordships will kindly go to the impugned order and the finding there. Page 21 of the appeal memorandum is the impugned order. The findings begin at page 26, para 70.
Yes.
Prima facie, I am of the view that since nothing contrary has been established by the respondent in its investigation, therefore it is contended on behalf of the appellant that once the permission has been granted by RBI, the delay stood regularized and there was no violation of the provisions of FEMA. At this stage, the presumption is in favor of the appellant that RBI must have been satisfied while condoning the delay. Counsel for the respondent says that there were no genuine reasons for delay beyond a period of 6 months. Counsel has referred to para 7.11 of the impugned order in support of her submission. The reliance is placed on para A12(1) of APDR, that is another circular 9 of 2000, which is, if I may just tell your lordships without showing the circular, that is the capital account transaction circular, which would have said that this is nothing but ECB. That was a reliance placed by the respondents before the tribunal. Now please see para 20. The appellants have prima facie demonstrated that there have been no violation of the provisions of FEMA, the rules, regulations, and the master circular on import. Without prejudice to any of the aforesaid and assuming without admitting that there was a violation, even then the RBI regularized the same by granting the permissions to settle the dues specifically from FEMA angle. The appellant has also been able to demonstrate the factual conditions which led to the delay in the settlement of import dues. The RBI letter expressly states that the permission was issued from foreign exchange angle under FEMA. The limitation of the permission was only in respect of any other applicable laws other than FEMA. The respondent is admittedly not seeking to impose penalty for alleged violation of any other law. In view of the aforesaid, the contention of the respondent, especially at para 16, are unsustainable. In this regard, submission of the appellants in their appeal stay application and the common synopsis are reiterated. Prima facie, I am of the view that the respondent has no justification to reinterpret the terms of the agreement between Google Ireland and Google India.
Okay, it's all. Now,
Yes.
Mr. Thakkar, tell us one thing.
Yes, Manoj.
There is, rightly or wrongly, there is a penalty.
Yes, Manoj.
Now, today the issue is only of a pre-deposit that whether it need to be made subject for hearing the appeal.
Yes, Manoj.
Now, the question would be this: where is that element of prima facie under this provision of section 19? That's one. Very well. This is only to put it because the way the section has been framed, it says, see, unlike 39(1) and 2, when we are considering on a prima facie or in balance of convenience, irreparable loss, all those things, would that feature really fit in section 19? Or section 19, rightly or wrongly, there is a penalty. Before you or when you undertake the process of appeal, you need to pre-deposit this. This is sort of a mandatory provision. How much should be there? That is left to the discretion of the tribunal. What do you have to say?
Yes. Therefore, Manoj, your lordships are referring to the proviso, section 19 proviso, which talks about undue hardship. And your lordship's question to me is that if the word prima facie is missing from the provision and it only relates to undue hardship, then please demonstrate that there was indeed an undue hardship. And therefore, was there a requirement for making a deposit between ₹0 to ₹6 crore as what has been imposed by the adjudicating authority?
Yes.
That is how I understand your lordship's question.
So prima facie need to not be looked into. Penalty there. This is, we are just putting it to elicit. Prima
On the
facie.
contrary, I understand, Manoj, what falls from your lordship. I completely understand. It is my submission, Manoj, that the word undue hardship, in fact, it is not hardship per se. Because it was only hardship, it would have been financial hardship. Because what is the financial hardship for me to make the payment? If undue hardship, as what the Honorable Supreme Court says, is hardship which is undue, which is over and above the normal hardship. For the purposes of considering that, the Honorable Supreme Court in the decision shown by my learned friend actually looks at two things: prima facie case and then the question of undue hardship. And that is the reason, Manoj, I also refer to paragraph 16 of that decision of Monotosh Saha, because Monotosh Saha, paragraph 16, the Honorable Supreme Court actually considers the decision of Banara Valves. And please see para 16 for a moment.
Page number 4, Manoj.
The Supreme Court says the position was highlighted in Banara Valves. The decision was rendered in relation to section 35F of Central Excise Act, where also identical stipulation exists. In fact, Manoj, in section 35F of the Central Excise Act, your lordships can take it from me, the requirement is identical, but it also says prima facie case. The question now, before your lordship, that is what your lordships have asked, does undue hardship therefore within itself encompass also prima facie case? In Monotosh Saha, while considering the proviso to section 19, the Supreme Court says a prima facie case is required to be looked into. And then what is required to be considered is undue hardship. Your lordships will kindly see in this connection a decision of the Allahabad High Court. And Manoj, I will show now the decisions of various courts.
Before that, just only one thing, Mr. Thakkar, if you have 19 for a moment, second proviso.
Yes, Manoj.
Now you are reading prima facie in second proviso.
Yes.
You have understood?
Yes, Manoj.
Provided further, just read that. Provided further that where in any particular case the appellate tribunal is of the opinion that the deposit of such penalty would cause undue hardship to such person, the appellate tribunal may dispense with such deposit subject to such conditions as it may deem fit to impose so as to safeguard the realization of the penalty.
Yes.
Okay. Now, what is being said in the context is there is a penalty imposed. You will not ask for complete deposit of complete penalty if there is a case of an undue hardship. But you would put such conditions as it may deem fit to impose so as to safeguard the realization of penalty. So
Yes.
what it
Yes.
appears is not a complete penalty which has been imposed, such penalty which you deem appropriate to ensure it, the penalty which has been imposed is safeguarded or it is
Yes.
realized if
Yes.
ultimately the appeal is decided against.
Yes.
That's the intent. Now, how do we get that? That if it is now what we are understanding you is, and that's what you are relying upon the tribunal's order, if it is a prima facie case, then the whole of the penalty need not, or any part of the penalty need not be, even if it is not a case of an undue hardship.
Yes.
Are
If
you
you're
arguing that?
Yes, yes, my lords, but I am going a little further because the tribunal does not stop at prima facie case. And I may just address the question that your lordships have put, allow me to address that first. To demonstrate undue hardship, my lords, I need not just have financial hardship and I need not have financial hardship at all. I'm going as far as saying I need not have any financial hardship at all. I could be a company which is, cash positive, so to speak.
Okay.
Therefore, the question is, I don't have any financial hardship, therefore I have no hardship per se. Now the question is, how do I demonstrate that yet if I was asked to make any deposit, it would amount to undue hardship. And undue hardship, therefore, my lords, is nothing but a facet of prima facie case. If I have a prima facie case, and yet if I'm asked to, if the tribunal comes to a positive finding of a prima facie case, and yet if I'm asked to deposit any amount or give a security, that is undue hardship. And why am I saying this, my lords? Now, please see. Because the tribunal does not stop at prima facie case. At paragraph 29 and 30 of the impugned order, at page 30, paragraph 29 and 30, your lordships will kindly see.
Yes.
Further, in the present case, the RBI specifically allowed the settlement of dues from FEMA angle, which was not the case in Telestar. It is evident that the appellant in Telestar never raised the issue of delay before either the tribunal or the High Court. Thus, there was no finding on the aforesaid aspect in the lower court's order prior to the same being considered by the Honorable Supreme Court. For the aforesaid reason, decision of Telestar has no application in the present case. In light of the prima facie case that has been made out by the appellant, and the appellant will suffer hardship if the appellant is asked to deposit the penalty amount after having gone through the facts and material placed on record, I am of the opinion that the chances of success of appeal are more than the failure of appeal, and therefore they allow. Now, therefore, the tribunal believes, and in my respectful submission, rightly so, that it is not the undue hardship here, is the fact that I have a good prima facie case. The balance of convenience is with me, and yet if I'm asked to deposit the amount, that would amount to undue hardship. How do I get to that, my lords? Please see a decision of the Allahabad High Court.
Just 1 minute, Mr. Thakkar.
Yes.
If we come back to that proviso, there are two limbs of that proviso.
Yes.
And we want to segregate those.
Yes.
Provided further where in any particular case, the appellate tribunal is of the opinion that the deposit of such penalty would cause undue hardship to such person. Okay, that's one. Then you can dispense with the complete penalty. Then it says the appellate tribunal may dispense with such deposit subject to such conditions as it may deem fit to impose so as to safeguard the realization. How would, see, when you are invoking, let's assume the tribunal has invoked this proviso and actually considering the case under the proviso, very well, it would not, if it is a case of undue hardship, it will not say complete amount. But let's assume for a moment, what you are saying is if it is a prima facie case, complete amount can also be dispensed with. Okay, complete penalty. But how would you answer the second limb
Yes.
With such, subject to such condition as it may deem fit to impose as to safeguard the realization of penalty.
Absolutely, my lords. And I'll tell your lordships how. If your lordships are with me, and I'm assuming for a moment, my lords, let me take my case at the highest and say that your lordships are with me on the prima facie case and therefore the undue hardship. Now the question that your lordships are putting to me is that yet what the tribunal has to do is that it has to impose a condition.
That's
In
right.
my respectful submission again, this subject to condition as it deems fit is not a provision which is found in FEMA alone. Identical provision is in income tax, customs, excise, and I will show that to your lordships that the courts have held that once you have demonstrated prima facie case, and yet if you are asked to deposit any amount or to give any security, it will amount to undue hardship, and therefore there is no requirement. Ultimately, it is at the discretion of the tribunal. The tribunal has absolute discretion. It says as it deems fit, subject to conditions as it deems fit. That whether it has to impose condition or not, that also is the prerogative of the tribunal. Because it's an appellate authority. It has vast powers of stay. Unlike what would happen in the current situation, assume for a moment in GST, where if the tribunal does not have the power as it used to wield earlier under the erstwhile Central Excise Act, what would happen under the erstwhile Central Excise Act is it could dispense with 100% penalty subject to such conditions as it would deem fit for the purposes of realization of the revenue. That was the condition under Central Excise Act. Now, under GST, the appellant is required to make a deposit of 10% before it can go ahead. And yet the tribunal can call for certain security for the purposes of securing the revenue. Nonetheless, I will show to your lordships, and that is what my endeavor will be now, to show to your lordships decision after decision where under various statutes.
Let's see that. Let's see that.
Yes. Kindly see, in the first instance, I am showing to your lordships a decision of the Allahabad High Court in ITC Limited. ITC Limited. My attorneys are there, they will, yes.
Yes.
Yeah. Please see paragraph number 26 at page number 6. May I read it, Manoj?
Yes, yes.
In Bongai Gaon Refinery and Petrochem versus Collector of Central Excise, the Calcutta High Court, while examining similar issue, had placed reliance upon large number of judgments and held that the phrase undue hardship would cover a case where the appellant has a strong prima facie case. The phrase also covers a situation where there is an arguable case in the appeal. If the appellate authority forms the opinion that the appellant has a strong prima facie case, it should dispense with the pre-deposit condition altogether. However, where it is of the opinion that the appellant has no arguable case, the appellate authority must safeguard the interest of the revenue, as the same also cannot be jeopardized. In Sri Krishna versus Union of India, the Delhi High Court considered the issue of dispensation of pre-deposit condition and the concept of undue hardship while considering the provisions of Section 129E of the Customs Act and Section 35 of the Central Excise Act, and held that the court, while considering the case of appellant, should examine as to whether the appellate authority or tribunal have dealt with the plea raised by the appellant before it and have considered as to whether the appellant has a prima facie case on merit. In case the appellant has a strong prima facie case, as is most likely to exonerate him from liability, and the appellate authority tribunal insists on the deposit of the amount, it would amount to undue hardship. In Hooghly Mills Company Limited versus Union of India, the Calcutta High Court again reiterated the view that if the appellant has a strong prima facie case, he is entitled to waiving the pre-deposit condition, and in the case of appellate authority insists to deposit the amount so assessed or penalty so levied, it will cause undue hardship to the assessee. While considering the case, the court placed reliance upon large number of judgments, including Tata Iron and Steel Limited versus so-and-so. Now let's kindly see 29. In ITC Limited versus Commissioner of Central Excise and Customs Appeals while examining the issue of pre-deposit under Section 35 of the Act, after considering large number of judgments of the Apex Court and various high courts, it was held as under. While considering the case of undue hardship, the authority is required to examine the prima facie on a case on merits of the dispute as well. Pleading of financial disability would not be the only consideration. Where the case is fully covered in favor of the assessee by a binding precedent like that of the judgment of the Supreme Court, jurisdictional high court or special bench of the tribunal, then to still insist upon the deposit or duty and penalty levied would certainly cause undue hardship to the assessee. Absence of the financial hardship in such a case would be no ground to decline the dispensation of pre-deposit under the proviso to Section 35F. The power to dispense with such deposit is conferred upon the authorities, has to be exercised precisely in cases like this type, and if it is not exercised under such circumstances, then this court will require it to be exercised. Such like cases where two views are possible, then the condition of pre-deposit before the appeal is heard on merits can be dispensed with. In case two views are possible on interpretation based on conflicting judgments of the tribunal or different high courts in the absence of judgment of the jurisdictional high court, then the authorities may pass the order under proviso to Section 35F of the Act, keeping in view the facts of the case at hand. Now kindly see paragraph 35. Para 35. In view of the above, the aforesaid authorities make it clear that the court should not grant interim relief stroke stay of the recovery merely by asking of a party. It has to maintain a balance between the rights of the individual and the state so far as the recovery of sovereign due is concerned. While considering the application for stay stroke waiver of a pre-deposit as required under the law, the court must apply its mind as to whether the appellant has a strong prima facie case on merits. In case it is covered by the judgment of a court stroke tribunal binding upon the appellate authority, it should apply its mind as to whether in view of the said judgment, the appellant is likely to succeed on merit. If an appellant having strong prima facie case is asked to deposit the amount of assessment so made or penalty so levied, it would cause undue hardship to him, though there may be no financial restraint on the appellant running in a good financial condition. The argument that appellant is in a good position to deposit, or if he succeeds in appeal, he will be entitled to get the refund, are not the considerations for deciding the application. The order of the appellate authority itself must show that it had applied its mind to the issue raised by the appellant and it had been considered in accordance with law. The expression undue hardship has a wider connotation as it takes within its ambit the case where the assessee is asked to deposit the amount, even if he is likely to be exonerated from the total liability on disposal of his appeal. Dispensation or deposit should also be allowed where two views are possible. While considering the application for interim relief, the court must examine all pros and cons involved in the case and further examine that in case recovery is not stayed, the right of appeal conferred by the legislature and refusal to exercise the discretionary power by the authority to stay stroke waive the pre-deposit condition would be reduced to nugatory stroke illusory. Undoubtedly, the interest of revenue cannot be jeopardized, but that does not mean that in order to protect the interest of revenue, the court or authority should exercise its duty under the law to take into consideration the rights and interest of an individual. It is also clear that before any goods could be subjected to duty, it has to be established that it has been manufactured and it is marketable to prove. Then they go into the issue on merits. And here, if I may only end this by saying that here, complete waiver, no condition, subject to no condition, complete waiver. Now, kindly see a decision by your lordship's court in case of United Telecom Limited. Versus Commissioner of Customs, Bangalore. So therefore, in a case under Section 129E of the Customs Act, your lordship will take it from me that 129E of the Customs Act, identical, that's subject to such conditions as it deems fit. The appellate authority may, on a prima facie case and an undue hardship being shown, subject to such condition as it
Where
deems.
is this? Is there any case which you have in the context of Section 19?
Monotesh Saha, the Honorable Supreme Court, while there, yes, Monotosh Saha, in fact, is in my favor. Because para 8, the Supreme Court goes into this question of Section 19. But in Monotosh Saha, in the facts of the case, Supreme Court says that, let any security be granted. But otherwise, the finding of the Supreme Court is in my favor on the conditions of Section 19. And if your lordships want, my lords, I can look for other decisions and give it. But Monotosh Saha itself is very clear. And as I said, Monotosh Saha relies upon.
Let's see this judgment.
Yes, yes. Just one thing so that your lordships are clear on this, my lords.
Yes.
Monotosh Saha itself relies upon Banara Wells. And Banara Wells was under Section 35F of the Central Excise Act.
Yeah, right.
And there the Supreme Court says that the provisions are identical.
Okay.
And as I said, my lords, 129E of the Customs Act, your lordships will see, is identical again. It's the same. Now, kindly see paragraph 5 of this decision of your lordships court, where, my lords, and your lordships will skip the first 15 lines, because, my lord, that is on what it only goes to say that the issue was covered by the decision of the Supreme Court in a case called Preamble Industries. Now, I am reading from the sentence beginning with the words, though the word undue hardship is not used. Your lordships have that, my lords?
Paragraph 5.
Paragraph 5, my lords, almost 10 lines from the top. Though the word undue hardship is not used. I'm reading from there.
Yes.
Though the word undue hardship is not used, in the facts of the case, it constitutes undue hardship. And the learned single judge committed an error in not properly appreciating the circumstances under which the said waiver is sought. And therefore, he submitted that the order of the learned single judge was required to be interfered with. Further, he points out that in a similar question which had arisen for consideration before the Bombay High Court, it upheld the contention of the assessee and granted the benefit. The revenue challenged the same before the Apex Court. The Apex Court declined to entertain the appeal on the ground that in the facts, they see no reason to interfere in the matter which is reported in 2007 211 ELT A45 Supreme Court. By relying on this judgment, the tribunal has waived the pre-deposit. In other words, if the said judgment of the Supreme Court is applicable to the facts of this case, there is no liability to pay tax. When there is no liability to pay tax, merely because the authorities took a contrary view in an appeal, if the pre-deposit is insisted upon, it would not only cause undue hardship, but would also cause untold misery to the appellant. In that view of the matter, and in the facts of this case, we are satisfied that the order passed by the tribunal granting complete waiver of pre-deposit was legal and justified. It ought not to have been interfered with by the learned single judge under 226 of the Constitution. In result, the order of the learned single judge cannot be sustained. Now, my lords, since they rely upon this decision of the Honorable Bombay High Court, may I just show this to your lordships, because that decision is telling. That is, my lords, decision of CH Limited versus Union of India. Paragraph 13 is what I'm going to refer to directly.
Yes.
While considering undue hardship, the balance sheet of a company or of an individual may be one of the relevant factors. I'm sorry, your lordships have that, Manoj?
Yes.
So while considering undue hardship, the balance sheet of a company or of an individual may be one of the relevant factors. However, at the same time, the courts cannot be oblivious to the state of economy and the need for companies to have sufficient liquidity to proceed with the business on industrial activity. I'm sorry, Manoj. Any burden by way of deposit of resources required to keep the business running may have an effect on productivity as also on employment. No doubt, these are matters which a party approaching a tribunal must be in a position to establish and cannot be based merely on whims and fancies. The economy, therefore, is another indicator which could be considered while applying the test of undue hardship. Considering the law as stated above, a duty is cast on the tribunal after it has considered whether the prima facie case has been made out while considering the issue of balance of convenience and irreparable loss and injury to examine the undue hardship as of now understood and explained by the Supreme Court in Benara Valves Limited. It is no doubt true that while considering the issue of pre-deposit, the tribunal has discretion. The application of discretion cannot be subject to any standards. It would be within the jurisdiction of the tribunal, considering the facts of each case by applying the law as declared by the Supreme Court and this court. If the party has made out a strong prima facie case, that by itself would be a strong ground in the matter of exercise of discretion as calling upon the party to deposit the amount which prima facie case is not liable to be deposited or which demand has no legs to stand upon, by itself would result in undue hardship if the party is called upon to deposit the amount. And then, my lords, therefore, your lordship will kindly see paragraph 18. In these circumstances, in our opinion, the petitioner having made out a strong prima facie case, calling upon the petitioner to deposit would occasion undue hardship. The application for waiver of pre-deposit ought to have been considered on that test. And therefore, my lords, they do not interfere with the order of the tribunal.
Yes.
So, my lords, I can, my lords, there are decisions after decisions that I can give, my lords, I can replicate it, but my lords, I need not trouble your lordships with more decisions on the subject. It is my respectful submission that I have, my lords, before the honorable tribunal, I had, my lords, two submissions to make. I had shown one that there was a gross delay in passing an order, and there are decisions of the Supreme Court and decisions of, my lords, various high courts which say that if even if the act does not provide for any time limit within which an order is to be passed, you must pass an order within a reasonable time frame. Even a 9-month delay, allow me to show, my lords, the decision in case of MCO. The Bombay High Court was considered this issue that, my lords, is a 9-month delay in adjudication, is that a gross delay, and therefore, my lords, should a order of the authority be set aside on that count. Suffices to say, my lords, in MCO, it's a 2014 decision of the Bombay High Court, confirmed by the Supreme Court thereafter. In paragraph 6, and I need not, my lords, trouble your lordships with reading of that, suffices to say that in this case, there was a 9-month delay, and the High Court comes to a conclusion that that 9-month delay, despite the fact that there is no time limit provided for adjudication, was gross delay, and they then, my lords, set aside that order.
Okay.
In my case, there was a delay of 2 years and 4 months from the date when I appeared before the authority and the order was passed. That was the first case. Yes. And the second issue was prima facie case on merits, to say that once RBI grants me the permission, no case. And therefore, my submission was, if there is prima facie case and the tribunal comes to that conclusion, then to ask me to deposit would be undue hardship, and that the tribunal, in my respectful, has considered all the submissions while passing the impugned order. So, in my respectful submission, my lords, following the decision of the Supreme Court and the various courts that I have showed your lordships, this order ought not to be interfered with.
Okay.
That's my submission.
Yes, Mr. Shetty. He says prima facie case is a case of undue hardship, and complete amount can be waived.
My case is, my lord, even if it is there, then what else? Because proviso.
How would you answer this prima facie case?
Please, my lord, even
they don't have a prima facie.
Even, my lord, my submission in, my lord, tribunal has even gone to the extent of even deciding the matter on merits also. In the name of prima facie case, my lord, the tribunal has answered delay aspect as well as the other aspect also. In fact, while considering the interim application, I will keep it as it is, my lord. The question here is,
paragraph 31 says there is a caveat. The above order shall have no bearing when the appeal will be considered on.
Now, question here is, my lord, even the proviso makes it very clear. It is an injunction, I could say, my lord, to the tribunal. You can give leniency or dispense with, subject to.
I know that's what we have asked him. He says
that is an injunction, my lord. You can waive off 100%.
Yes.
But subject to.
But how
so
would
that cannot be overcome.
Very well. So we are putting it to you.
Please.
100% waiver
Maybe it's
subject
left to the discussion is given,
right? But you
subject to
must-
undoing,
So we are asking you,
Please.
100% waiver,
please.
what else condition would come in?
But
Just give us an eventuality.
that the tribunal has to answer.
No, but see, it cannot be
No, no,
vacuum, na.
There is some purpose in putting, Mela.
You are right.
Because you,
Mr.
you have been given 100% waiver benefit. So you can't go scot-free without any condition. That is a word, because statute says it is not a decision by any even Supreme Court considers it. And even after the deposit also some amount, again, my lord, for the remaining amount, there is a condition. Honorable Supreme Court very well aware that because even prima facie case is also made out there. That is why para 8 may kindly seen, my lord. There, the first word is, it is true that on merely establishing a prima facie case, interim order of protection should not be passed.
My learned friend will read further, my lords, from the words.
No, no, I have already, in the morning, I have read it. Again, I am repeating it. That's why. Even, my lord, in all the judgments, my learned friend has quoted is in a different statute provisions, my lord. But here, my lord, specific provision in FEMA, which has been reproduced by the none other than the Honorable Supreme Court, my lord, in the order, my lord, Monotosh case. And ultimately, my lord, para 50, the another that is realization of a penalty amount to safeguard. How? Putting some condition at least, because proviso is there. There is no power granted to the tribunal, my lord, to waive off that condition. So far as pre-deposit may be subject to his satisfying about the undue hardship. Undue hardship, I am not on that. But even if it is undue hardship is pleaded and proved, then what else? That is what the proviso 2 says, subject to. It can't be read in any other manner. See, one exemption or dispensation is given subject to this. Even the next, my lord, in my citation, I have given, my lord. After that first judgment, second judgment is also there, my lord.
Which one?
Page 5, my lord.
That's right. Okay.
That is, my lord, there also, parallel 11 and 15 make it relevant.
Yes.
I will just, two significant expressions used in the provisions are undue hardship to such person and safeguard the interest of the revenue. Therefore, while dealing with the application, twin requirements of consideration of undue hardship aspect and the imposition of conditions to safeguard the interest of the revenue have to be kept in view. That is the word used, my lord. Then, my lord, as noted above, there are two important expressions in section 35 app. One is due hardship. This is a matter within the special knowledge of the applicant for waiver and has to be established by him. A mere assertion undue hardship would not be sufficient. It was noted by this court in so-and-so judgment that under Indian condition expression, that is also discussed by in the first case, my lord. Then, my lord, the 15 para. The other aspect relates to the imposition of conditions to safeguard the interest of the revenue. This is an aspect which the tribunal has to bring into. It is for the tribunal to impose such conditions as are deemed proper to safeguard the interest of the revenue. Therefore, the tribunal, while dealing with the application, has to consider material to be placed by the SSE relating to the undue hardship and also stipulate the condition required to be safeguard the interest of the revenue.
Yes.
So lastly, my lord, he shall furnish such security as may be stipulated by the tribunal. That is the even first case also the same one. The next, my lord, that is the case of assistant collector excess. In that, my lord, para 5 may be cut.
Para 5.
In page 15, man. we repeat and deprecate the practice of granting interim order, which practically give the principal relief, that is very important, sought in the petition for no better than that of a prima facie case has been made out, without being concerned about the balance of convenience, the public interest, and the host of other relevant consideration regarding the practice of some clever litigants resort to filing writ petition in faraway courts having doubtful jurisdiction. We had this to observe. That is, my lord, that has been observed, my lord. Then we have come across cases where the last parameter in that. Collection of public revenue has been seriously jeopardized, and budget of governments and local authorities, so and so and so. That has been discussed. Then last, my lord, in page 18. In the middle, my lord, we do not have the slightest doubt that the order of Solar and single judge as well as the division bench are wholly sustainable, should never been made. Even assuming that the company had established prima facie case about which we do not express any opinion. We do not think that it was a sufficient justification for granting interim orders as was done by the High Court. There was no question of any balance of convenience being in favor of the respondent company. The balance of convenience is certainly in favor of the government. The government are to run the mere bank guarantees. We notice that very often some courts act if furnishing bank guarantee would meet the ends of justice. No governmental business, or for that matter, business of any kind, can run on mere bank guarantees. Liquid cash is necessary. So that is the.
Yes. What else?
So that is why, my lord, the maximum benefit has been granted by the tribunal by weighing of the 100% pre-deposit amount. Once it applies, my lord, proviso 2, then it has to be applied fully, my lord. That is my argument.
Pardon?
Once the tribunal has applied proviso 2 of 19.1, then it has to be applied fully, not halfway. Because subject to condition, he can.
So what you say is, even in the case of undue hardship, even 100% penalty, there must be some protection. That's
after giving that, because that is a precondition, my lord.
Okay. Which are the appeals which gets covered by these arguments?
Lord, serial number 28, 29, 30, and serial number
41.
4 appeal.
So these will get covered, huh?
Please.
Yes. Yes.
You said 28.
28, 29, 30, and 41.
41.
So 3 plus 1, 4.
Yes.
Please. Please.
4, na?
Please.
4.
Okay, reserve.
Malod's much obliged. Malod's just one last thing on what my learned friend just said. Malod's, my learned friend Malod's continues to say that he has no difficulty on the finding of prima facie case, and he also assumes that Malod's there is undue hardship that I have proven. But yet, Malod's, he says that there is some safeguard of revenue, and he's read all the decisions, including the decision of the Supreme Court in Benara Wells, which was considered by various high courts. So it's my submission, Malod's, after having considered all these decisions, the various high courts have come to the conclusion on undue hardship, namely that once you have a prima facie case, and in fact, Manotosh Saha, paragraph 8, my learned friend read only, in the morning he read the whole thing, but right now, Malod, he read only the first line. The second
We will see it, Mr. Thakkar. We will see it. We'll
I am not saying, my lord, statute says.
Very well, Malod.
Just bringing it to our lordship's file.
Thank you. Reserve.
Grateful, Malod. I'm obliged.
You have to, 30, what is this impleading application? Who has filed it?
There, my lord, I have filed, my lord, that representative of the company, my lord, died. So I have made a present representative.
What is
only
that?
Only for that purpose, my lord. Because somebody has to represent me.
Propose Vivek Chabra.
Please.
What are your instructions on this?
Because Mr. Hari Raju has passed away, that's true. And because they seek to, because they asked us who would be those. So we've given him the name on that basis. So I have no difficulty.
That will help them also, my lord. Somebody should represent.
So we allow this.
Yes, my lord. Your lordship will kindly allow this.
But then have you filed any amended?
No, my lord. I will file it in me.
You will file it by tomorrow.
Tomorrow.
See, what you have to do is only this, Mr. Shetty.
Please,
Just come to page 108 of that application.
Please.
Or see the memo of parties. Let's see the memo.
No, I will make a
So just only you have to just
appeal memo, please.
memo of the appeal.
I will file.
It should be that you have to just only change the name. The designation remains the same.
No, my lords, it does not. Because no, my lords, it does not. It does not remain the same. But my lords, we've given the name. If your lordships want, my lords, I can find out
On the designation also, if you see the application.
They themselves have given that particulars.
If you see the application.
Yes.
Director and finance controller.
He
But
says
here
finance controller.
Very well, my lords, allow me to find out, my lords. I'll let my learned friend know immediately, my lords. After this, I'll let my learned friend know immediately.
Yes, just to note.
Please, if there is any changes, I will.
But we must know, because ultimately we are allowing this application. The designation remains the same, or what is the designation?
Please. They themselves have given this particular, so might be.
Just check up.
Later, if there is any
Please
changes,
let
I
us
will.
know.
Please.
Just say that this is an application filed by the appellant with the following prayer. The submission of Mr. Shetty is that as the earlier director and finance controller, Hari Raju Mahadevu has expired,
12/5/23.
on 12/5/2023.
23. Para 2 I have taken.
23, the appellant has filed this application, bringing the present incumbent on record. Bringing the present incumbent being, what is the name?
Manoj Mittal. Ma'am.
No, you say Vivek Shabra. Where is your application, Mr. Shetty? Your application is number 4/24.
Vivek Chabra, madam.
Vivek Chabra.
Proposed respondent, yes.
Vivek
Was reading.
Chabra. Full stop. Okay, for the reasons stated in the affidavit and Mr. Thakkar and then a counsel appearing for the respondent has no objection in that regard, the application is allowed, the respondent shall be impleaded, shall be represented, the respondent is Hari Raju Mahadevu. Yeah, just say that the respondent shall now be yes, so-and-so is brought on record. Yes, so-and-so, Mr. Vivek Chebra is brought on record as the respondent. As the respondent. Amended memo parties be filed by tomorrow.
Yes.
Necessary correction be also carried out in the memo of appeal. Having.
Milords, if I already have a written submission which I had pre-prepared, may I just hand it over, which will only assist?
Do that. Give it to Mr. Shetty also.
Yes, Milords, I'll do that. My attorneys are there, Milords, they'll file it, and Milords also.
Just say that the submissions on behalf of the respondent as filed in the court are taken on record in all the matters.
In all the matters, they'll cover all the 4 matters.
All the appeal, full stop. The counsel is directed to file the same through e-filing also. Within 2 days.
Yes, but
Okay.
in 3 matters, my lord, there is a IA, my lord, for condemnation of delay.
In which matter?
First 42, 43 and 44. So they have been filed, my lord, within 120 days. But in first case, my lord, 45 days delay is there.
Just.
Okay.
29, we will condone 46 days, then 39 days in item 30, 42 days in item 28, and.
No, other one is already condoned.
Which one?
41.
41 condone?
MSA 45.
Okay.
Has already
So these 3 are
Please,
Remaining, we are condoning it
please.
for the reasons stated in the affidavit, and Mr. Thakkar has no objection.
Yes.
We have heard the counsel for the parties on the appeals. Orders reserved. Okay.
Much obliged. Grateful.
Because these written submissions,
And just take this. Call the next one.
well, the written submissions,
I'll take it on record. They will file the.
will you file it in the?
You have to file
Yes.
it by tomorrow.
Yes, yes.
Thank you. Next.
Number 31. 31, Srimati Anuradharas.
Lord, I appear for the respondent in this appeal.
Have we filed that reply, Mr.
I have not filed, my lord. My submission is it may be taken along with the main argument. I would submit my oral argument on that. But I have nothing to say beyond one issue. That's all.
Just say there is no representation on behalf of the appellant. Just say re-notify. 32.
4th of March. Serial number 32, Sri Nanjanda Swami.
In this matter, my lord, the third appellant, D.T. Raju, my lord, before the trial court, my lord, he died after the award.
Who has died?
One D.T.
R1?
Raju, D.T. Raju, who is, my lord,
Where is he a party here?
one wife is made a party, the third appellant in trial court, my lord, he died, my lord, after the passing of the order. My lord, wife is made party, but two daughters are there, my lord, they are in Australia. They are not cooperating, my lord, is my humble submission.
What
Yeah.
can we do?
The only wife is there, wife, third appellant here in Malati. Sorry, Lata is a wife of D.T. Raju, my lord. She is representing the interest of D.T. Raju.
Suppose they raise an issue, the daughters.
Daughters, any share, my lord, this all court, suppose if they.
We will not take the responsibility. The responsibility has to be the counsel and the litigant to ensure that everyone comes on record. We will not.
We will take.
Do that. At the request of counsel for the appellant, re-notify. See that you have to convince them. Okay.
10-3, serial number 33, K.V. Narasimhan.
Yes.
My lord, matter was dismissed for non-prosecution, my lord, since the court fees was not paid. My lord, appellant was passed away, my lord, in the year 12th of 2023. My lord, hence court fee could not be paid in time, my lord. Now the court fees has been paid and IF for recalling has been filed, my lord.
Who appeared? Was there any appearance for the respondent?
No, my lord. Still notice has not been ordered. Even
Show me the application.
even LR applications have been filed, my lord.
There is a cross objector also. How can you say no one is appearing?
Still notice
objector. Must be the respondent, must be the cross objector. Must be, he must be, he is. Yes, this is an application. How many are there?
Was single respondent, sole respondent.
4, 5, 6 applications. These are 3 applications seeking condonation of delay in filing the application for recall of order dated 5/9/2024, comma, recall of the application, recall of order dated 5924. And
In serial
no,
number,
but tell us one thing, what is this advocate for cross objector? Why do
My-
you say in your third application?
my lord, I'm sorry, it is a serial number 33. List one, my lord.
No, your application.
Mine is one application.
We have 33.
Yes, my lord. It is the LRs of appellants, my lord.
No, you have third application under order 22 rule 3.
Yes, my lord.
This for abatement, na, setting aside.
Okay,
Yes,
cross
madam.
objector is written. Application. 22 rule 3.
Application is done. As of date.
Sure. In my application, it is appellant, my lord. I don't know. I'll cross verify.
Cross objector.
Now, whether the wife and the son have filed application,
First application is filed by wife and son, my lord.
what is the number of that application?
That is IA number 3 of 24.
Where is the 3 of 24? na?
Yes, my lord. When that application was filed, our daughter was in USA. So other application was filed, even other application is filed.
But either it is 4, 5, 6 and 0.
Typographical error.
Okay.
Oh, they have not been listed. So you have to get that 1, 2, 3 also listed. Yeah, there are 3 applications which you have filed.
Yes, my lord.
Even that is not listed.
I've checked in the afternoon, my lord. It is in the file.
No, it's not there in the file. Where is the file?
No, this is listed. 3. The 3 is here. 3 is here.
My lord, either.
5, 4.
Okay.
Why don't they show it in this? It's there in the. What is this? Where is one? I know. Where is IA number 2? When was this appeal dismissed for non-prosecution?
It was in the month of September, my lord. September, 5th of September 2024.
6 days.
But tell us, after 5th September, what have you filed?
My lord, after 5th September, my lord, this LR application and recalling application has been filed, my lord, along with the delay. And court fees has been filed and along with LR application has been filed. LR application is,
What are the numbers?
my lord, that is IA number 4, 5 and 6.
What are the earlier applications you have filed?
Prior to dismissal, my lord, I filed IA 1, 2, 3.
If prior to that you have filed dismissal applications, these applications, for what you have filed this application for bringing them on record?
Yes, my lord.
So,
What happened, my lord, on the last date of hearing when the matter was posted, at that time, our name has not been shown, my lord, hence it was not brought to our notice that matter was listed. Hence, matter got dismissed for non-prosecution. Even those IAs which we have filed, that was not put up on the file. Hence, that matter was dismissed for non-prosecution, my lord. Later, same was rectified and we filed IA for recalling application.
let's say this.
We come on record with the NOC wakalat.
I gave 1, 2, 3. Just not issued.
No.
I gave 1, 2, 3. Just say that these are the applications filed by the so and so LRs of the
Appellants.
deceased appellant who said to have expired on 21/12/2023. for the reasons stated in the affidavit in support of these applications. The delay of 73 days delay in seeking setting aside of the abatement is allowed. Affiliation disposed of. Then
There's one more application, my lord, LR, same, there's also.
stated in the application from the where sought in this is allowed, application disposed of. This is then there is another application 3. I believe this is an application under order 22-3 section 151 CPC. For the reasons stated in the affidavit in support of this application, Srimati Pushpalata and Shri Sumukh V. husband, the wife and the son of the deceased appellant are brought on record, application disposed of. Stop. Stop. Further, 3 applications have been filed by the legal heirs of the appellant, namely Srimati Pushpalata and by Pushpalata to bring on 2 for seeking condonation of delay. How much is the delay? Delay in filing the application seeking the recall of dismissal order. Dismissed dated 5/9/2024. Noting the contents of the affidavit, the delay in filing the application for recall of order dated 5/9/2024 is allowed. Application disposed of. Then IA number 5. It's an application seeking is for filing IA for recalling of the order dated 5/9/2024 for the reasons stated in the affidavit. The order dated 5/9/2024 is recalled. The appeal is restored to its original number. Application disposed of. Then this is an application under order 22-3, section 7 CPC by Miss Samiksha, said to be the daughter of the deceased appellant, for bringing her on record as LR of the appellant.
Yes, ma'am.
You are the counsel for the earlier LRs also, Pushpalata and.
Yes, ma'am.
Counsel for the appellant says she is the daughter of the late deceased appellant who could not be brought on record earlier as she is residing in US.
Yes, ma'am. She was at the time when that application was filed.
At one time, she was in USA. She could not join Pushpalata and Mr. Sumukh V as applicant in IA number so and so. IA number 3 of 24. For the reasons stated from Miss Samiksha B is brought on record as the LR of the appellant. Let amended memo of parties be filed within 2 weeks. Necessary corrections in the amended memo party shall also be carried out. This is the appeal for hearing on.
My lord, there is a delay in filing appeal, my lord, even notice may be ordered.
We'll look into it.
Yes.
28-3. Serial number 34.
Yes, I appear for.
I applied to. The suit for specific, I have filed this application, my lord, in the pendency of the appeal, your lordship. The respondent, my lord, before the Istanbul court, my lord, is excavating the soil. My lord was kind enough to protect the interest of the client by granting an interim order of injunction not to alienate or encumber. Kindly see the application, my lord, which has been filed. The application now filed, your lordship, seeking injunction, my lord, not to excavate or remove the soil on the land in question, my lord, which is the subject matter of the agreement of sale, your lordship, which is. What difference it could make? My lord, What difference otherwise it could make? otherwise, my lord, the nature of the land itself will be changed, your lordship. The photo, kindly see the photograph which I have produced.
Restraint order, no?
Yes, not to alienate the property is there, and that is.
May kindly see, the suit schedule property is agriculture property running to 10 almost 12 acres. He is doing agricultural activities. He is planting the trees, coconut and arconate trees.
Don't change it, why are you?
We are not changing the land from agriculture to non-agriculture.
One day is an encumbering not to alienate and encumber.
I have not alienated, that order is already there. It is only my learned friend is seeking that I should not excavate. It is an agriculture land, agriculture operations is going on. I will not change the land from agriculture to non-agriculture.
Why do you want to do that?
It is my land, it is agricultural.
You are right, but need to be, there is a list which is pending.
It is an agriculture land, he is doing agriculture activities. Other than the agreement,
Agriculture activity.
the lordship may kindly see.
Just show us one photograph where you can say that he is carrying out agriculture activity.
Photograph I have not put in. Photograph.
Applications ಇದೆಲ್ಲ ಕೊಟ್ಟಿದ್ದೀವಿ.
ಇಲ್ಲ. ನೀವು
ಕೊಟ್ಟಿದ್ದೀವಿ. ಕೊಟ್ಟಿದ್ದೀವಿ.
Send me by post. You send me by post.
ಕಾಪಿ annexes ಇದೆ.
ಇಲ್ಲ.
ಎಲ್ಲ ಮೇಡಮ್ ಕಾಪಿ ಕೊಟ್ಟಿದ್ರೆ ಅವ್ರಿಗೆ ಅಂತ. ಫೋಟೋಸ್ ಕೊಟ್ಟಿದೆ ಐಎನ ಜೊತೆಲೆ ನೋಡಿ. ಐಎ ಜೊತೆಲೆ.
Postal. I have not been
photographs.
I have no. I will produce the photographs.
The copies have been given. No, along with the annexes, my lord, I have given.
No.
What is marked, I have given.
What is sent is through post. It was sent. Only copies of the.
We want to know where is the agriculture activity being.
This is a portion of land. It is running 10 acres. This is only one portion.
Sure, file your reply.
I will produce a photograph.
Yes, do that. This is an application. You have madam, Xerox ಅವ್ರಿಗೆ ಫೋಟೋಗಳ ಎಲ್ಲಿ ಇಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೆ ಪೋಸ್ಟಿಂಗ್ ಇಲ್ಲ ಅಂತ ಮೈಲಾ
No, IA1 of 25.
IA1.
This is IA1 of 25. This is an application file of 25. I filed by Appellant. The following prayer. With a prayer to restrain the respondent or his agents from changing the nature of the suit schedule properties by not carrying out the excavation or the removal of soil till the disposal of the above appeal. Notice, so accept notice for the respondent seeks and is allowed how much time?
2 weeks, my lord.
2 weeks to file. Reply to the application, rejoinder be filed within weeks thereafter. This on the interim order dated 9/2/2022 shall continue till the next date of hearing.
(25) Serial number 35.
Yes, minute.
order.
It is an interim order, no?
There is an interim order not to alienate and encumber the property, your lords.
No intention to alienate that. I already submitted.
That will continue. Next.
Serial number 35.
I have the appeal for the
Not for interim order not to excavate the soil, your lordship, during the pendency of the.
We are hearing that application.
He'll file a reply, then only we'll pass.
By that time, my lord, already he has removed all, most of the soil, your lordship. Then, my lord, that is the whole difficulty, your lordship.
We will give time to him. Let's be clear. You don't want to file any rejoinder?
My lord.
You want to file any rejoinder?
No,
to his
already,
reply?
no, already it appears, my lord, in the card list, my lord, the objection is filed, my lord. A copy was,
For a different application. That's
Oh.
what we have checked up. That's for a different application, not for one of 25.
yes, sir.
Okay?
Yes.
You don't want to file rejoinder?
No, I want to file.
Very good. Rejoinder, we'll reduce it by 1 week. We'll have
Yes,
it
my
after
lord. That's why, my lord, let him file the objection as early as possible within a week, my lord.
3 weeks. After 3 weeks.
Please.
17 to
Next.
I humbly appear for the appellant, my lords. My lords, in this matter, this honorable court has already issued notice and has also granted stay till the disposal of the interlocutory applications. 2 interlocutory applications have been filed by me, one for condoning delay and the other for stay. My lords, I am the defendant number 1 in the commercial court. The respondent number 1 is the plaintiff. Suit was for a sum of around 49 lakhs with 12% interest per annum. Admittedly, there was a running account between us and the plaintiff was supplying electrical equipment to me. And admittedly, 3 transactions took place between the years 2017 to 2019, for which he has produced the invoices and he has also produced e-way bills under the GST regime to prove those transactions. Now, he has also produced his ledger accounts, which shows a sum of 70 lakhs having been paid by me towards those 3 transactions. Now, his case is that there is a 4th transaction for 49 lakhs, for which I have not paid, and where apparently I have received the goods as well. Now, to prove that he does not produce the e-way bill, he only produces his self-serving invoice, which is supposedly prepared by his former accountant, one Mr. Meeta Lal, whom he has not examined. There is no delivery note. There is absolutely nothing to show delivery of that additional, that 4th transaction. Hence, I am before your lordship. In spite of the same, my lord, the suit has been decreed.
What does the trial court say on the challan? Is there any challan which was produced?
No, my lords, kindly see page number 38. The Honorable Trial Court notes that page 38 at the middle of the page.
His case is totally different, denial of the entire thing. He says, I have never done any
My lords,
transaction.
if I may just finish this line of questioning. The e-way bills which are at exhibit at the middle of the page, my lords. The e-way bills which are at exhibit P11 to P13 also show that the materials as mentioned in exhibit P2 to P4 have been delivered to Messrs. Regal Insulating Corporation. No doubt the plaintiff has not furnished the e-way bill pertaining to exhibit P1, but the particulars of the e-way bill have been mentioned in exhibit P1. Now, exhibit P1, my lords, is the invoice, his self-serving invoice, signed supposedly by his own accountant, whom he has not examined. He says that Meeta Lal is no longer in my employ. Now, other than this exhibit P1 and his own ledger extract, there's nothing to show that I have been delivered goods worth an additional 49 lakhs, that any e-way bill was prepared and that I'm liable to pay the amount.
Did you receive that e-way bill?
No, I have never received it. I have denied it.
Where is that stand?
My lord, I have denied it in my written statement. Written statement.
You have denied any transaction of any nature with him?
That, yes, in the trial court, it has been a sort of general denial. It has been a sort of general denial of everything.
So you don't contest the three transactions?
No, 3 transactions I don't contest.
You have denied the transactions at all?
Yes.
All the transactions?
Yes, it is a general omnibus denial in the written statement. But in the evidence, I don't dispute these 3 e-way bills. Only the 4th one, my humble submission is, he should have proved this 4th transaction is
No evidence, my lord, on his behalf. He has
It's a
not
matter to be
cross-examined.
examined. My humble submission is, my lord, the record may be called for.
Let's see.
Yes.
Now, where is the e-way bill, exhibit P1?
Yes.
You are concerned with P1?
Yes.
Sure.
I will show your lordship's exhibit P1. Give 2 copies. My lord, I will give the trial court record copies.
How this exhibit has been proved?
It has not been proved, my lord. It has just been marked through the evidence.
Cross-examination. What is your
Yes.
cross-examination?
So he has not.
Kindly see the, I will show, my lords, the cross
There's
examination.
no cross-examination of me by that.
No, there is. I will show, my lords. Show the cross of PW1. Kindly see exhibit P1 for a moment, my lords.
You send this bill?
Yes, my lord, he has taken it and He has not cross-examined me, my lord. He has not let in any evidence.
No, I will show the cross. Kindly see the cross of PW1.
Some other defendant has cross-examined, not he, my lord. That particular, against whom the liability is fixed, he has not cross-examined me. He has filed a different written statement. He has not cross-examined me. He has not let in any evidence. Legal notice not replied.
PW1. Kindly see the cross of PW1, my lords.
We are very surprised why
Yes.
the other three transactions are not being contested.
My lords, we admit there was a running account.
That's right.
Yes,
So, when you have denied it,
yes,
and, but still it has been proved.
it's been proved.
But why are you not contesting the first three?
My lords, the documents are quite apparent, at the stage of mark.
Still you denied it.
Still, my lords, your lordships are aware, the trial court omnibus denial of everything.
Now, how was this document proved, exhibit P1?
Yes, my lords. My humble submission is,
There is your cross-examination.
yes.
He has not cross-examined, my lord. Some other defendant has cross-examined.
Kindly see, my lord.
Right, he may not have. There was a cross-examination on behalf of the defendant, yes or no?
Yes.
There was. There was.
I'm sorry, I have one copy, my lord.
You say someone else has cross-examined. As a counsel, he did not cross-examine, someone else has cross-examined.
First defendant's counsel has not cross-examined.
No, we have this cross-examination by advocate for defendant.
My lord, that is second defendant. Liability is fixed on first defendant only.
Now, who is the advocate? And on whose behalf this cross-examination happens?
Yes, my lords, that I will just. That's the only one. I'm sorry, I only have one copy of that.
So take this,
Yes,
please let us know who has examined. on
Yes, my
whose
lords.
behalf.
yes.
Other than invoice bill, what have you shown that the material had actually gone to him?
EVA bills, my lord. EVA bills,
Sorry.
he must have utilized the GST deposited by me.
See, when you are sending a material, you will send it through challan? Yes or no? Where is that challan? Have you filed it?
Yes, my lord.
My lord, I'm sorry, right now I'm not able to point out who the advocate was because the cross-examination says cross-examination by advocate for defendant. I may be forgiven, I will take instructions on that as to which advocate actually cross-examined him. But I believe it is our lawyer for the defendant number 1.
Don't know.
Yes, my lords.
The liability has been fastened upon you.
Yes, my lords. My lords, may I just read the cross-examination for a moment, my lords?
No.
Yes,
If it is by defendant number 2.
then there is no point in reading.
No point.
Yes, my lords. Could I seek a short adjournment to next week, my lords?
At the request of counsel, but we have to read.
My lords, in the meanwhile, could I seek extension of the interim order?
Have you deposited the amount?
My lords, it was an unconditional one granted by this honorable
There is a
court.
delay on
Liability.
The liability is to the tune of 49 lakhs plus 12% interest per annum.
You deposit the
My lords, the entire amount.
amount.
My lords, could I seek 25% because there's nothing to show that I am liable to pay the said amount. Nothing to show that I am liable.
These facts we will not.
My lords, 50%, my lords, I crave your lordship's intelligence.
Yes, say that. You want to deposit, we will say so. Otherwise, we leave it. Have you filed execution?
He has filed.
We'll work it out before the executing.
Could it be 60%?
We say nothing.
No, my lords, very well.
No, this is not the way, please.
All right, very well, I'm
Let's be
sorry.
very clear. This
Yes,
is not the way.
very well, my lords. I bow down.
They say that you will deposit 75%. This liability is only to the extent of 49 lakhs.
Plus 12% interest per annum.
Just say this The counsel for the appellant states that the respondent herein has filed execution proceedings before the and the Supreme Court has adjourned the proceedings to, what is the date?
Some future date is, I don't remember. Well, it's execution number 525 of 2002.
Has initiated execution for the, he seeks the stay of the impugned judgment and decree dated so and so, subject to the appellant depositing 75% of the decretal amount as computed as of today. Okay, with the Registrar General of this court within 4 weeks, there shall be a stay of the execution proceedings being
525 of 2022.
525 of 2022 pending before the concerned court.
Yes.
Okay. The concerned court, full stop. The amount deposited by the appellant shall be invested in an interest-bearing FDR. With periodical FDR of a nationalized bank with periodical renewals till the next date of hearing. Till further orders, let's say till further orders. So counsel for the, let the trial court record be requisitioned. Has it come?
No, sir.
No.
Will the trial court record be requisitioned before the next date of hearing? Notify the appeal.
Much obliged.
16-4.
1 minute, just 1 minute. Just say this, the learner counsel for the appellant, when we say no, that interim applicant. And say makes an oral request for the stay of the impugned order. The learner counsel for the respondent would submit, he has no objection, provided the appellant deposits the amount before this court. We then say 75%. Okay.
Obliged.
R2, who is R2?
R2 is, my lord, there is no liability is fixed, suit is dismissed against.
Why do you require? Just say this.
Yes, please.
Since the impugned order judgment decree imposes liability on the appellant herein and not on the respondent number 2, the notice to respondent number 2 is dispensed with. Okay,
16.
just give a date.
16-4.
Much obliged.
Serial number 36, government advocate.
Just take this.
As I request some time to file the affidavit regarding the admitted amount. I've received a letter, but that's not very clear on the calculation, my lord. So
Let's say Mr. Bhatt seeks further time. How much time, Mr. Bhatt?
it's about 2 weeks.
2 weeks to file the additional affidavit?
The affidavit, my lord, what had happened was that I had received instructions that there may be some amounts that are due to the respondent. And when I asked for an exact calculation, the calculation doesn't meet muster, my lord. So therefore,
To file an affidavit showing the admitted liability.
Yes, ma'am.
Of the appellants towards the respondent.
Yes, ma'am.
Request re-notified.
Any short date may be given, Manoj.
10-2.
Next.
Serial number 37.
I appeal for the appellant or the respondent. Lord, I have suffered a money decree, my lord. I have suffered a money decree, my lord. This honorable court by an order dated 13/6/2024, my lord, stayed the judgment and decree, my lord, subject to deposit of 50% of the decretal amount. My lord, the last date to file was the 8/8/2024, my lord. I could not mobilize due to my ill health, my lord. I have made an application, my lord, on 21/8/2024, my lord, seeking for extension, my lord. That was only listed today, my lord. I should be fair to the court, my lord, that 6 weeks is also over, my lord. My humble submission is, my lord, the execution is slated on 17th of February 2025. I may be granted time till then, my lord, before which I'll make it.
What? For what?
The 50% decretal amount.
When was the order passed?
My lord, order was passed on 13th of June 2024. my lord.
Why didn't you deposit it till date?
My lord, he is little unwell, my lord. He is undergoing some heart ailment. My lord, 13th, my lord, 17th of February, the execution is posted, my lord. Lordships may record my submission that before that date, if I do not deposit, my lord, let him go ahead with the execution.
Not clarify our orders like this. We have passed an order, need to be implemented.
My understanding, my lord, I've made an application, not a short accommodation, my lord. I will definitely obey the orders of the court.
I think we'll just adjourn it. It's not a way.
I understand. I'm not,
Almost a year, you have enjoyed the benefit of the interim order without depositing it.
88, of course, my lord, I concede, my lord, nothing to say on that, my lord. It's only a request, my lord. Time till 17th February, my lord, I will definitely deposit the decree.
Surely you will file an application if you want.
I will not, I'll undertake that I will not come further. I will not seek further time. On 17th February, if I don't do it, my lord, let him continue with the,
How much cost?
I'll leave it to the court.
How much is the liability?
About 13,28,720, out of which I have to deposit about 6.5 lakhs, my lord.
You will pay cost to him.
Very well.
How much?
Whatever your lordship say, something nominal, my lord, I'm in great difficulty, my lord. I'm
You say-
contemplating to sell a property, my lord. I will do everything, I do it.
You say,
I have filed an IA for vacating the interim order, my lords. That is, they have not deposited even after filing an IA for extension.
that's what we have put it to him. He has not deposited, subject to cost to you. He will deposit, we'll give him time till 16th of February.
Very well.
Okay?
Please, my lords, if on the 16th of February, they have not deposited, it may be vacated
Very well. You-
by some.
He say everything is subject to.
Very well.
On 13/6/2024, this court had directed the stay of the operation of the judgment decree. Between judgment and decree, subject to appellant depositing 50% of the decreed amount within 8 weeks. To stop, the counsel for the appellant states that the said amount has not been decreed. He prays that as the execution proceedings initiated by the appellant respondent are listed on 17/2/2025, he shall ensure the amount as directed by this court on 13/6/24 is deposited at least 1 day before the 17/2/2025, subject to the appellant paying a cost of ₹25,000 to the respondent, the time to deposit the amount as directed by this court on 13/6/2024. In this court is extended till 15/2/2025.
Very well.
Okay. The cost shall be paid before the deposit of the amount.
Very well.
Let's say this on, just give it somewhere in March.
I will deposit before this honorable court.
Yes, that's.
Very
what,
well.
That's one clarification, my lords.
But the order
13 lakh
doesn't say
cost
so.
plus-
The order doesn't say, but I will deposit before this.
It doesn't say so.
50% within 8 weeks is what it
50%
says.
of-
My lord, I will deposit before this honorable.
My lords, 50% of the decretal amount, my lords, that would include 13 lakhs plus the interest amount which.
We
comes
say
out.
nothing, we don't want to qualify this order.
Please, my lords,
Whatever has been passed, we have said so, whatever is order.
my lords, if they deposit less than,
We don't know,
Please.
see, we'll go by this order,
please,
okay? Just say this, the amount to be deposited shall be invested in an interest-bearing INR of a nationalized bank with periodical renewals till further orders, list on.
20th March,
Obliged.
November 38, Srimati Jyoti.
Delay of filing appeal 7 days, my lordship.
What are you saying?
Delay of 7 days, they prefer the appeal, my lordship.
Yes, for the respondent.
The notice not at all.
Attachment. How much is the delay?
7 days, my lord.
The reason stated in the. What is the date of, when did you apply? Let's see your 7 days, computation of 7 days. How do you say it's 7 days? What is the date of the decree?
Date of fees.
7/9. When did you file this appeal?
This appeal filed in 22 November 2024, my lordship.
The issue notice on the stay and as well as the termination. Let's see.
Please.
26(3). Serial number 39, Shri Ravi.
Appearing for the appellant, I was the plaintiff in a suit for recovery of money before the Honorable Trial Court. My suit was partly decreed, aggrieved by the judgment decree. I filed this appeal. There's a delay of 53 days, Your Lordships. On the computation of delay, the judgment was passed on 28/8, that is August 28th. Computing from 29th of August, the 60 days would expire on October 27th. I've spent 20 days for obtaining the certified copy. So it would move to 16/11. I've filed this appeal on January 8th. So there is a delay of 53 days. Now the delay of 53 days is the reason is,
Given for the delay.
yes. Now on the reasons for the delay, I'll have to explain a bit, hence I seek your kind indulgence. Now the plaintiff is a class 1 contractor. He had been assigned 5 work orders in 2014 March. All the 5 work orders were executed by him in his individual capacity. He had invested his savings and also had borrowed from financial institutions and from another individual who has subsequently implemented himself into this suit as respondent number 6. He died during the pendency of the suit and his LRs have been brought on record in the suit. Now, while obtaining a loan from him, he had also obtained a loan from him of about 50 lakhs. At the time of obtaining loan, he had issued blank unsigned checks as security for the sum of 50 lakhs. Now by 2015, about 15 lakhs had been repaid with interest. Now, when he asked for return of the checks, he was told that the checks have been misplaced and he was very evasive. Subsequently, for the remaining 35 lakhs amount, a sale agreement was executed as collateral and for security in May 2016. By April 2017, the entire 50 lakhs had been repaid. And when he sought return of this, then started all issues. So one is the checks, one of the checks was misused. It was filled up for 50 lakhs. A check bounce case was filed against the appellant herein. Then there was a suit filed for specific performance based on the sale agreement. Apart from this, there were other criminal cases hoisted against the appellant. Now he has depleted all his financial resources and hence there is a delay. Now let me explain. Now on the decretal amount, about 9.29 lakhs was paid by our respondent number 1 out of the total amount, apart from the court fees and the pleader's fees. It is only after they have deposited the total amount of about 14.8 lakhs, I have been able to pay some of my outstanding bills and then pay other bills, and then I have been able to pay the court fees and file this present appeal. Hence, there is a delay. On 9th of December is when the amount of 14.8 lakhs was paid to me. Only after this, I've been able to pay the court fees and instruct my counsel, etc., and then file this appeal. Hence, there is a delay.
So this 53 days is over and above 60 days.
Yes.
Now, how have you explained the delay that caused after you have received the certified copy? Where is the explanation?
Yes. If my lordship
From your application.
Yes, if my lordship comes to my application on page 105, para 5 and 6,
I state and submit that I had invested all my savings apart from borrowing amounts to complete the work orders 1 to 5 that are the subject matter of the commercial OS 8367 of 2017. I state and submit that even after repayment of the loans taken by me from Sri Chandrasekhar, the defendant number 6 in commercial OS for the aforesaid purpose, civil and criminal proceedings have been initiated against me, Sri Chandrasekhar, through his confidant Sri Umesh and Sri Mariswamy by leveling false accusation from 2017 onwards. I state and submit that being embroiled in the aforesaid issues/litigations, I have depleted all my financial resources. I state and submit that it is only after the respondent number 1 has paid an amount of 14.81 lakhs on 9/12/2024, I have been able to take care of some of my outstanding bills and also approach my counsel, pay his outstanding fees, give instructions to prepare the present appeal, pay the court fees to file the present appeal. I state and submit that hence there is a delay in the filing of the present appeal. That is what has factually happened, my lords. There is already a caveator. Respondent number 1 has filed caveat. We have served a copy of the entire petition and the IA.
Who is the caveator?
R1.
Just a issue notice. Who are these sellers? Who is R4?
R2 to R4 are officers of R1.
R6?
R6 is an impleading applicant whose impleading application was allowed, R6 and R7.
How is he connected with the?
That's wherein the dispute arose, my lords. There were 2 work orders wherein R1 started saying that there was a rival claim saying that the partnership firm has executed 2 work orders. So that's where the disputes arose.
26(3).
Have they initiated any execution?
No, it was only about 14.81 lakhs which they have paid. Grateful.
Number 40.
Yes, Mr. Dutt.
Our associate had mentioned the matter in Bombay High Court before the tax bench. But apparently, my lord, it was not successful because they are hearing appeals of 2003, 2004. And this is a 2017 appeal. So, Lord, there are 2 things, Lord. May I only say this? Now, as far as the base tax is concerned, Lord, it has to await the order because this is only tentative. Eventually, the payee has succeeded before the ITAT. The matter is pending in the Bombay High Court. If not, the payee succeeds, that's the end of the matter. If the payee doesn't succeed, the money Jindal has already deposited in 1997. The money is with the department. Now, if Riol doesn't succeed, as far as not the base tax is concerned, that's the end of the matter. But the penalty will still remain. So that's why my submission was because they had not refunded me the penalty amount in 2006 when ITAT ruled in my favor. The ruling is on the basis that there is an exigibility of tax, but there is reasonable sufficient cause because of ABCD reasons. And my lord, therefore, my lord, what I was saying, because if tomorrow, my lord, after 10 years, I lose the penalty, the interest will be phenomenal, my lord, as far as I am concerned. May I only say this? Your lordship may, my lord, hear the penalty. It will not take more than 15 minutes because, my lord, it's a 1 ground appeal. Your lordship may either accept it or that 1 ground may reject it. Secondly, my lord, there are judgments. As a general principle, my lord, your lordship knows subsequent events can be looked into. There are judgments, my lord, on tax side of Rajasthan High Court Division Bench, Bombay High Court Division Bench, that subsequent events can be looked into. Now, today, the subsequent event is that there is still no clarity whether there is, my lord, the taxability or not. That itself is a sufficient ground. 1, my lord, this honorable court in division bench held that partly it is not covered, which led to a, my lord, retrospective amendment by them. 2, my lord, the Bombay ITAT says there is no exigibility. Therefore, even on, my lord, the subsequent events, the penalty, my lord, order cannot be sustained. That's my submission. It will not take more than 10-15 minutes. Lordship may hear the penalty appeal, decided it's his appeal, my lord, it's 1 ground appeal, 1 2-page appeal, and my lord, decide that.
He says everything need to be heard together.
My lord, together, the penalty, my lord, as I said, even if I succeed, even if Riol succeeds, my lord, the payee, the penalty will still remain because that's independent. If Riol succeeds, no, nothing will remain, sorry. If Riol succeeds, nothing will remain, my lord. Penalty will also automatically go. But if they succeed, If the department succeeds, penalty still remains. And we are in the same position after 10 years, my lord. And your lordship will be deciding whether there is sufficient cause or not, which already ITAT has given a finding of fact. My lord, in my respectful submission, my lord, the law is very clear. Finding of fact, my lord, there is no question of law involved here. It's a finding of fact based on various, my lord, opinions given by the lawyer, given by the chartered accountant, steps made before the, my lord, authority of advance ruling to get to say that there is, whether there is exigibility of tax or not. All that is considered, and the tribunal held that there was sufficient cause. Even though there is exigibility of tax, there is sufficient cause. Therefore, there is no need for any penalty. And they, in fact, my lord, they also didn't take it seriously. They refunded the amount in 2006 and filed just a one-pager, my lord. Your lordship may see it's a one-pager.
Your lordship, it has to go together, my lord. In principle, my lord, in tax matters, first tax, my lord, it is all penalties, always consequential, my lord. Because your lordship may kindly see whether penalty levied is correct or not. Not your lordship, prima facie, we have to show that whether this tax is chargeable or not.
Today, I am saying we are proceeding on the basis that there is exigibility. Today, my lord, the penalty proceeds on the basis that there is exigibility.
Right, Mr. That we'll do one thing, we'll just release it, we'll place it before the roster bench.
Lord, since your lordship had heard it, my lord, at some length, therefore, that's why I was.
We were to, in fact, hear it, you were only on your legs.
Yes, my lord. But your lordship had heard the substantial part. But my lord, today I am saying base tax is right. Base tax may be, my lord, an academic exercise as far as the base tax is concerned. Penalty issue will still remains because I am on a demurrer that yes, there is exigibility.
The justification is if it is ultimately heard, submits after a lapse of time. Surely the.
My lord, it's 12% interest, my lord, under the statute. Because my lord, the way things are, it's the Bombay High Court is hearing appeals of 2003-04. I am told, my lord, here it's 2019-20, my lord, the court is doing very well. But there is 2003-04, my lord, and 2017, I don't know, my lord, it may take another 6 years, 7 years. And then it will go to Supreme Court, my lord. This is a matter where the government has come out with a retrospective amendment just to deal with your lordship's judgment in division bench. So it will not end in the High Court also.
We'll place it there only. Let it go to rest.
As a lordship.
Just say these matters, these appeals are released from Partha to be listed before the roster bill, subject to the orders of the honorable. That they can only do. We'll give it date. When do you want, Mr. Dutt?
Not either 3rd or 10th, whatever is convenient. Because it will be on a Monday only, I am told.
3rd or 10th?
3rd of February, sir. 3rd of February.
3rd February. 3rd February.
Thank you.
Great.
All the matters will be
42, serial number 42. Nidhishri.
For the appellant, my lord.
Yes.
My lord, this is an 34. This is a 37 appeal that has been filed against the commercial court order where it upholds an ex parte arbitral award, my lord. At no point in time was the appellant served copy firstly of the CMP. Then after we came on record, the same wrong address was also used before the arbitration center. Subsequently, the arbitration center holds that service is sufficient, despite the fact that the notice comes back as no such person, party left. Now, these grounds were urged before the commercial court below. Unfortunately, the commercial court does not look into this and says that this is a specific performance that had to be necessarily executed and dismisses my appeal.
Yes.
If I can take my lord to the order.
Let's see that.
Yes, madam. Page 39, my lord.
Yes.
The operative portion, my lords will find at 55.
Yes.
My lords have that.
How much was the delay in filing 34?
My lord, it was filed within the additional 30-day period.
Initial 3 months?
Yes, my lord. After the initial 3 months.
No, after or before?
After, my lord.
So that is another 30 days.
Yes, my lord. So well within that 30 days.
Okay. Now, that was decided in affirmative or in negative?
In negative, my lord.
Let's see the reasoning given then.
Yes, my lord.
Here are the facts which
My lord, I'll just quickly take my lords to the fact. What has happened is there was a sale agreement that was entered into between the appellant and the respondents, my lord, in respect of a commercial premises. Now, the appellant was a co-owner of the property. Sale agreement is dated 2nd November 1998. The dates may kindly be taken note of, my lord. There was an arrangement under the sale agreement that part of the sale consideration would be paid within a particular date, and the rest of the balance sale consideration would be paid on the day of execution of the sale deed. Now, out of the amount that was to be paid, there was about 1,40,000 that was to be paid before signing of the sale agreement, which was admittedly not paid. Only 1 lakh was paid. Balance also, they did not come forward to pay that. Then they issue a legal notice seeking specific performance in the year 2015, my lord. No steps have been taken from 1998 till 2015. And this 2015 legal notice was not served on the appellant. So they come forward, they invoke section 11, they come forward and file a CMP. In the CMP, they again give this wrong address. Then there is a phone call that is placed to the appellant. Then the appellant receives summons through the court peon, comes before the court, furnishes his correct address, and then it is referred to the arbitration center. In the arbitration center, my lord, again, while filing the claim statement, the respondents give the same wrong address that was given in the time of issuing the legal notice and also as in the CMP.
How was the matter referred to arbitration?
There was an arbitration clause in the sale agreement.
No, but how was it? Did they issue any notice to you?
They supposedly issued a notice which was not received. Then they filed a CMP, my lord. In the CMP, the postal department then called the appellant, and then the appellant said, my address has changed, and the postal address, the postal Jamedar then came to the new address and served him a copy of that. Then he appeared before the Honorable High Court. And he filed his objections, raised various grounds such as specific performance is not maintainable since it is barred by limitation.
What happened to that application?
The CMP was allowed, my lord.
Was allowed in your presence?
Yes, my lord, in my presence.
What was the order passed?
Yes, my lord. I'll take my lords to that. My lords can look at it at page 155. The relevant portion is at 165, my lord, paragraph 14. My lords have it.
165.
165 is the relevant portion, my lord. May I read, my lord?
Just one. Maybe 165.
This is with my application, my lord, interlocutory application. I had filed an interlocutory application for stay.
Is it there? Yes.
Page 165, my lord, paragraph 14. May I read, my lord? Insofar as the contentions put forth by the learned counsel for the respondents that the relief as paid pursuant to the agreement of sale would be barred by limitation, that aspect of the matter need not be gone into in the instant petition, since that is also an aspect.
Tell us one thing. Did you receive any notice from the arbitrator?
No, my lord, we did not. Because the address that was given by the claimant, that is the respondent herein, was the same address from which all postal service comes back as returned, no such person, party left.
But you were the person who filed the section 11, no?
No, my lord, I did not file section 11. Respondent filed the section 11.
Yes.
So my lord, the issue of limitation was kept open.
When did
The
you come to
CMP.
know about the award?
My lord, I came to know about the award when an execution petition was filed, and then the court peon called me again, called the appellant, and that's when they got to know that there was an arbitral award that was passed. I did not take part at all in the arbitration proceeding, and then I appeared before the executing court.
Yes.
In fact, my lord, curiously, in the execution petition that is still ongoing, the respondents appear through their counsel. In fact, they have filed a memo even as recently as 8th January 2025. My colleague will hand over a copy of the objections file, my lord.
Aforesaid. See this.
On-
Last time notice was issued, no? Just check up.
If I could trouble my lords to look at the memo that I'll
Now,
be
what is
handing
the
over.
stage of the execution proceedings today?
My lord, it is next listed on 1st of February. They are appearing before the executing court and they are insisting on payment execution of the award in terms of executing a sale deed. However, they're refusing to accept notice and appear before this honorable court. If the memo
How much is the liability?
My lord, this is a sale agreement that was entered into. A balance of 67,000 had to be paid by the respondent to the appellant for execution of a sale deed, which admittedly they failed to do so. They've been quiet about it. They haven't shown readiness or willingness to perform their end of the bargain in terms of paying the balance sale consideration. Then after a gap of over 15 years, nearly 15 years, they issue a legal notice and initiate all these proceedings, my lord.
Let's see, where do you plead the knowledge insofar as the arbitral award is concerned?
Yes, my lord. May I show it from the order of the commercial
Yes,
court,
show
my
it
lord?
from the impugned order.
Yes, my lord. My lord, if I could take my lords to page 44 and 45, my lord.
Yes.
My lord, on 45, it says, accordingly, on 25/9/2018, court peon served the copy of the summons and the execution petition on the first plaintiff at his work address. Upon perusal of the summons, they came to know execution petition has been filed by defendant number 1 to 5 against them and the defendant number 6 to 9 in respect of the award dated 11/1/2018, which was passed in arbitration case number so-and-so. So they entered appearance through their counsel on 12/10/2018 in the said execution proceedings. On the same day, approached the arbitration center and filed for copy of the arbitral award dated so-and-so along with case papers on 29/10/2018. On perusal of the case papers, found that the defendant number 1 to 5 had showed their address to be that of so-and-so, for which they vacated as far back in the year 2010, and which was also known to the defendant number 1 to 5, as was evident from the affidavit filed by them in CMP number so-and-so. Defendant number 1 to 5, with an intention to place them as ex parte and to snatch the order at their back, had furnished wrong address in the claim statement. May I continue, my lord?
And where do you say that no notice was issued from the arbitrator?
As I continue, my lord, the defendant number 1 to 5 had cancelled change of their address to the arbitral tribunal. Consequently, a notice from the arbitral tribunal was sent to them to the old and incorrect address, which expectedly came to be returned with postal shara addressee left, returned to sender. Defendant 1 to 5 mischievously sought leave of the tribunal, carried out notice to them, and the defendants by way of substituted service through newspaper publication in Kannada daily newspaper so-and-so. And they were placed ex parte and they were not conversant in reading Kannada language, and they had no opportunity or reason to come across the paper publication arrived at by defendant number so-and-so. The tribunal pleased to pass the ex parte award. And even in the grounds which have been extracted, my lord, even
Now,
in that,
what about, how do you answer this defendant 1 to 5 cancel change of their address to the What is this? Had cancelled change of address to their address to the arbitral tribunal. What do you mean by this?
My lord, I think the.
C45, page
Yes, my
40.
lord. Yes, my lord. I think that's a typographical error. What was probably meant was that the defendant number 1 to 5 had not intimated change of the appellant's address herein to the arbitral tribunal.
But did you inform the change of address?
Not to the arbitral tribunal, my lord. We had informed when we appeared before the Honorable High Court in the CMP, in our affidavit, the correct address was mentioned and this submission was also made. And subsequently, when the order was passed and it was referred to the arbitration center, the respondents furnished the same old address, did not take any efforts to change it to the current address that was furnished in the CMP. I had absolutely no notice of the proceedings. And in fact, a perusal of the arbitration center proceedings, my lord, clearly indicates that the notice.
Let's see the High Court order.
Yes, my lord. My lords will find it at 155, my lord. This was along with the stay application.
Yes.
At 159, my lord.
Where do we inform?
Yes, my lord.
The change of address.
Yes, my lord. My lord, it's not forthcoming from the order. If I may be permitted to file my objections, my lord, as in place before this court, my objections that I filed in the CMP. In
Yes.
that, there would be this contention that will be taken up, my lord.
Where is the objection?
Yes, my lord. My lords, look at page 151, my lord.
Yes.
At paragraph 6, my lord. 152, my lord, page 152.
Yes.
The averments in paragraph under reply are denied as false and the respondent is put to strict proof of the same. Petitioners claim to have allegedly issued legal notice dated so-and-so. Respondents having allegedly evaded service notice is denied in toto. Petitioner has not produced the postal receipts or the acknowledgement in respect thereof. Respondents state that no legal notice has been issued.
But this is not the way. Where do you say you have changed the address? You have communicated to them.
My lord, at 154 is my verifying affidavit, which shows that new address, my lord.
This is not the way. This is not the way. I have described my address at a place and it is expected he should know.
My lord, there were every efforts that if the respondents had made, they have deliberately given the wrong address. If they'd at least given my phone number, such as they've done now with the execution
That we
petition.
can't take it. Whatever address he has as per his records, he has given that. That you can't deny it.
My lord, this is not as per his records. This was in 1998, almost 15 years prior to the issue of the legal notice.
Let's see the order of the High Court.
Yes, my lord.
Your address is the one which is depicted here at page
Yes, my lord.
156.
This is the address furnished by the respondent, my lord, to the court.
That's right. Obviously, then have you corrected him? And this address is
Yes,
based
my
on
lord.
some previous correspondence between both of you.
The agreement, my lord, sale agreement of 1998.
Okay. So where is the communication from you? Look here, this is the change of address. Henceforth, now this would be. Where is the representation before the High Court also?
My lord, other than the verifying affidavit, I cannot better my case, my lord. This is with respect to limitation. If I look at the other facts, my lord, even otherwise, when I look at the merits of the case.
No, So let's proceed on this premise. There was no communication of change of address. Whatever address the respondent had, they had given to the High Court, and possibly the arbitrator has sent the notice on that address.
Yes, my lord. Subsequent to
Right?
that, yes, my lord. Subsequent to that,
So
it
he
came
proceeded,
back as,
arbitrator proceeded.
my lord, subsequent to that, it came back as no such person. Addressee left. It says so.
Right. You're right. No such person. They don't know about your address. What will
Yes,
they
my
do?
lord.
Through publication?
And again, the publication, my lord, mischievously is given in the Kannada newspaper, when the appellants, unfortunately, are not well versed in the language. They're business persons.
But the address is the same on which you were residing, on which the respondent had the knowledge.
In 1998, my lord, they keep quiet for over 15 years. And then they issue a legal notice to an address that is 15 years old.
Oh, it's all right.
Seeking
man.
specific performance.
You show us one communication, you have address. Say, look here, this is the change of address.
My lord, I cannot better what is already on record, my lord.
See, everything flows from there.
My lord, even
And
then.
he proceeds ex parte, he gives an award. Now you don't have the knowledge of the award. At the execution stage, you come to know.
Yes, my lord.
And then you file an 34. 34 is admittedly from the date of the award would be barred by time.
My lord, 34, there again, if I may be permitted to take my lords through case law, which is settled law that from the date of when I get knowledge.
No, you see that? You see
Yes, my
that
lord.
provision?
Yes, my lord, from the date when I get knowledge, when I have knowledge of the award, when it is served on me, that is when my limitation starts, my lord.
By whom? You can just show us. By the arbitrator.
Yes, my lord. In fact, now the arbitration center makes it very clear that only the parties themselves have to come and collect the award in person, not even their counsels and collect the award. So I have filed for a copy of the award once, as soon as I received notice of the execution petition, and subsequently I filed well within the time. The statutory period, I filed my section 34. So the limitation in that aspect is saved, my lord. With due respect, I'll take my lords through case law as well in that aspect.
You see 34.3.
Yes, my lord. My lord, in fact, even in respect to the first point, if I may, if my lord permits me, I'll take my lords through the case law. There is ample case law which says that mere procedural requirement, if it is complied, does not mean it is compliance of notice having been served.
Different regime. We are in an arbitration regime.
Yes, my lord. In the
Yes,
arbitration,
you have to show
I'm
us.
talking about. Yes, my lord.
And let's see the reasoning given by the 34 court.
In fact, my lord, the 34 court also says that the High Court has already decided on the issue of specific performance and limitations. So there's nothing left for me to do here, which is what the arbitral tribunal says. And the,
let's see that.
Yes, my lord. And the trial court upholds that. Page 59, my lord.
See paragraph 15.
Yes, my lord. That page 59, paragraph 15, my lord.
Yes.
It is an admitted fact the learned counsel for the plaintiff, while canvassing his arguments, has submitted that no notice has been served not only on the plaintiffs, but also on the defendant number 6 to 9 and the defendant number 1 to 5 have not taken the steps to the correct address of the plaintiffs. And the defendant number 6 to 9, knowing fully well about their correct address and the award, which passed by the sole arbitrator, comes within the purview of section 34 of the Arbitration and Conciliation Act. So before considering the arguments, etc., then it is extracted various provisions, my lord. Reasoning, my lords will find at page 67
Come to page 68.
Yes, my lord.
This para 12, what he refers to, just read that.
Yes, my lord. The learned counsel for the plaintiffs has much argued for non-service of summons nor the notice from the arbitral tribunal. Thus, this court has drawn its attention on Rule 14 of Arbitration Center, which reads like this. So the above provision reflects director and the arbitral tribunal.
No, just read that. Just read that.
Yes, my lord. Very well, my lord.
Rule.
Yes, my lord. All notices or communications from the director and the arbitral tribunal shall be in writing and deemed to have been duly delivered when sent to the last known address of the party or the duly notified representative of the parties. Such notice or communication may be made by one of the following modes: delivery against receipt, registered post, courier, facsimile, transmission, telex, telegram, or any other means of electronic communication. So the above provision reflects director and the arbitral tribunal shall issue notice in writing through the ways as referred above from participating in any subsequent proceedings. Thus, this court draws its attention on Order 5, Rule 17 of CPC, which reads like this. Procedure when defendant refuses to accept service.
Just come to the next para thereafter. The above provision.
The above provision is very much clear where the serving officer, after using all due and reasonable diligence, cannot find the defendant who is absent from his residence at the time when the service is sought to be effected. Service can be made to the serving officer, shall affix on the outer door or some other conspicuous part of the house. This has not been done, my lord. In any case, this has not been done. Now let me know the arguments advanced by both the counsels. As the learned counsel for the plaintiffs, while canvassing his arguments, has drawn the court attention on the award passed by the sole arbitrator on the ground that the order which passed by the sole arbitrator reflects notice has not been served on the plaintiffs nor the defendants number 6 to 9. So on careful perusal of the award in para 4, found that after the claim statement, notice was sent to the respondents through registered post acknowledgement due by I think it must be registry, my lord, by the sentry to submit their written response, and same returned with postal shara, respondent 1 to 3 left, returned to sender, and the notice sent to respondent number 4 returned with postal shara as no such door number, and the notice which sent to respondent 5 and 6 returned with postal shara as no such person in the address and returned to sender. And thereafter on 26/10/2017, notice through RPAD intimating the respondent about the first day of hearing as on 13/11/2017 was sent to the respondents by the sentry. The notice sent to respondent 1 to 3 returned with postal shara left, and in respect of respondent 4 to 6, notice has been returned with postal shara as no such person in the said address. Thereafter, the claimants were taken the steps through paper publication and placed the plaintiffs and the defendant number 6 to 9 as ex parte. So in the order which is passed by the sole arbitrator reflects, though the defendant number 1 to 5 have taken steps as per Rule 14 of the Arbitration Center, Karnataka Domestic and International Rules, but neither the plaintiffs nor defendant number 6 to 9 did not appear nor prosecute the case. Thereby, they were placed them as ex parte. So there is no bar to take the steps as stated above. Accordingly, defendant number 1 to 5 were taken the steps, and plaintiff and defendant number 6 to 9 were placed ex parte. Learned counsel for the plaintiffs has much argued that the defendant number 1 to 5 in the CMP filed before the Honorable High Court of Karnataka were not shown the correct address, as they came to know about CMP, which filed by defendant number 1 to 5 through local postman who telephoned them about the postal article, and they were also informed the new address to the said postman and collected registered post from the postman, and they were appeared in the said CMP petition and filed their objection in the verifying affidavit.
Come to paragraph 17.
Yes, my lord. My lord, before that, may I just read the second half of on page 72 of para 16, my lord?
Yes.
So if the direction which made by the Honorable High Court of Karnataka is taken into consideration, the plaintiffs as well as defendant number 6 to 9 and the defendants number 1 to 5 have been directed to approach the arbitration center and to file the necessary papers. And it is not the case of the plaintiffs nor defendant number 6 to 9 that as per the direction of the Honorable High Court of Karnataka, they were approached the arbitration center when there is a direction from the Honorable High Court of Karnataka to approach the arbitration center to file the necessary papers. It is a bounden duty of the plaintiffs and the defendant number 6 to 9 to approach the arbitration center and to file their necessary papers, but either the plaintiffs nor the defendants number 6 to 9 did not do so. It shows their conduct in spite of direction which issued by the Honorable High Court of Karnataka. Even then, the defendant number 1 to 5 have taken the steps as per rules, but the plaintiffs did not appear. Therefore, they were placed as ex parte. Learned counsel for the plaintiff, while canvassing his arguments, has much argued that the plaintiff number 1 has filed his verifying affidavit in which has shown the correct residential address, but the reasons best known to the plaintiffs when they were appeared before the Honorable High Court of Karnataka and CMP Nothing is prevented to file an application to direct the petitioner for correction of their present address in the cause title of the petition. But the reasons best known to the plaintiffs did not take any steps. Now they come up with instant petition stating that no notice has been served on them to appear before the arbitral tribunal when there was a direction from the Honorable High Court of Karnataka to approach the arbitration center. Without doing so, now they come up with the instant petition on the ground of non-service of notice. Therefore, the arguments advanced by the learned counsel of the plaintiff on this aspect holds no water. It is an admitted fact, neither the plaintiff nor the defendant number 1 to 5 were not disputed about agreement of sale, which taken place in between the plaintiffs and the defendants. It is a contention of the plaintiffs that the defendant number 1 to 5 did not come forward nor paid the balance sale consideration. The award which passed by the arbitral tribunal reflects the arbitral tribunal after considering the materials on record, passed the award, directing the defendant number 1 to 5 to deposit balance sale consideration within 3 months and directing the very plaintiff and the defendant number 6 to 9 to execute the registered sale deed in favor of the defendant number 1 to 5. Now, the question is whether the
We will
petitioner...
continue, ma'am. We'll just continue.
Tomorrow, my lord?
Just see it tomorrow. Tomorrow, how many are there, ma'am? How many are there tomorrow? Sure. The others, we will be giving you dates.
Interim orders?
Yes, we'll have it day after tomorrow, this matter.
My lord, if it's not too much of an inconvenience, could I ask for Monday, my lord? I'm not available from the 22nd to the 24th, my lord.
27th,
Deeply obliged, my lord.
Just give dates.
53, 54, 55.
She'll give dates. Just give dates.
Well, matters in which interim orders, then, my lord, will get extended.
There you will just inform the court officer. She will, if there
Please.
is any, we will extend it.
Much obliged, my lords.
Madam, serial number.
ಸರ್ ಆ ಥರ ಅಲ್ಲ ಒಂದು ಕಡೆಯಿಂದ ಬರ್ತೀವಿ ಸೀರಿಯಲ್ ವೈಸ್ ಬರ್ತೀವಿ ಸರ್ serial number 43
appellant 2 weeks ಮೇಲೆ time ಕೊಡಿ
sir written submission you have to file the written submission sir
ಹೌದು 2 weeks ಇದು ಕೊಡಿ
ಇಲ್ಲ sir 27-2 serial number 44
7-2 ಏನಾರ ಆಗೋದು
27-2
ಓಕೆ ಥ್ಯಾಂಕ್ ಯು
44 5th of March 47 interim order ಇದೆಯಾ ಮೇಡಮ್
ಪ್ಲೀಸ್ ಮೇಡಮ್ 47 interim order ಇದೆ
interim order extend ಮಾಡಿ 3rd of April 48 urgent 49 ಯಾವ್ದ್ರಲ್ಲಿ ಯಾವ್ದು ಸರ್ ಸರ್ ಈ ವೀಕ್ ಬೇಡ ಸರ್ ನೆಕ್ಸ್ಟ್ ಮಂತ್ ಅಲ್ಲಿ ತಗೊಂಡು ಯಾವ್ದು ಸರ್ 30th $50 next week ಯಾವ್ದಾದ್ರು date execution ಇದೆ
First ಇದೆ execution.
49 ಯಾವ್ದು
ಮೇಡಮ್ ಕೇಳ್ತಾ ಇಲ್ಲ ಮೇಡಮ್.
This Thursday, sir.
ಕೋರ್ಟ್ ಆಫೀಸರ್ ಕೇಳಿಸ್ತಾ ಇಲ್ಲ, ಡೇಟ್ಸ್ ಕೊಡ್ತಾ ಇರೋದು.
ಸರ್ ಈಗ ಕೇಳಿಸುತ್ತಾ?
ಈಗ ಕೇಳ್ತಾ ಇದೆ.
ಕೇಳಿಸ್ತದೆ.
ಸರ್ ಸೀರಿಯಲ್ ನಂಬರ್ 51 ಅಲ್ಲಿ ಯಾರಿದ್ದೀರಾ? ವಾರೆಂಟ್ ಇದೆ 29ಕ್ಕೆ 23 1 ಸರ್. 52 ಹೇಳಿ ಸರ್. ಯಾವತ್ತು ಸರ್? 30 29 28 29 ಯಾವತ್ತು ಸರ್? ಎಕ್ಸಿಕ್ಯೂಷನ್ ಇದೆ, ನೋಟ್ ಮಾಡ್ಕೊಂಡಿದೀವಿ. 53 28 1. 55 ಮೇಡಮ್ ಅರ್ಜೆನ್ಸಿ ಹೇಳಿ ಮೇಡಮ್. 26 3 56
Any date, respondent.
ಸರ್ ಅರ್ಜೆನ್ಸಿ ಇಲ್ವಲ್ಲ?
ಇಲ್ಲ.
ಮಾರ್ಚ್ ಏಪ್ರಿಲ್ ಸರ್ ಏನ್ ಗೊತ್ತಾ, ಫಿಲಿನ ಪ್ಲಾನ್ ಮಾಡ್ತಾ ಹೋಗ್ಬೇಕು. ಅರ್ಜೆಂಟ್ ಇರೋರು ಮೊದಲು ಕೊಡ್ತೀವಿ, ಆಮೇಲೆ ಅಷ್ಟೇ. ಸರ್ ಇನ್ನು ಹೇಳಲಿಲ್ಲ. 56 26 3 ಸರ್ 57 ಅವ್ರ ಗಲಾಟೆ ಮಾಡಿದ್ರೆ
57 I appear for the appellate.
ನೋಡಿ appellant.
No urgency.
No urgency, sir. Then April, okay, sir. April is
Application
okay.
also is fine.
May adrunu okay, sir. Very good.
May madam, after vacation ಮಾಡಿ.
May full.
After vacation andro I have to give one date, sir.
Any date. 1st June, 2nd June.
3rd of June.
Thank you.
At request, joint request.
Thank you.
Joint request ಅಂತ ಹಾಕಿ ಮೇಡಮ್. 58 ಹೊಳ್ಳ ಅವರಿದ್ರ ಸರ್. 58 ಯಾರಿದ್ದೀರಿ? ರಾಧಾಕೃಷ್ಣ ಹೊಳ್ಳ ಇಲ್ಲ. 25 3 59 ಶ್ರೀ ಕುಲಕರ್ಣಿ.
29 ಜಾನ್ ಕೊಡ್ಮಾ
ಸರ್. ಯಾವ ಡೇಟ್ ಸರ್?
29th January.
29 ಸರ್. ನೆಕ್ಸ್ಟ್ ಮಂತ್ ತಗೊಳ್ಳಿ ಸರ್.
ಆಯ್ತಮ್ಮ, ನೀವು ಕೊಡಿ. 29 January ಕೊಟ್ರೆ ಖುಷಿ, ಇಲ್ಲ ಅಂದ್ರೆ ನೀವು ಯಾವ್ದು February 1st week ನಲ್ಲಿ ಯಾವ್ದಾದ್ರು ಡೇಟ್ ಕೊಡಿ.
ಸರ್ 12/2.
ಓಕೆ ಮಾ, ಒಬ್ಲೈಸ್.
60 ಫೈನಲ್ ಹಿಯರಿಂಗ್. ಫೈನಲ್ ಹಿಯರಿಂಗ್ ಅಲ್ಲ ಮೇಡಮ್, ಅರ್ಜೆನ್ಸಿ ಇಲ್ವಲ್?
3rd or 4th of April. What is too long?
ಏಪ್ರಿಲ್, ಮಾರ್ಚ್ ಆರ್ ಏಪ್ರಿಲ್ ತಗೊಳ್ಳಿ ಮೇಡಮ್. ಹಿಯರಿಂಗ್
Urgency execution proceedings are going.
ಮಾರ್ಚ್ ಅಲ್ಲಿ ಕೊಡ್ಲಾ?
March is too far now. 1st week of February, please.
25/2 ಮೇಡಮ್.
Earlier date if possible.
ಸರ್ ಹಿಯರಿಂಗ್ ಅಲ್ವಾ ಸರ್?
The execution proceedings are going on. This is 2nd week of February.
61 ಹಾ ಸರ್ ಹೇಳಿ. 10/2 ಸರ್. 62
ಮೇಡಮ್ ಅಪಲೆಂಟ್ ಮಾರ್ಚ್ 1st week.
ಮಾರ್ಚ್ ಅಲ್ಲ ಏಪ್ರಿಲ್.
ಏಪ್ರಿಲ್ ಬೇಡ ಮೇಡಮ್, ಮಾರ್ಚ್ 2nd week.
ಮಾರ್ಚ್
2nd week.
ಸರ್ 12/3 63 64 ಅವ್ರು ಬೆಳಗ್ಗೆ ಯಾರೋ ಕನ್ಫ್ಯೂಷನ್ ಮಾಡ್ಕೊಂಡು ಅನ್ಸುತ್ತೆ. ಇದು ನೆನೆ ಈ 64ಗೆ 22/4 ಹಾಕಿ. 65 ಅರ್ಜೆಂಟ್. 66
28 ಅಥವಾ 29 ಮೇಡಮ್, ಇದೆ ನೆಕ್ಸ್ಟ್ ವೀಕ್.
ಸರ್ 66 ಸರ್.
66
ಹಾ ಸರ್ ಹಿಯರಿಂಗ್ ನಲ್ಲಿ ಇದೆ ಅಲ್ಲ ಸರ್? ಏಪ್ರಿಲ್ ಅಲ್ಲಿ ಕೊಡ್ಲಾ ಸರ್?
ಮೇಡಮ್ ಇಲ್ಲ ಏಪ್ರಿಲ್ ಇಲ್ಲ, ಕಂಟಿನ್ಯೂಸ್ ಬರ್ತಾ ಇದೆ. 2020 ಮ್ಯಾಟರ್ ಮೇಡಮ್. ಹಲೋ
20th ಮಾರ್ಚ್
ಮೇಡಮ್ ತುಂಬಾ ದೂರ ಆಗುತ್ತೆ. 20th ಮಾರ್ಚ್ ಬೇಡ ಮೇಡಮ್.
ಸರ್ ಹೇಳಿ, ಮತ್ತೆ ಹೇಳಿ ನೀವೇ.
ಫಸ್ಟ್ ವೀಕ್. ಹೌದು ಮೇಡಮ್, ಫಸ್ಟ್ ವೀಕ್ ಅಲ್ಲಿ ಕೊಡಿ ಮೇಡಮ್. 28 29 ಈ ಮಂತ್ ಆಗಲ್ವಾ?
ಈ ಮಂತ್ ಕೇಳಲೇಬೇಡಿ ಸರ್.
ಆಯ್ತು, ಫಸ್ಟ್ ವೀಕ್ ಫೆಬ್ರವರಿ ಮೇಡಮ್.
ಫೆಬ್ರವರಿನೂ ಇಲ್ಲ, ಸೆಕೆಂಡ್ ಹಿಯರಿಂಗ್ ನಲ್ಲಿ ಇದೆ ಸರ್ ಇದು.
ಹೌದು ಸ್ವಾಮಿ, ಇದು 6 ಸತಿ ಕಂಟಿನ್ಯೂಸ್ ಆಗಿ ಬರ್ತಾ ಇದೆ. ಬಿಫೋರ್ ಆಲ್ರೆಡಿ ಕಂಟಿನ್ಯೂಸ್ ಆಗಿ ಬಂದಿದೆ. 2020 ಮ್ಯಾಟರ್
14 ಹೇಳಿದೆ ಬೇಡವಾ?
ಫಸ್ಟ್ ವೀಕ್ ಮಾರ್ಚ್
14 to 66 ಸೀರಿಯಲ್ ನಂಬರ್ ಅಲ್ವಾ?
ಸೀರಿಯಲ್ ನಂಬರ್ 66 14
ತಗೊಳ್ಳಿ ನನ್ನದೇ.
ಆಯ್ತು
67 ಯಾರಿಲ್ವಾ 67 ಗೆ? ಏಪ್ರಿಲ್ ಅಲ್ಲಿ ಹಾಕಿದೆ ಸರ್. 68
ಅಲ್ಲಿ ಮೇಡಮ್, ಇದರಲ್ಲಿ ಫಸ್ಟ್ ವೀಕ್ ಮಾರ್ಚ್
68 ಫಸ್ಟ್ ವೀಕ್ ಆಫ್ ಮಾರ್ಚ್ ಸರ್.
23 ಇಲ್ಲ 24 ಆಗ್ಬೋದು.
69 67
ಕೋರ್ಟ್ ಮಾಸ್ಟರ್ 69 ಗೆ ಪೆಟಿಷನರ್ ಫೆಬ್ರವರಿ ಮಾರ್ಚ್ ಎನಿ ಡೇಟ್
ಸರ್. 10/3
10/3 ಓಕೆ ಮೇಡಮ್. 15/3 ಮಾಡ್ತೀರಾ? 15/3 ಮಾಡ್ತೀರಾ
ಸರ್? 15/3 ಐ ಥಿಂಕ್ ನಾಟ್ ಎ ವರ್ಕಿಂಗ್ ಡೇ.
15th ಪ್ಲಸ್ ಮೈನಸ್ 2 days ಅಲ್ಲಿ ಮಾಡ್ಬಿಡಿ ಮೇಡಮ್.
18th
ನೆಕ್ಸ್ಟ್ ವೀಕ್ 18th
70 ಬರಲಿಲ್ಲ. 28/4 71
Any date, I am for the appellant.
ಮೇಡಮ್ 44
24/4 sir.
Okay.
72 2022 matter ಇಲ್ಲಿ appeal. 14/2 next 73 14% ಯಾರೋ ಕೇಳಿದ್ರಲ್ಲ, ಹೇಳಿ ಸರ್.
ಇದು 73.1 ಮತ್ತೆ 73.2 ಅಲ್ಲಿ ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್ ಇದೆ.
29th April is last working day sir. Okay, is it okay? Last working day, then vacation commences. 1 month is vacation. No, just I am informing. So 29th is last working day, then it will be vacation. 29th of April at your request.
ಮೇಡಮ್ 1 ಸೆಕೆಂಡ್, ಇದರಲ್ಲಿ 73.1 ಮತ್ತೆ 73.2 ಅಲ್ಲಿ ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್ ಇದೆ.
73.1
ಮತ್ತೆ 73.2 ಅಲ್ಲಿ ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್ ಇದೆ.
ಆಯ್ತು.
ಡೇಟ್ ಏನ್ ಮೇಡಮ್ ಇದರಲ್ಲಿ?
ಸರ್ 29/4 ಕೇಳಿದ್ದಾರೆ ಪಾರ್ಟಿ ಇನ್ ಪರ್ಸನ್.
ಓಕೆ ಮೇಡಮ್.
ಸಮ್ ಸರ್ಜರಿ ಇದೆ ಅಂತ.
ಓಕೆ ಮೇಡಮ್.
74
ಮೇಡಮ್ ಇದು ಮೆಮೊ ಮಾಡಿದ್ದು. ಯಾವ್ದೋ ಶಾರ್ಟ್ ಡೇಟ್.
ಇದು ಹಿಯರಿಂಗ್ ಅಲ್ವಾ ಸರ್?
ಹೌದು, ಹಿಯರಿಂಗ್ ಶಾರ್ಟ್ ಡೇಟ್ ಬೇಕಿತ್ತು.
21/2
ಈ
ತಿಂಗಳು ಕೇಳಲೇಬೇಡಿ ಸರ್. 75
ಫೆಬ್ರವರಿ ಫಸ್ಟ್ ವೀಕ್.
ಫೆಬ್ರವರಿನೇ ಕೊಟ್ಟಿದ್ದು ನಿಮಗೆ 21/2. 75 ಸರ್. ಸರ್ ಹೇಳಿ. ಏಪ್ರಿಲ್ ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್ ಆಗುತ್ತೆ, ಏಪ್ರಿಲ್ ಹೋಗುತ್ತೆ. 23/4 76 28/4 ಅಷ್ಟೇನಾ?
44 ಮೇಡಮ್.
22 ನಾ? 22 ಪಾಸ್ ಓವರ್ ಸಮ್ ಪಾರ್ಟ್ ಡಿಕ್ಟೇಷನ್ ಮೇಡಮ್, ಡೇ ಆಫ್ಟರ್ ಟುಮಾರೋ ಹಾಕಿರ್ತೀನಿ.
21 ಪಾಸ್ ಓವರ್ ಆಗಿದೆ.
ಡೇ ಆಫ್ಟರ್ ಟುಮಾರೋ ಅದು ಅರ್ಧ ಡಿಕ್ಟೇಷನ್ ಆಗಿದೆ ಮೇಡಮ್. ಅರ್ಥ ಆಗ್ಲಿಲ್ಲ ಅನ್ಸುತ್ತೆ ಅವರಿಗೆ.
Madam, serial number 32.
44.
Madam, serial number 32. Madam, serial number 32.
ನಮ್ಮ ಕೊಟ್ರ ಡೇಟ್ 21 28 ಹೌದು.
Madam, serial number 32, madam.
32 10/3 madam.
10/3. And madam, what did you say about February?
Madam,
you were saying something about February.
No, some other matters madam.
Okay, fine. This which you said, which March you said, na?
Yes madam, 10th of March madam.
Fine, thank you madam. Thank you.